Welcome. I'm Ada Kay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of java and let's dive in. Good morning. Oh, that was a bit abrupt. My apologies. Good morning, everybody. I hope this finds you all lovely and well. I hope everything is gone good with you, that you all got a good night's sleep, and that you guys are ready for another day of court. Today we are, I'm looking for something. Going to be in the Christopher Wolfenbarger trial. But before we get in there, I do have some sad news. Yesterday, Frank Caprio, he was born in 1936, passed away yesterday, 2025. He was an 88-year-old, very well-known judge. He was known for his compassionate heart, his love and understanding, and his huge amount of generosity when it came to dealing with people and their court issues, especially with the traffic court that we used to watch on TV. So, yeah, he passed away. So let's just have a moment of silence. Yep, he was a great guy. We'll miss him. I watched his show sometimes. It was interesting. Beloved Rhode Island judge. It would help if I did this. The beloved Rhode Island judge, Frank Caprio, has died after a battle with pancreatic cancer. His family confirmed his passing a day after he shared a video from his hospital bed asking for prayers. Known for his compassion and his compassionate courtroom style, Caprio was admired by many and gained global recognition. Oh, rest in peace. Thank God you are out of pain, no longer in pain. But that is kind of sad, and I'm sorry to have to start off with that. But I got something funny for y'all to watch while we're waiting for the trials to begin. Y'all, this is absolutely hysterical. Let me see if I can get it bigger. When I turn 80, okay? When I turn 80, this is what I'm going to do. I kid you not. When I turn 80, this is what I'm going to do. Y'all ready for this? I'm gonna do it. Here we go. This is what I'm gonna do when I'm in my 80s. I'm gonna learn how to pole dance. I'm kidding. Good morning, Miss Erin. First in chat. Second in chat is Mr. Jesse. Thank you for the likes and the shares. Yeah, I don't think I'll be doing that. Little bit much for me. Little too much for me. Not something that I look forward to doing. Miss Great. Court sucks. Court volume sucks. I just heard the court for Miss Donna Adelson. I just heard the court talk about them getting everybody into the courtroom. There is a chance, a small chance, Miss Donna Adelson will have opening statements today, but like I said, very small chance. I would be shocked if we had opening statements. Good morning, Miss Case One. How's my mod doing? It's a mod day. It's a mod day. Yep, no, we don't have it yet. Turn it down. I'm just trying to get everything situated. Okay, so what I'm going to do today is while we're waiting, we're going to do a review of the 5 days, a quick one, nothing too deep. Nothing too deep. I've got all these windows open unexpectedly. I don't know why. There we go. Slow going this morning. Yeah, it is. And I didn't go to sleep until 5:00 this morning. Oh, we have got weather, they say, coming our way. Let me look and see what it shows. Oh, we do. Did it miss us? Oh my gosh, the weather is just going to miss us. Look at that. Oh, we're going to get clipped by weather, but not a whole lot. That little blue dot is where I am. And if you see that square, that's the river that flooded back in July 4th. And it's just showing that there's a flood warning. And it looks like I may not get really. Wow, look at that. That's going to go real close to us, but luckily it's not going to hit us today. I'm not in the mood for rain. So let's do a recap of the first 5 days of the Christopher Wolfenbarger trial in Fulton County, Georgia, where he stands accused of redrum and dismembering his wife and victim, Melissa Wolfenbarger, in 1998. This is a cold case that turned real hot real quick lately. The case is steeped in generational trauma. Melissa was the daughter of a convicted serial killer, Carl Patton, and her mother, Norma Patton, has attempted to help dispose of bodies for Carl's killing spree back in the 70s, I think 73 to 77. So on day one, of course, we had opening statements and crime scene witnesses. We had the prosecution allege that Christopher abused Melissa and disposed of her body near his workplace. Hello, Angela. Defense claimed Melissa fled her abusive family and pointed to alternative suspects. They had witnesses, 3 witnesses that day. George McEarthen found Melissa's skull in 1999 behind a glass shop. Detective Dale Kelly admitted a critical VHS tip showing the dog dragging the skull and the bag is missing. Ugh, just the thought. I don't want a visual of that. Good morning, Angela. Detective Tina Miller found additional remains in June of 99 behind an auto body shop. Day 2, the defense cross-examines Ronald Brock, former employee. Okay, so the court reporter and attorneys are going to the jury room. That's in the background in my ears with Donna Adelson. We are in the background with her until we know otherwise. Okay, got it back up. So Ronald Brock, former employee, claimed Christopher Bald Assault admitted falsifying the records. Cynthia Brock contradicted herself about the saw being returned. Dorothy Coley, the neighbor, claimed the witness abuse crossed revealed over 11 arrests and memory gaps. The defense dismantled the credibility of all three witnesses. Norma Patton on day 3 described years of abuse by Christopher, including dragging Melissa across pavement, admitting helping Carl Patton dispose of the bodies in 1973 to 77-ish, claimed she tried to keep Melissa away from Christopher, and the later searched for her after she vanished. So good. First sip. The defense's strategy for that day suggesting that Norma had motive to defend and deflect the blame and protect her husband Carl's legacy. I wonder what that was. Day 4 was more about forensic and behavioral experts. The forensic analysis confirmed the saw marks on the bones could not link tools to Christopher. The cold case detectives admitted delays and missing files in the chain of custody. Christopher's daughter recalled the claim that he made incriminating statements cross-exposed the confusion. Defendant's psychiatrist suggested Melissa may have been fleeing multiple abusers, not just Christopher. Good morning, Miss June. One sunny day. I have a question for you. I thought I screenshotted what you had picked out for your prize at the end of the month. Remember the giveaways that we did? I could have sworn I took a screenshot of that. And I guess I didn't because I don't have it and I'm ready to send it. Would you do me a favor, love? Can you put in the comments whether you wanted the mug or the t-shirt? If you wanted the t-shirt, I have yours. If you wanted the mug, I need you to resend me your name and phone number and address again. Sorry. To the akbjuror.com. Let me get it up there so you will have it. Where is it? There it is. So if that was you, if you wanted the mug, send me the photo of the mug and the color you want, and you send me your address and all that again. Boo. Just so you know, the payment on the 21st of every month is when us YouTubers get paid. It's payday. So yeah, really want to get that to you, boo. I really, really do, because you're freaking awesome. And I want you to have it. Okay, let's continue. Day 5 was the investigators and medical examiner. And that was kind of an interesting little trip we took down. That path was kind of like, huh? Detective Jordan Shepard reviewed the original case files and flagged Christopher's lack of concern and proximity to the remains. Thomas Scott Jr., retired detective, helped identify Melissa's skull in 2003, noted red flags in Christopher's statements. Now, Dr. Mary Beth Abusive described decomposition and connection of the remains found in the trash bag. So far, we have a few things that are kind of popping out there. Thank you, beloved. Thank you. The VHS and incomplete report weakened prosecutor's case. The witness credibility and the defense exposing contradictions, criminal histories, and memory lapses. Alternative suspects are Carl and Norma Patton, repeatedly raised throughout this whole process of possible perpetrators other than Christopher. And the jury exposed to general trauma and domestic violence information, and no murder weapon, no cause of death, no DNA leaking to Christopher. The state has an uphill battle right now. They are not looking so well, in my humble opinion. One, you were the t-shirt. Okay, I have yours. I got yours. It's the other one. Okay, so that was the other person. So we're good. I got yours. Yay! That's always a good thing to have. I was going through my emails and I know I saw it, but it's not there. I looked in the trash folder. It's not there. So we'll see. We'll see. But yours is. It's the other person's. So I will take care of that. I'm popping out my links because I don't have them. Today is going to be a long day, but it's going to be a fabulous day. June, I hope you got some sleep. I did not. Good afternoon, Miss Letty Jane. Thank you for sharing, June. Oh, and for the Donna Adelson trial, we will be doing the bingo again. So bingo will be good for the Donna Adelson trial. So y'all get ready for that. Everybody thank Miss June. She is the one who does our bingos for us. She takes a lot of time to make those up. So thank you so much for my fabulous mod. I have, you know what? I want to say this, and I don't do it enough. We have some mods that you guys don't see. They're kind of in the background. And I want to give a big shout out to my background mods. You know who you are. And I just want to thank you for everything you do. Thank you, thank you, thank you. I want to get one of those t-shirts too with the, well, maybe I'll pull it up. With the, let me pull it up. Go to my shop and I'll pull it up. Okay, let me pull it up. Here we go. Let's switch over here. Y'all, this is my merch shop. And we have different versions of Legal Eagles. We have an S on it. In my humble opinion, tumblers. We got Legal Eagle hats. We got, in my humble opinion, t-shirts, sweatshirts. We got Legal Eagles over the pocket. We have, in my humble opinion, over the pocket. Let's see. So you can see. See, in my humble opinion. Oh, it didn't share. That's okay. So you guys, when you win, the end of the month drawing for the court and the end of the month drawing for the end of court bingo, you get to go over here and you get to pick out an item, whichever one you want. And so these are the Legal Eagles and in my humble opinion. And where is the hat? There's, in my humble opinion, my mug. We got the legal beaches. Look, we got the legal beaches. We have that. That somebody wanted that and I did it for them. So anyway, these are our merch. I've got more coming. I got kind of clean it out a little bit, figure out what we're going to keep. I want to have some Christmas shirts coming in, some end of the year shirts. That is something that I'm looking forward to and I'm working on. So if you are artistic in any way and you actually like to design and create things, let me know. Maybe you can help me create and design a fall shirt for our group, and then maybe you can help me create and design a Christmas shirt for our hat or whatever for our group. Would love to have you. We also are over here, and this is the finalizing jury selection. It says openings are expected today. I'm not too sure if I would be that optimistic, but you never know. We may get opening statements today. That would be awesome. And we are in the Wolfenbarger. We are expecting the prosecution to rest and going into the defense's case in chief. By what they kind of indicated yesterday, we will probably only be having the defendant and maybe one other person. Not too sure, but we'll see. Miss June, did you get your cup of coffee yet, beloved? Did you get your coffee yet? I did. I'm not drinking it fast enough, but I did get it. Also, I wanted to say that we had somebody, I did something silly yesterday. And okay, I got that up. We'll leave that up there so I can see. I did something silly yesterday. I have my my sister got me hooked on Animal Crossing, and I normally don't play it since she's passed, so I kind of started picking it up and playing it again. And I've been looking for the Islander Marina. She's the pink octopus. And she's one of the most popular characters in this game. And I had her forever, and then somehow she disappeared from my island, and I had to wait to kick another member of my island off that I didn't want to keep. And then you have to go and search and search and search and search and invite them. Well, I've been trying to get her on my island, gosh, a year. Yesterday we got her on my island. So I have all 4 octopi on my island, and that's just one of the quirks that Tracy and I did. And so she loved the fall. She loved Christmas decorating on the island. So when things get a little bit boring or monotonous, you might see me pop up, and you can watch me. You can watch me play a little bit. I do know that I've ordered a new game, and I'll tell you what it is later when it gets here. I do not play a lot of games. I'm not a gaming person, but I do like that style of game, I guess. And so I ordered another game, and we'll see how it goes. So, someone commented how much they liked and enjoyed and thought it was kind of cool that they could see the court on one window, and where I am right here, I had the game up. So it was kind of fun. We are waiting for both courts to pop into their start their days. Wonder why we're running so late with Wolfenbarger. Not too sure why, but let me get. I'm searching, y'all. So give me a second, please. Yes, I am tired. Oh my gosh, this is funny.
Loves and has children with, I believe.
Donna Adelson on the Wheel of Fortune. What is it with these people on game shows? Why do all these people who end up committing red room end up on a game show? I don't understand that. I mean, you got Boone, now you got Donna Adelson, and now you got Lori Daybell, all of them on game shows. This is weird.
And because he did not marry an appropriate woman, he is excommunicated from the family. Meanwhile, He doesn't matter. Smartly
I want to see her play the game.
mischief maker.
Oh, oh my God! Law is that Law and Lumbers? No, not Law. Is it Law and Lumber? No. Who calls their wife mischief maker and little ones? He married her, and her name is Mischief Maker. Yeah, Lawn Lumber, I believe. His wife, that's what he calls his wife. That's her handle.
Yes, there's 1H. Time starts now. First. Donna.
F.
Yes.
Mischief Maker.
Yeah, that's it.
Mischief maker.
Well, she was a little mischief maker, wasn't she?
Well,
Oh
how
my
did she
God,
know
y'all,
That's like,
that right there is so freaking weird. She is a mischief maker. Oh my gosh, y'all, that is so creepy.
so. Yeah, right.
I like it.
That
Donna
what we call
Adelson.
this, Aquanet Don. Let's listen to more of Donna
That's
Adelson
one?
on wheel.
How does she get on there more than one?
Go after this
Dollar store. When
But from that,
on the What's My Line show.
I was looking more like
What's my line?
You know, have straight hair, so I was kind of looking.
Right,
Like I
Rob.
was thinking, like
Rob, Lawn
you know,
Lumber.
make me meatloaf or Farrah Fawcett, like like straight, but a couple of little like thingies going on.
That hair is
That's an
scary,
interesting
y'all.
look, they're meat
every day. Thank
focus
Joseph Ryan.
happening place.
Yeah, doesn't quite
going
strike
into-
me.
Everybody wants their own arrow there. 500.
N.
It's my motto in life. There's one N.
Lori Daybell.
Well, the turn's gone. The cash will stay. Maybe we'll get back to you. Florida, your turn.
I guess you have to clap every time.
Yeah. Sorry, the best body language didn't work. Lori? 600. There are two S's. Yeah.
Woo!
Yeah, 900.
C.
3 C's. Good for you. You have almost $4,000 for it.
I'd like to buy a vowel.
Mhm.
An I.
There are some I's for you.
3.
Anybody want to solve?
Yes, I would like to solve.
Wait, I gotta go back.
We are about to embark to the planet Remulac.
For it.
right.
No.
I'd like to buy a vowel.
Oh, that is so
An
funny.
I.
There are some I's.
God, this
There's
is
an
memories.
I.
I much fear damage to the fuselage, Frederick.
I would be terrible at this game. Lose the turn. Lose the turn.
800.
C.
There are two of those.
She knows it, right? She's gotta know it. Stop.
300.
N.
Yeah, 3 N's.
She knows it. I still don't know it. What is it?
I've got the last.
Y'all know it? Put
I've
it in
got-
chat if you know it. I don't know it yet.
Caution, I
I'm
think.
sorry. What's the category?
I don't know.
Yeah, I was trying to figure that out too.
Rock, ice, and
You know, our viewers are screaming at their devices right now.
oh, they probably can solve it, right?
So
Yeah.
can y'all solve it?
If we go there. All right.
Can y'all solve this? Yeah. Can y'all solve it? Let's see. I can't solve it. My
You gonna
mother
solve it?
my mother was brilliant at this. I suck.
Isaac and
Something Doc,
Doc,
Isaac, and
da 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 da.
And Hamilton Joe Kidd.
Wait, I gotta go back. I can't. I have no idea what this is. How do we not know what this
Doc,
is?
Isaac, and
Sure.
An A.
There are 5
She's basically
A's.
has everything filled up.
Captain something or another.
What is Captain with an O?
what is
Oh.
that?
Oh,
And
Captain Stubing.
Ooh,
Yes.
Oh, yeah,
Yes,
yeah.
yes,
Oh,
yes.
Doc, Isaac,
It's,
and Captain Stubing. What's the first one?
It's whatchamacallit. So Isaac was the
Gopher, Doc, Isaac, and Captain Stubing.
Yes.
Wow,
Category
what's
is.
your-
There are 2 P's. You want to risk it? You can. There's either bankrupt or that $10,000 Kenneth Cole gift certificate. You'd be risking $6,000.
I have to. Now I'm here.
You have to?
I had no money anyway.
Well, okay, then lift the darn thing up. Oh my.
Wow, are you
Let's see.
surprised that she's
Let's
spinning?
see. Did she get the bankrupt?
That's always a bad. That's always a bad move.
Oh my
Yes, what he said.
Bad move.
God. 800.
Gee.
Yes, there are 2 G's.
She's killing it.
I want to go.
Okay.
Gopher, Doc, Isaac, and Captain Stubing.
Yeah.
Pat St. Jack looks like he's like in
7,500.
a hurry to get over there to congratulate her too.
I loved him, and he's back as like the celebrity Wheel of Fortune host on specials.
I got it
But
one
thought
sunny
it was a
day.
great
Thank you. I
game
just
show. And very
responded.
thin
Thank you.
bodies, because it translates well. It looks good on camera.
That's a
Look at the bottom of her blouse.
benefits. Yeah. Well,
Contestants.
who wins if Donna goes against Lori on Wheel of Fortune? Who do you think would win?
Loretta? No T. Lori?
R.
2 R's. Wow. $18,000 on the map.
Anyone want to solve?
No, but do either of you gentlemen remember the ad campaign? What is Vanna wearing tonight?
No.
They would have someone say, "What is Vanna wearing tonight?" Because you had to watch the show just to see Vanna White's fabulous wardrobe.
That's smart. Smart.
Loretta? Lori?
D.
1D.
I have it.
Loretta? Luis, a letter.
I.
2 I's. No money for vowels, but maybe they'll do it for you.
Republic of Ireland.
Yeah. Hi, Lori. How you doing?
I'm good.
You should be. I know you're ready to take that one away. Waiting. Luis, don't get it, but he did.
I'm happy for you.
Good, and we're happy for you. You did very well despite my advice.
She seemed normal, and that to me, the other thing it demonstrates is how different she became, and whatever.
Okay, so speaking of, we are over here. Donald Adelson has popped into court. Let's get going over there while we wait for the other trial to start.
Well, or Deputy Eldridge, whoever is handling it, please double check to make sure the number and the name match so there's no confusion with the record.
I just want to confirm with you, one sunny day. I'm ordering a large is what I have in your email.
They were sworn in when they were qualified. So
It doesn't come in a blue, babe. It comes. Oh, let me go back and look. Let me go back and look. I can put it in a blue. That's for sure. I can make it blue. All right. You want to? Oh. Okay. Now they go to the closed court. Okay. Back over to the Family Feud. This is funny, y'all. I'm
Whatever
enjoying
level
this.
Of
I know, right?
mental illness, brainwashing, whatever happened to her, completely changed who she was. I mean, you watch her on that show and everything is extremely normal. right? To me, Donna seemed more like Donna.
Yeah.
Lori seemed much different than the Lori that was on trial for all those horrific things.
She was perky and likable.
Yeah. I mean, she seemed very, what's the word? I mean, because there were descriptions that were given to us of her, what she was like before whatever happened, right? And it came from Charles's sister as well. And it's sad because if she had remained that same person, the children would still be here and things would be much more normal. But something obviously happened to her that changed her. It's not a defense. It's not an excuse. It's just the reality. Those are two different people. All right. This is an interesting one. I have a short clip to show you. This was actually a pretty recent one. Timothy Bleefnick was on Family Feud. Let's watch. This is a very recent trial.
What's the biggest mistake you made at your wedding?
Honey, I love you, but said I do. Not my.
How you doing?
I'm good.
You should be.
Yeah, one more time.
All right, people, what's the biggest mistake you made at your wedding?
Honey, I love you, but said I do. Not my mistake. Not my mistake. I love my wife.
Oh, yeah.
I'm going to get in trouble for that, aren't I?
Yeah.
He got in more trouble after he red-rummed his wife
Yep.
and got convicted.
Yep.
I'm just all wrapped up in the idea that this guy took over for that show, and the great Richard Dawson hosted it for so many years.
Yeah, but some of those Richard Dawson clips, if you look at them, they're a little creepy.
I don't think so.
Yeah,
Well,
marrying one of those.
No.
Look, I might get in trouble for this, right? But Richard Dawson was a very charming guy, and the clips that I've seen where he walks over and hugs the contestant and stuff, they seem like it, happy to have him do that.
He's kissing everyone on the lips, including little girls, because
Oh,
sometimes
whoa. We're moving on from that.
Well,
We're moving on.
War.
Yes, he
Humor.
and I'm in trouble.
Right.
And he has a big head.
Who is this?
You're a dirty old man. Take it.
Oh, come on over here.
Wow.
Can you believe it? Like, whoa. Woo. Boom. It's insanity. Like, there wasn't a ton of screening of the contestants because I believe.
So that's exactly what. They had the red rummer.
Absolutely.
Dinner.
Oh.
What are you called and what do you look like?
I'm called the banana and I look really good.
It's both a lame answer and like almost.
Bachelor number 3. Who gets the date?
Well, I like bananas, so I'll take one.
Number 1.
Whoa.
He won with the banana line.
But you do know that there are bananas that are this long. I'm not kidding. Have you seen the micro mini bananas? Is he a micro mini banana? Or is he a standard banana? Or is he one of those really extra? I can't believe we're reduced to talking about bananas at this point. Oh my gosh, y'all. That is so we're talking about bananas. Oh my gosh, y'all. That is so my bad. I apologize. We reverted to the banana theme. Or should we just say, why don't we just say pickle? Thank you so much for the fabulous pickle from one of my fabulous peeps. I thank you and appreciate you so very much for the pickle. The pickle likes that pickle day. We had a day talking about pickles. It was so funny. State of confusion. Is this the first time Ada saw this? Yes. This is the first time I am seeing this. And forgive me. What's what I need? But yes, state of confusion. That is the first time I am seeing this. And is it raining? Did we get rain? Did the rain change its path and we are now getting rain? We're getting major rain here, y'all. Can y'all hear it? I feel it. Can y'all hear it? Wow. Oh my gosh, y'all. That's pretty intense rain. Good morning. Oh, really? Really? Why did she refuse to go on a date with him?
To Rodney Alcala. Rodney, come on and say hello. Congratulations, Rod. You did it with a one answer. Well, as far as I can see, Cheryl and Rodney, it looks like the two of you may be involved in some sort of racket. So we're going to have you taped to the court. Oh, first, you'll receive tennis lessons from expert Naomi Besa of the famous Kirkwood Tennis.
Boy.
Out by
Frankie.
Okay.
Oh,
I'm gonna take a look at that.
Oh my gosh, that is so fun. She probably saw his banana or didn't see a banana. Maybe she saw Vienna sausage. We have resorted to the banana theme. Oh, y'all. Oh, I can't believe we're talking about bananas. And so I Vienna sausages and bananas and such. I can't believe we're doing that. I can't believe we're doing that. I am actually right now ordering our winners shirt. And I'm doing it as like a light navy blue. So, Sarah, that is going to be coming your way. Here's a 5-1. There we go. Yes. That rain, I can feel it. It's pretty heavy right now.
Okay. Madam Court Reporter, are you ready? Yes. State ready?
Yes, Your Honor.
Mr. McDermott, is the defense ready?
We're ready.
Okay.
Defense is ready.
Okay.
Ready,
This is
Freddie.
going to be
Freddie.
Thursday, August the 21st, in the trial of the state of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that the state's counsel is also present here in the room. I have a couple of questions just in terms of logistics. At the end of the day yesterday, I had asked if the state was going to rest. Is that the expectation, or do we expect that we're going to have some more witnesses from the state?
The state is going to rest, Judge.
Okay. Will there be motions that I need to take up from the defense, or here's why I ask. Logistically, I'd really like to go directly into the state rests. Defense, call your first witness if I can.
We are on a very slippery slope between the pickle and the banana.
Doing it just very quickly, and then at the lunch break, expand on it, as long as there's no waiver or contention that we didn't properly raise it. I mean, we do that in federal court all the time, say,
sure,
we are hereby, moving for a directed verdict on every count, on every element. And we just agree that we'll expand on it, when the jury's not having to wait.
Seems fair. Mr. Fussett, you agree?
Yes,
Okay. So, so if I bring the jury out right now, and you've already reserved your right to move for directed verdict, am I, if I say state, call your first witness and your next witness, and you say the state rests, Mr. McDermott, are you ready to call your first
I need
witness?
to go check and see if they're here.
Okay.
Okay, let's see if I can remember how to do this. No. There, I did it. Yay. I'm learning how to do the emojis in Discord. Yay. I did it. I am learning Discord. I mean, I know Discord, but I mean, like, I'm really trying to learn Discord. And so, yay. Good morning, my beloved son.
Witnesses are here.
Okay.
But 2 of them are in restrooms. So we'll just need a few more minutes. Honor, I sent in my bench warrant to.
It's been approved and signed. I don't know if it's been filed yet or if it's been sent back to you, but I am aware of it and I have signed it.
Okay. Is that?
What more do we need to do in order to get the sheriff?
That is a question for Ms. German. So let me find out where she is in status and who she's notified. Ms. German, when you get a moment, if you could, 1, let me into the Zoom, and 2, come here for just a moment, please. Thank you.
I'm muted. I know. One sunny day, your order's on the way. Oh, that rhymed. Yeah, that's pretty cool. I like that. For those of you who did not know, I think I took it down. Let me do this and share. While we wait for that, let me share for a lot of you who are just hopping on. The wonderful, wonderful judge. Why'd you go away? Share screen. This wonderful, wonderful man and judge. Oh my gosh, what was his name? Frank Caprio. Judge Caprio passed away this morning. His cause of death was pancreatic cancer. And it is a sad, sad day for the legal community. They cut it off. Beloved Rhode Island Judge Frank Caprio has died after a battle of pancreatic cancer. His family confirmed his passing one day after he shared a video from the hospital bed asking for prayers. He is known for his compassionate courtroom style, and Caprio was admired by many and gained global recognition with his show. So, rest in peace, Judge. You were 1 in a million. And he was 1 in a million. I loved his courtroom shenanigans. Sometimes he was cool. All right, here we go.
That you can then present to the sheriff. She's also going to call upstairs to the sheriff and let them know that request has been made.
So I'm required to take it to the sheriff?
I believe that the defense is required to make that request, but we are also notifying the sheriff of the request.
Thank you. I guess all I'm saying is I might just show it to her.
That's fine.
Instead of flipping through the whole.
Yeah, that's it.
So the witness, their first witness, did not show up to court yesterday, although they wouldn't have testified, but they were required to be there. And so yesterday, before we left at the end of the day, the defense's legal team requested the judge send a sheriff and to go and pick up the witness and bring them to court. So it's forceful. It means they have no choice. Contempt.
May I have one moment, Your Honor?
Yes.
Thank you guys for sharing and liking. We have 8 likes and 4 shares. So if you've not shared, please share the video and comment in there, I shared, so you can be in the end of the month giveaway. I really would love to give you a blessing. I'm over in my Discord, y'all. You guys, we have some places in our Discord that's for recipes, memes, and fun things like pet pictures,
Thank you all. Please be
hobbies.
seated. Good morning.
Go leave some
Thank you
pictures.
for your patience this morning. We are ready to go ahead and get started. Mr. Fossett, the state may call its next witness.
Yes, Your Honor. Your Honor, at this time, the state will rest this case.
Okay, thank you. Mr. McDermott, defense may call its first witness.
We did the motion already.
Yes, sir.
Okay. At this time, the defense calls Kimberly Cameron.
Okay.
Okay, so Miss Kimberly is the one that did not want to show up this morning. How was my sound? Hello, it Brit. Good morning, babe. Hello, it Brit.
Come on up to the witness stand, please, ma'am. And when you get there, before you have a seat, if you'll turn around and face the deputy and raise your right hand, he'll swear you in, okay?
Raise your right hand, please. You swear or affirm to the testimony that you're about to give the whole truth and nothing but the truth, so help you God. Yes.
And ma'am, if you'll do me a favor and scoot up to the microphone, get situated however you feel comfortable, but make sure you're close enough to the microphone that you can speak into it, because I can already tell you're a little bit soft-spoken. And state and spell your name for the record, okay?
Kimberly Cameron, KIMBERLY CAMBRON.
Okay, and also we will remind you to try to talk more slowly because the court reporter needs to take down everything you say. And I will add a caution the judge has given other witnesses that there's a ledge right by your chair, so be careful not to roll off to the side too much.
That is true.
All right. Now, Ms. Cameron, do you know the defendant?
I do.
How do you know him?
It's my brother.
And did you know Melissa Wolfenbarger?
Yes.
And how did you know her?
She was married to my brother.
Okay. And did you know her while she was alive?
I did.
Did you spend time around her?
Yes.
Okay. And how and where did you spend time around her?
When they were married, they lived with my grandmother. So I would go there and spend time with her.
And would you do that frequently?
Yes.
So you, suffice it to say, you spent quite a bit of time around Melissa.
Yes.
Okay. Do you remember any episodes growing up with her that stick out in your mind?
Yes, I remember when I was learning to drive, I was so nervous that every time I would drive, I would go over to the side of the road.
You would pull over?
Well, when a car was coming toward me, I was afraid that I was going to hit that car. And so I would pull over and she would calm me down.
Okay. Do you remember when Melissa was pregnant?
Yes.
With Chrissy?
Yes.
And then about a year later with Joey?
Yes.
And do you remember her having discussions about the custody of those children?
I do.
And do you remember what she ultimately chose as far as a decision in that regard?
She decided to give custody to my mom.
And why did she discuss her other parents?
She did, and she said that she did not want her mother or the state to have her children.
Did she at any time give you a reason why she didn't want her children with her parents?
She did. She just, she did not elaborate. She just said that they were not good people.
Okay. You said you visited Melissa multiple times because she lived at your grandparents' house, correct?
Correct.
And you went over there multiple times. Were you generally over there during the holidays?
Yes.
Was it pretty much every holiday?
Yes.
Do you remember, you spent most of the holidays with Melissa then, correct?
Correct.
Do you remember if Melissa at any time called her mother on a holiday?
Not to my knowledge.
Do you remember her calling her mother at any time?
Not to my knowledge, no.
Do you remember her writing letters or cards to her parents?
No, not to my knowledge.
Okay. Just a minute, Your Honor.
Sure.
No further questions, Your Honor.
Thank you. Questions for this witness? Yes.
I'm on it. I'm on it. Oh my God, I'm on it, guys. Hold on. I can't. I'm on it. Oh my God, y'all. That's horrible.
Good morning, good, and you?
I'm doing well. Thank you for asking. You just testified that Melissa told you she did not want her parents to have her children. Is that fair?
Yes.
Okay. What year was this? Do you remember having these conversations with Melissa?
I don't remember it exactly, but it was between 96-ish.
Okay, 96-ish. All right. Permission to approach, Your Honor?
Sure.
Nothing I can do to fix that.
With husband and witness exhibit number 71. And I want you to read this entire letter out loud of Stacy exhibit number 71.
Oh my God, this is hell.
It's been a while since that.
Hang on. Sorry, yeah. If you would just try and read it a little bit slowly, especially when we're reading things, we have a tendency to speed up. And again, the court reporter has to take it down, okay? Thank you.
Dear Mom, hello. It's been.
Oh my God, y'all. I cannot get rid of the hum. I've done everything I can. It is, I don't know what happened in court, but that
a while
sucked.
Since that weekend that I last talked to you, I thought that I would write you a letter. I'm okay. Here are some pictures of Chrissy, 7.5 months. Can you, I'm not sure what that one says. Please.
Does it say you can pass them out?
Yes, sorry. You can pass them out if you wish, but it won't for
Does it say,
the fact.
But if it wasn't for the fact that Kathy was there when I got them, she would not have gotten any.
She would not have gotten any of them. She wanted me to give Chris's grandmother the biggest one, but I didn't. And she got mad
best
at me,
I can do.
but oh well. They are both getting on my nerves. They act as if Chrissy is their daughter and not mine. And there is something that I need to tell you, and I really don't know how. So I will tell you like this. And you want me to continue?
Yes, please.
You will sooner than you think have another grandchild. July 27th is the due date. Do not be mad because you are not the only one just finding out. Please. Not sure.
Does it say, please don't rub it in, mentioning something like, you know, how hard it is to take care of two kids so close in age, like Kimberly and JC?
A few days.
Is that
They're blocking out the names of the kids. Guys, I can't fix this. This I can't fix. That is coming in from their feed. Hold on, I'm looking for another feed. This is bad, y'all. This is just nasty. The sound is horrid.
from what you read?
I'm sorry, could you repeat the question?
Sure. Does it
Get along pretty good. Every time she hears her mom say something about me, she sticks up for me and tells me about it. I remember telling that Kathy said that she wishes me and Chris would move away. Kimberly says to her that if she moves, that Chrissy would move with us. Kathy said no, she won't either. And Kimberly's, she is their daughter. Then Kathy said no, she isn't. If someone said that about you would be mad. So did I? I told Chris, and Chris got mad. When Kathy asked to take Chrissy off, Chris said no, she better be here when I get back. And Kathy got mad, and I laughed. You probably think this is stupid, but if you had someone trying to be mother to your daughter, you would get mad too. And when we do move, they are not going to know where we are living. Every time they go off, they have to take Chrissy and don't even ask. They get her all ready and leave. I'm supposed to have my own car soon. Then I will bring Chrissy and let you see her. Bye for now, Melissa.
And this is a letter that Chrissy wrote to her mother. Is that fair to say from what you read?
I'm sorry, could you repeat the question?
Sure. Does it appear from what you read that's a letter that Chrissy wrote to her mother?
This is a letter that Chrissy wrote to her mother?
A letter that Melissa wrote to her mother.
In my opinion, it doesn't sound like Melissa, but it does state her name on there.
And it's signed by her?
Yes. It says bye for now, Melissa.
And so in that letter, Melissa actually wanted her mother to at least spend time with her children. Is that fair to say?
In that letter.
And is it fair to say that she actually would have preferred her mother to have her children rather than Kathy, who's your mother? Is that fair to say?
Again, in that letter.
Now, you also, I think, discussed on direct examination that you were not aware of any cards that Melissa sent to her mother.
You have to answer out loud. Thank you.
Permission to approach?
Go ahead.
I'm going to show you what's already been admitted. That Stacy's in the 67, 68, 69, and 70. You take a moment and look at those. And I'm going to
I have to make a phone call to my bank. I will be here, but I'll be right back.
So I want to first look at Stacy Exhibit 67. Is this a letter addressed to Norma Patton?
Yes.
And is your understanding Norma Patton is Melissa's mother?
Yes.
And does it say birthday?
Yes.
And does that say happy birthday?
Yes.
In 97 with an asterisk?
Yes.
And does it say love you, Chrissy and Joey?
Yes.
And is Chrissy and Joey Melissa and Chrissy's children?
Yes.
Looking at Stacy Exhibit 68, is that addressed to Carl and Norma Patton?
Yes.
Right. And does it say anniversary?
Yes.
And does it say Melissa Wolfenbarger at the top?
Yes.
And is Melissa their daughter?
Yes.
And does this letter or card say on the side, special anniversary, which is to a very special couple? Have a happy anniversary. Love Melissa, Chrissy, and Joey.
Yes.
And does it read in handwriting, happy anniversary. This year, I am going to take you out to lunch. My only day off is June 6th. Meet us there at 11:45 to 12 at Ryan's. You and Dad can bring JC and Kimberly.
Yes.
Okay. Does this appear to be a letter or a card sent by Melissa to her parents for their anniversary?
Yes, it appears to be.
Now showing you State's Exhibit 69. Is this appears to be a Father's Day card?
Yes.
Does it say for a dad who means so much?
Yes.
It means so much to know our family can always depend on you.
Yes.
Have a very happy Father's Day.
Yes.
Love, Melissa.
Yes.
Does the card further read, Dad, with all the things you have to take care of, you always take care of your family first.
Yes.
And on a bag, does it say, a father's love is a promise made deep in the heart of a man, a promise to care for his family that keeps every day of his life.
Yes.
Is this also signed by Melissa?
Yes.
And was it sent to her father, Carl Patton?
Yes.
State's Exhibit number 7. Is this a Mother's Day card?
It says Mother's Day, yes.
Does it say, is it addressed to Norma Patton?
Yes.
Does the card read, it is the only thing in the house that doesn't have to be swept, polished, watered, cooked, picked up after, or washed behind the ears? Relax and have a happy Mother's Day, Melissa.
Yes.
And right appears in handwriting. Next Wednesday, May 14th, I would like to take you and Daddy out for lunch. I'll give you your Mother's Day present then.
Yes.
And these all appear to be cards either from Melissa or Melissa writing cards on behalf of Chrissy and Joey. Is that fair to say?
That's what it appears.
Now, you testified on direct examination that Melissa and Chris lived with your grandmother.
Yes.
If you can approximate, when did they live with your grandmother?
I don't remember the exact time.
At any point, did they move from your grandmother's house to a different location?
Yes.
Where did they move to?
They moved to Atlanta.
Do you know where in Atlanta?
I don't recall exactly. I think Brookline Street.
Okay. Now, Brookline Street, are those homes that were owned by your grandmother?
Yes.
Had you ever visited Melissa and Chris at the Brookline address?
I'm sure I have, yes.
Do you think you spent more time with Melissa and Chris when they were living with your grandmother or when they were living at the Brookline house?
I think it was more with my grandmother. I can't remember.
Now, you talked about your kind of relationship with Melissa. Would you consider yourself friends?
Yes.
Did she speak to you about her life experiences?
I'm sure she did.
Did she talk to you about your brother?
I don't remember.
Did she ever discuss to you some of the difficulties she was having with her brother, with your brother, excuse me?
No, I don't remember.
Did she ever talk to you about her and your brother arguing?
No, I don't remember.
You don't remember, okay. What about them fighting? Did she ever talk to you about that?
No, I don't remember.
Did she ever talk to you about a July 1998 incident in which your brother pulled her hair and dragged her down the street?
No.
No, or you don't remember?
No, I don't remember.
Okay. Do you know if she talked to you about the fact that your brother, was upset because she went to the male neighbor's house who was up the street?
No.
No, or you don't remember?
No, I never had that conversation.
Okay. Do you recall her ever telling you that she loved your brother, but she wanted to leave him?
No.
No, you don't remember? No, it didn't happen.
No, I don't remember.
Do you remember detectives back in around 2003 coming to meet with you regarding Melissa's disappearance?
Yes.
And do you remember it being a Detective Calhoun?
I don't remember who it was.
Do you remember talking to him about your friendship with Melissa?
I don't remember exactly, no.
I'm sorry, say that last part again.
No, I don't remember.
Okay. And I apologize. Do you remember talking on the phone with any detectives back in 2003?
No, I don't remember talking on the phone.
Did you tell that detective that Melissa wrote you a letter?
No, I've never said she's written me a letter.
So is it your testimony today that you never told a detective that Melissa wrote you a letter prior to her disappearance?
It is my testimony that she did not write me a letter.
And that you never told a detective?
I never told a detective that she wrote me a letter.
And that in the letter or either in the conversation, again, Melissa told you she loved your brother, but she was getting ready to leave him.
She's never told me that.
Do you remember Melissa telling you about a guy that she met at the Waffle House?
No.
And do you remember telling any of that to a detective over the phone in 2003?
I never said that. I didn't talk on the phone, no. I never.
Okay. Your mom, Kathy Wolfenbarger, she raised Melissa and Chris's children?
Yes.
Is it fair to say that your mother never talked about Melissa to her children after she disappeared?
Can you rephrase that?
Sure. Is it fair to say that your mom did not speak about Melissa to her children after Melissa disappeared?
I don't know.
You don't know. Is it fair to say that your brother did not speak about Melissa to their children after Melissa disappeared?
I don't remember. But they did take the children to Melissa's funeral, so I'm sure at some point they did talk to her, both of the children, because they were younger.
Would you agree with me that the funeral was in 2003?
I don't remember exactly when it was.
Let's speak about the funeral. At the funeral, did you know that Kathy and Chris didn't tell the children that it was an actual funeral?
I don't know.
Did you know that Chris nor Kathy actually wanted to go to the funeral?
I don't remember what their feelings were.
Let me ask, when the kids were younger, did you ever talk to the children about Melissa, your friend?
I don't remember exactly.
Do you remember ever telling the kids that Melissa was their mother and she disappeared?
I don't remember how and what was discussed.
Do you ever remember showing the kids pictures of Melissa?
I don't remember.
Now, in 1996, is it fair that Christina gave temporary guardianship to your mother?
Yes.
I'm sorry, was that a yes?
Yes.
Thank you. That's okay.
And, Your Honor, this time, the state is going to ask to admit States Exhibit 81 and 82, which are self-authenticating documents from the Henry County Probate Court regarding the guardianship of both Christina Wolfenbarger and Joseph Wolfenbarger.
Mr. McDermott?
No objection.
81 and 82 are admitted.
Thank you, Your Honor. Did you know, or do you know, if on July 23rd, 1998, Melissa dissolved their temporary guardianship?
I don't know.
Well, first show you States Exhibits 81. And on State's Exhibit 81, am I showing you this document?
Yes.
And does this document read on the page that's clipped, in the matter of Christina Wolfenbarger, petition to terminate temporary guardianship of minor?
Yes.
And does it say the petition of Melissa Wolfenbarger shows, one, petitioner is the natural as mother and father of the above named minor? Does it say that?
Yes.
And does it say that on 8/28/96, the court appointed Kathy Wolfenbarger as temporary guardian
Yes.
of the above named petitioner and temporarily relinquished parental rights?
Yes.
And then it says, wherefore petitioner prays that the court enter an order dissolving the temporary guardianship instanter.
Yes.
Okay, and has her signing, it looks like Melissa's signature, or a signature, I should say.
Yes.
Okay. And is the date of this July 23rd, 1998?
Yes.
Did you know that that is 2 days after Melissa called the police on your brother?
No, I didn't know.
And you also see in State's Exhibit 82, the same document, petition to terminate temporary guardianship of a minor, and it's the same document for Joseph.
Yes.
And is that also on the 23rd of July, 1998?
Yes.
And were you aware that about a week later, on July 29th, 1998, Melissa then asked for permanent guardianship, or gave your mother permanent guardianship of the kids about 2 weeks later?
Yeah, I don't know from the documents, yes, but.
And let me ask you this. Did you know that on the day that she gave permanent guardianship was the same day she dropped the temporary protective order that she took out of control?
I don't know.
How would you describe Melissa's demeanor?
I would say she was quiet.
Was she easily influenced by others?
I don't. Yes and no.
Okay. Why do you say yes and no?
I don't remember completely, but yes, I think she, I don't know how to put it into words.
Now, when was the last time you remember seeing Melissa?
I don't remember, I'm sorry.
Can you remember, was it at your family's home?
I don't remember.
Do you remember what she looked like the last time you saw her?
She looked like herself.
And when you say herself, describe for the jury what she looked like.
She just had a cute teddy bear round face with dark hair.
Dark hair, like down to her shoulders, about your length. When you say dark, like what's the length?
Ma'am, I don't remember exactly the length of her hair.
Okay. Was it longer or shorter than your hair right now?
Maybe a little bit longer than mine.
Do you know if you saw her around the holidays?
I want to say, I think maybe Thanksgiving, but I can't remember exactly.
Now, are you familiar with any of the podcasts that have come out regarding this case?
No.
Now, testified you all were close. When you didn't hear from her in a while, did you get concerned?
About the time that they moved to Atlanta, we were not close. I was a teenager. I was doing my own thing, and I had a boyfriend, so I was more focused on me.
And I get it, teenager. At some point in time, did you ever, when she stopped coming around, did you ever question where she could be?
I was told that they split up. I don't remember exactly when.
Did you ever question if she came by to see her children?
I don't remember. I don't remember.
Now, in the year of 2000, did you come to learn that there was a missing persons report regarding Melissa?
I don't remember exactly when I learned.
Do you remember speaking to police in the early 2000s about Melissa's disappearance?
Yes.
Did you ever speak to your brother about maybe talking to the police about Melissa being gone for a long time?
I don't remember what I discussed.
And is it fair that the only people that reported Melissa missing was her mother?
I'm not sure who reported her missing.
And is it fair to say that the only people who have been trying to get some justice for Melissa are her parent, her mother, and her sister?
I'm not sure who.
Court indulgence, for one moment.
Sure. Thank you, Mr. McDermott. Anything else for this witness? Sure.
You remember reading a letter that was purportedly from Melissa to her mother just a few moments ago?
Yes.
And do you remember her mentioning any kind of time frame in that letter?
No.
Okay. Do you remember her saying that she was announcing to her mother in that letter that she was pregnant with Joey,
Yes.
or with who would become Joey, and that she was thinking of getting her tubes tied after that?
Yes.
And you remember her reading in there that it said her next appointment for the doctor would be at the end of April.
Yes.
So that would mean that that letter the time frame for that letter would have had to have been in April of 1996.
Yes.
Do you remember it telling the letter communicating? Well, never mind. I'll back off on that. You grew up, as you said, having a lot of interaction with Melissa because of your grandparents' house, right?
Yes.
And at some point, now, were you older or younger than Melissa?
Younger.
Okay. And how old would you have been in 1998?
I would have been.
Sorry to ask you your age in front of national TV, but sorry.
I think I would have been 15, 16,
Okay.
maybe.
And during that, as you said, that was the time you learned to drive
Yes.
and you started dating
Yes.
and you started developing your own life.
Yes.
And at about that time is when Christopher and Melissa moved up to Atlanta.
Yes.
And at that point, did you stay close to Melissa?
No.
Okay. Did you talk to her much at all after that point?
No.
Okay. So after 1998, early 98, you kind of diverged into separate lives.
Yes.
Okay. So that would explain perhaps why you don't have very many memories of conversations with her or.
Objection leading, Your Honor.
Sustained. You can rephrase.
Okay. So do you think that would explain why you don't have memories of many conversations with her?
Objection leading.
It's argumentative. It's not really leading. Why don't you read?
Oh!
I'll just move on, Your Honor.
Oh, snap, snap.
Sure.
Not only is the judge corrected the objection and then she smacked him for it. Oh my gosh, that was so funny. Funny, y'all. That was funny. Very funny.
So, counsel for the state just showed you this document, didn't she?
Yes.
And it says a petition to terminate temporary guardianship of minor.
Yes.
And she asked you about the dates on that letter.
Yes.
And it says, wherefore petitioner prays that the court enter an order dissolving, doesn't it? And state emphasized the word dissolving when she asked you that question, didn't she?
Yes.
But she didn't emphasize the word praise, did she?
No.
Because this is a petition to the court,
Yes.
correct? It's asking the court to do something, right?
Yes.
And did the court follow through with that something?
Yes.
Have you seen a document that says the court actually ordered
Oh,
the
no, I was
dissolution?
going by that.
Okay,
No, I haven't seen it. No.
correct. And would it surprise you to find that the court never followed through with that order
Would it surprise me? Yes.
to dissolve? Let me just rephrase it so I'm clear. That was a petition to dissolve the temporary guardianship.
Yes.
And would it surprise you to find out that the court did not grant that to Melissa? It did not dissolve Kathy's temporary.
Objection leading.
Overruled.
Would it surprise you to find out that the court did not dissolve Kathy's guardianship based on that document?
Would it surprise me?
Yeah,
No.
exactly. Are you aware of the process for dissolving a temporary guardianship?
No.
It would have surprised you to find out that.
So is this better on my sound, you guys? Are we having that problem because of the court fee that I'm too hot? I apologize. I've lowered my volume as far as I can. Hopefully this is a little better. State of confusion. Please verify that this is better. Thank you.
The court requires it to be in the interest of the children?
That would appear so.
Okay. Backing up to the April 1996 date when the letter to Melissa's mom was purportedly written.
Are you familiar with this document?
I've seen it. Yes.
You've seen it? Can you tell us whose handwriting that is?
It appears to be Melissa's.
Okay.
And
Thank
whose
you.
name is on that document?
My apologies.
signature?
Melissa Wolfenbarger.
And does that appear to be an original document or a copy of the document?
Appears to be original.
I can do it again.
I'll show it to you Are we almost done?
Your Honor, if I could have a moment, we need a defense sticker.
Okay. And you're on Exhibit 11. So.
Thank you. We cleared off our desk for the court yesterday, and there you go. Thank you. At this point, Your Honor, state or the defense moves to admit defense 11.
And what is defense 11?
It is a handwritten document from Melissa, previously authorized to be under 807.
There's not, I mean, we might have had that conversation. It might very well be coming into evidence, but I haven't heard a foundation or an identification of what that document is yet. So,
Could you tell us what that document is?
Are you asking me to read this one?
No.
Don't read it yet. Just
He's not. He's just asking you if you recognize that document, and if you do, what you recognize it to be.
I do recognize the document, and it is a letter to my mother.
And letter to your mother, for what purpose?
Stating her.
Hey, nope, sorry. Don't read it. It's not in evidence. Who's it from?
It's from Melissa.
Okay.
We had already covered that.
Okay, I apologize. I didn't hear that part.
Okay. So may I move it into evidence at this point?
Any objection? No. Defense 11 is admitted.
Now, would you please tell us the content of that letter?
It's Melissa telling my mother that she wants to give her temporary custody of Chrissy and the baby that she's carrying. And it's dated June 20th, 1996.
June 20th, 1996?
Yes.
And that would be roughly 2 months after April of 1996?
Yes.
No further questions, Your Honor.
Thank you. Anything else for this witness, Ms. Hilton?
Just to, do you know if Chris forced her to write that letter?
No, just like I don't know if she wrote that letter. I don't. So, no, I don't believe Chris forced her to write that letter.
But you don't know.
I wasn't with them
No further questions.
24 hours.
Mr. McDermott, I'm sorry. Anything else for this witness?
Nothing further, Your Honor.
Okay, thank you, ma'am. You may step down.
Thank you.
The witness may be excused, Mr. McDermott.
Witness may be excused.
Okay. Mr. McDermott, the defense may call its next witness. Sir,
May we approach?
do you need to approach? Sure.
Sidebar. We do have some Donna Adelson stuff coming up. So when they take a break, we'll hop on over there and catch up with that. Thank you so much, everybody, for being here today. I greatly appreciate you. We have a lot of viewers today on the alternate jurors on X. Thank you so much for being here and sharing your time with me. We greatly appreciate your presence.
Defense may call its next witness.
Defense called Kathy Wolfenbarger.
Kathy Wolfenbarger. Wolfenbarger. Can I skim this a little bit? I sure can.
F-E-N-B-A-R-G-E-R.
Mama? Is that Mama, maybe?
Good morning, Ms. Wolfenbarger.
Good morning.
Suffice to say, you may be a little bit nervous.
Yes.
You don't like cameras,
No.
unlike some of us.
No.
Do you know the defendant?
I do.
How do you know him?
He's my son.
Okay, I want to ask you to lean forward, please, and speak closer to the microphone.
Okay.
And remember to talk kind of slowly.
Okay.
So, how do you know him?
He's my son.
Okay. And did you know Melissa Wolfenbarger?
Yes.
And how did you know Melissa Wolfenbarger?
His wife.
Okay. And did you spend a lot of time around Melissa Wolfenbarger?
All right. If you notice already, we've got some distinction here. She didn't say my daughter-in-law. She goes, his wife. That's telling.
Somewhat.
Somewhat. And describe your relationship at the time that you were around her somewhat.
Well, they mostly lived with my mom, and the kids was there, and I would go and visit up there.
How far away did you live from your mom?
From Locust Grove.
Okay, I'm
to
too loud,
Stockbridge.
Joe.
Okay.
I mean,
how
June.
often would you go up there?
This better.
Just, maybe, I don't know, just every other day or once a week or something.
want to show you a document that's already been admitted into evidence. Are you familiar with that document?
Yes.
And can you describe what that document is?
Melissa giving me temporary custody of the children.
Right. Okay. And when she gave that to you, did she give you any reason why she was choosing you as opposed to someone else?
She does not want them down her parents' house.
And at some point later, did you make that temporary custody permanent?
She did.
Okay. And you remember what year that was?
I don't know.
And when she had you do that, did you go down to the courthouse, or how did that work out? How did you get the message from her that she wanted you to do that?
Called me on the phone.
From where did she call you from?
I was at my mother's house, my parents' house.
And where was she calling from?
I assumed the court place. I
At
don't
the
know.
courthouse?
Mhm.
Do you remember when Christopher and Melissa moved to Atlanta? Just generally speaking.
I'm not sure.
Do you remember that they moved to Atlanta?
When they moved to Atlanta?
That they moved to Atlanta.
Yes, they did move to Atlanta.
Okay. And do you remember what street they moved on to?
Brookline.
Okay. And who owned the house they lived in?
My parents.
Your parents, both William Autry
And
and
Virginia.
Virginia Autry.
Yes.
And did they own any other houses in that area?
2. There was 3 altogether.
3 altogether.
Mhm.
And did a Mr. Holyfield ever own the house that Christopher lived in?
No, he didn't.
Okay. To your knowledge, did he own any of the houses?
He
that your
did
parents-
not.
Okay.
As my knowledge, he didn't.
Do you know who Mr. Holyfield was?
I'm not sure who. I've heard of the name, but I'm not really sure who he was.
I'm not talking about the boxer.
Oh, no. Okay. No.
All right. Do you remember during the time that Melissa went missing? Did you ever talk to the police? Did the police ever come to talk to you about Melissa being missing?
I can't recall, but I don't know. I can't remember if they did. I don't know.
Is it possible that
It's
they did?
possibly they did.
Okay. And somewhere around the time frame of 2001, early 2000s, do you remember ever taking down Melissa's pictures from your home?
Well, I'm always changing my walls and my pictures and stuff, so probably did.
Is it possible that it
Possible,
happened?
yes.
Okay. Do you remember a time that certain pictures of Melissa were stolen from your house?
Yes.
Okay. Describe that a little bit for me.
When we had moved to McDonough, I had photo albums in my garage, and there were some photo albums pictures got gone out of the photo albums, and there was 2 lanterns that I had out there that was gone.
2 lanterns.
Lanterns I had on my front porch I had put in the garage, and they had got gone.
And why had you moved the lanterns to the garage?
Because we was working on the front porch painting it, and we just putting the stuff in the garage.
Okay. So you were doing some renovation work?
Yes.
And you put some stuff in storage in the garage?
Yes.
Okay. No further questions at this time, Your Honor.
Ms. Hilton, any questions for this witness?
Yes, sir. Good afternoon.
Good afternoon.
Afternoon. Is it afternoon already over there? Yes, it
You
is.
just spoke on direct examination regarding the homes your parents owned on Brookline. The homes your parents owned, not touch the mic. The home your parents owned on Brookline Street in Atlanta.
Yes.
They said it was 3 homes?
There was duplexes.
Duplexes?
Yeah.
But were there 3 duplexes that they owned?
Yes.
And is one of the addresses 823 Brookline?
Yes.
Was another address 824 Brookline?
Yes.
And what was the third address?
I'm not sure.
Okay.
I'm not sure.
Now, these homes, are they the homes that you grew up in?
The 823 one was.
823 you grew up in. Did you have other family members in 824 in the other?
My uncle.
About how old were you when you moved from Brookline?
How old was I?
Yes, because you said you grew up in 823, right?
Yes.
Okay.
Probably about 17 or 18. I don't. I mean.
When you moved out of Brookline, did your parents still live there?
Yes.
And did your parents eventually move from Brookline?
Yes.
Roughly what years do you think your parents may move from Brookline?
I'm not sure. I don't know.
70s, 80s, 90s?
Probably about 2000. I don't know.
Oh, 2000.
I guess. I don't know. I'm not sure.
One.
She is so nervous and uncomfortable. It's making me uncomfortable for her.
You moved out of the Brookline house. Did you ever live back on Brookline?
No.
Once you moved out of Brookline, how often did you go back to Atlanta?
I don't know. I don't know.
I apologize, ma'am. I've heard everything you've said so far, but if you'll just make sure and speak up a little bit into that microphone. Thank you.
I'm sorry.
Would you ever go to Brookline to check on the homes on Brookline?
To check on? No. Why would I? No.
No. At some point, did your brother Rick live in one of the houses on Brookline?
Yes.
Which house did he live in? Do you remember?
823.
Did you ever visit your brother on Brookline?
Yes.
Did your brother live at 823 Brookline in the late 80s, early 90s?
I'm sure he did. I'm not sure, I guess. I mean.
Would Chris ever visit your brother Rick at the 823 Brookline house?
I don't know, because I guess. I don't know.
Now, Mr. McDermott asked you about Mr. Holyfield.
Mm-hmm.
Yeah,
I'm sorry. Yes.
It's okay. Do you know Mr. Holyfield's first name?
I have no idea.
Now, you said that Mr. Holyfield never owned any of your homes. Do you know Mr. Holyfield managed any of the homes?
No.
Okay. How do you know Mr. Holyfield?
I don't.
Okay. How do you know that name?
Because it was through the, I don't know. I don't know him.
Did he have some connection to your parents' homes on Brookline?
I don't know. I don't know who. I've heard the name, but I don't know.
She testified on cross that she didn't know who he was. So this is pretty much asked and answered. What's the point?
Overruled. Go ahead.
You said you know the name. Why do you know that name?
For the houses, I guess. I don't know who. I don't know.
Now, you said that Chris and Melissa lived at your parents' house at some point.
Yes.
Okay. If Chrissy was born in August of 1995. Is that fair? Chrissy's born in August of 1995.
Yes.
When did they live with your parents?
The years I'm terrible with the years. Oh, probably probably a year old or so, or maybe, I don't know, before, but probably about a year old or so, or before. I don't know. But
Were they living with your parents before Chrissy was born?
before, I don't think so. I think they had, no, or I don't know.
So is it fair to say they didn't live with your parents until after Chrissy was born?
Yes.
And so that's sometimes after 1995.
Yes.
And they lived with your mother for about 2 years, 2 or 3 years, and moved to Brookline in 1998.
Sounds like it, yes.
And they moved into 824 Brookline.
Yes.
Did you ever visit them at 824 Brookline?
I guess. I'm not sure. I don't think so. I don't know.
You don't think so?
I don't know. I don't know.
Do you know if they were paying rent to your mother when they were staying at 824 Brookline?
I'm pretty sure there was.
Now, in 1998, at least the early part of 1998, you had temporary guardianship of Chrissy and Joey, correct?
Yes.
Did you ever take the kids to go visit their parents on Brookline?
They would come and visit them. Yeah, they would come. Yeah.
When you say they would come, will you bring the kids to Brookline, or are you saying they mean Melissa and Chrissy would come to you?
Chris and Melissa would come in there.
They would come to visit you?
They would, yes, they would come, yes.
Did you ever visit Christopher at his job, at any jobs he ever had?
No.
Do you know where your son was working back in 1998?
I'm not sure, but they said the glass place is what, is that, I don't know.
Had you ever been to the glass place?
No, I don't even know where it, no.
You said you don't even know where it is? Isn't it true that Melissa wanted to dissolve your temporary guardianship in 1998?
No.
I'm sorry?
No.
She did not want to dissolve it.
I'm sorry. Can you reread what you said? I mean,
did Melissa want to dissolve the temporary guardianship?
Dissolve it?
Did she not want you to have her kids anymore for a short period of time?
No.
Are you aware about an incident in July of 1998 in which Melissa took out a TPO on your son, a temporary protective order on your son?
I did not.
Did you ever go to court with your son to answer to a temporary protective order?
I didn't know anything about it.
When Chrissy and Joey were younger, isn't true you wanted them to call you mother or mom?
No, they just called me mom, but they knew I was their grandmother.
Did you ever tell Melissa, Chrissy or Joey about Melissa after she disappeared?
I told them we would go look for her, but we didn't know where to go look.
When you say you would go look for her, what do you mean?
I mean, she was gone. We would look. I mean,
Where'd you go look for her?
I don't have no idea. I mean, if somebody would go, we'd just go look for her.
Where'd you go look for her?
We didn't because we didn't know where to go.
Oh, so you didn't go look for her?
No.
Did you ever tell them about their mother?
I told her that she had left and that we would go look for her. If we could, that's about it.
Okay, so you told them that she had left and that you would go look for her.
Yeah.
But you never went to go look for her?
We didn't know where she was at.
So why did you tell the kids that you were going to go look for her?
Because we would go look for her if we knew where she was at. I mean,
So is that what you told the kids? If we knew where she was,
Oh, snap. No. I don't know why that did that.
I have no idea.
Sorry, guys. It feels like there's crickets in the room. I almost feel like I'm sitting on a screen porch watching this. It feels like the crickets on the ears.
his children about their mother?
I'm pretty sure he did.
Did you ever see Chris do it?
No, he would have them.
How often would he have the kids?
He would have them a lot. I mean, he would come up and play with them and take them places, and we all went to Six Flags. And
when was the last time you remember seeing Melissa?
I guess at the courthouse when we done the papers. I
apologize, ma'am. I just need you to speak a little more loudly and clearly into that microphone. Thank you.
I guess when we did the paperwork at the courthouse. I mean, I don't remember when.
Now, is this in 1998?
98, I believe so.
Now, do you recall in 1998 when you got full guardianship or permanent guardianship of the children? Do you remember Norma Patton bringing the children to you?
Bringing them to me?
Yes, like giving you the children.
No, I don't remember her bringing them to me. Oh.
Do you remember Norma Patton ever giving you the kids at any point in time?
I remember they was at their house one time, and they brought them back, and they had a head full of lice, and they had Joey had diaper rash, and me and Melissa went down to Walmart and got some stuff and done all their heads with. I mean, that's the only time I remember this.
So you never remember picking her up, picking the kids up?
The kids up? I don't.
You don't remember?
I don't know.
Did you ever see Melissa around the holidays in 1998?
We had Christmas at my mom's house.
Okay. Do you remember that being in December of 1998 when you had Christmas at your mom's house?
Yeah, I guess, yes.
Okay. Was Melissa present at that Christmas at your mom's house?
I guess. I mean, I guess she was.
Do you remember seeing her?
Yeah, I guess we're always there. I mean,
when you last saw Melissa, what do you remember? What did she look like?
Long brown hair, just an average girl. I mean, just
long brown hair, about your length?
Probably.
And this is maybe around December of 1998 at that Christmas at your mom's house.
Yes.
Now, after Christmas of 1998, when you didn't see her anymore, did you have any concern about her whereabouts?
Yes.
Did you call the police or anyone to see that she was missing or to report that she was missing?
No.
To your knowledge, did your son call to tell anyone that his wife is missing?
I'm pretty sure he did. I mean, I don't know.
You don't know. In 2000, do you recall a detective from the Henry County Police Department coming to speak to you about Melissa's disappearance?
In 2000?
Yes.
I don't remember.
And do you remember being reluctant about giving him information about Chris?
I don't remember that. No.
Do you recall this detective wanting to kind of make contact with Chris so he can talk to Chris about his wife's disappearance?
I have no recall about any of that. No. Hmm.
And I guess, is it fair to say that since Melissa went missing, you didn't really go look for her, right?
No, I didn't know where she was at.
To your knowledge, your son didn't go looking for her, right?
I'm pretty sure he did. I mean, I don't know.
And it's safe to say you love your son, right?
Yes.
And as a mother, you're a protector of your son, right?
Yes.
She's about ready to break down, y'all.
Court's indulgence. Sure.
Okay, while they're doing the court's indulgence, let me quickly say the Christopher Wolfenbarger's children are not supporting him in this trial. The fact of the eldest daughter, Christina Garrett, testified against him in court this week, offering a deeply personal and unsettling insights to upbringing by her father. They were raised by the paternal grandparents. Christina said she was led to believe they were her real parents. No memories of Melissa. She was a toddler when her mother disappeared and only learned of the truth years later. The family scrutiny is that she was discouraged from asking questions about her mother or the Patton side of the family due to the stigma surrounding her grandfather, Carl Patton's criminal activity. When at the funeral, Melissa's in 2003 funeral, Christine recognized Norma Patton, her maternal grandmother, as a woman from the front yard who had sporadically visited them. And I don't know why that feed is going that way, but it is. Let me go to another feed if need be. Okay, they're behind a few seconds. So we'll just keep it there for a minute. Uh-oh. They lost signal. So we're just going to pop it over here and let that play in the background. So by 2013, Christina had cut off contact with Christopher, searching for answers on her own. She recalled her father making a disturbing comments about how to hide a body and referencing real cases they would watch together. Y'all, this is kind of creepy. Let me see if the camera's back up. It's not. Okay. Christina's testimony not only distanced her from her father emotionally, but painted a picture of manipulation and concealment and a long-term deception. Her decision to testify publicly against him adds weight to the prosecution's narrative and undermines the claim that Charles was a misunderstood grieving spouse. So that is where they are when it comes to that part of the case. What I'm going to do right now while we're waiting for that to come in, we're going to hop on over here. We're going to play. This is Donna Adelson.
This will be the attorney's only opportunity in this trial process to directly engage in conversation with you. The purpose of the questioning by the attorneys is to assist them in determining if your verdict in this case would be unduly swayed or influenced in some way by your personal experiences, any opinions that you currently hold, or any special knowledge and training that you may possess.
Since when has she had those ear things, y'all? I don't remember her ever having headphones. This is the first time I'm seeing this old lady in headphones. And that yellow with the red and white stripe, it ain't working for you, boo.
The object of this process is to select jurors who will impartially try the issues of this case that will be based on the evidence that is presented in the courtroom without being influenced by any other factors. It is very important that you be totally candid and truthful with us today. At parts during this jury selection, once again,
I am jumping.
All doubt.
I'm jumping to this
reasonable
page.
doubt
Thank you.
is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant may not take the witness stand cannot influence the jury in any manner whatsoever. The attorneys at this point are going to have their opportunity to ask you some questions. What they say now or at any other time during this trial is not to be accepted by you as evidence or any instruction on the law itself. They are simply going to be asking you questions. Please do not infer anything or read anything into the questions that you will be asked. Before I turn over the inquiry to the attorneys, let me remind you to please answer their questions honestly and forthrightly, and also volunteer any information that you believe may be important. Is counsel for the state prepared to inquire?
Yes, Your Honor. May it please the court. Well, congratulations. Yeah. It's a compliment, I think. So I'm going to ask you some questions about some legal concepts. Today is not the trial. You're not going to hear any evidence in the case today. As the prosecutor, it is my burden to prove the case to you beyond a reasonable doubt through evidence, which we will do. I'll be assisted by Sarah Catherine Dugan in doing that when the trial actually starts. But for jury selection, we're just trying to get sort of your ideas about concepts and issues that we think might come up during the course of the trial. And it's important and will be less painful, certainly for me and probably for you too, if you guys will participate and raise your paddles and answer. And I'm going to attempt to not.
Okay, we do have the feed again. I hate to do this, but they're going to go to break in the other trial shortly, I'm sure. So I'm going to pause her testimony and the other one, and we'll bounce back over there. I'm going to give this to you guys. You guys have the choice today. Do you wish? Oh, we have another feed problem over there. Do you guys want to continue to follow the end of the Wolfenbarger, which is what I'm prone to do, and then in breaks and pauses, we will catch up on the Donna Adelson. They are hoping to get into possibly getting into at least the prosecution's opening statements today. And we are probably going to get into the jury instructions in the Wolfenbarger case today. So what I'm prone to do is continue with the Wolfenbarger for now. When they get into the jury instruction debates, we'll hop over and during breaks to Donna Adelson. And by the end of the day, they'll match up. So thank you so much for joining. Thank you so much for sticking with us. I will go ahead and reset her so we don't lose our place. There we go. And we're going to go back over to the Wolfenbarger trial for the moment. Until next break.
This is Chrissy's graduation, 18th, and Chris and me. Okay, this is Chris.
And can you describe what's in that photograph, please?
Okay, this was Savannah, and it was in Savannah, Georgia, and we're sitting on a bench, and Chris and Melissa are eating ice cream cones. And there's Kimberly and there's Chrissy in the stroller.
And how old is Christy in that picture?
She's in the stroller, so I figure about 2,
And
maybe, or 1 or so.
A couple more questions. In that picture, is Melissa wearing long sleeves and long pants?
No, she's in like a little short little, is that like a culottes thing? Like a.
And is she got any bruises on her arms or legs?
No, not at all. And she's smiling and she's laughing, happy.
I don't have anything further.
Ms. Hilton, any additional questions for this witness? And when y'all are done, if you'll sort of just collect the photographs on that front ledge. Thank you all.
First ask you this. In 2023, around December of 2023, did members of the Fulton County District Attorney's Office and Investigator Shepard come to your home or your daughter's home to speak with you?
23. I'm not sure. I mean, I don't know.
Do you
Did
remember
she?
seeing this man before? Do you remember him? Seeing him?
I think I've seen him before. I mean, yes.
Was that at your home? or
At
your
my
daughter's
home? I don't think it was at my home. I don't remember. I don't know.
Do you remember anyone in the 2020s coming to talk to you about Melissa's disappearance?
Yeah, they came to my daughter's house. Was it last year or something like that?
And that was before Chris got arrested. Is that fair to say?
Before, yes. I think it was in January.
Now, we talked about these pictures. Looks like graduations, fishing trips, birthdays, kindergarten graduations. And these are all events that Melissa didn't have the pleasure of enjoying. Is that correct?
She was in some of the pictures.
She's in one of the pictures, right?
I guess. I mean, yeah.
Is it just that last one where I think they asked you about what clothes she was wearing?
Mm-hmm.
Oh, thank you.
Thank you.
This is the only picture that has Melissa, right?
I'm sorry, is that a yes, ma'am?
Oh, yes.
Thank you.
And that's been, this picture in 1995 or 6 was Chris in the stroller.
There was one that went to Six. There was one that we stayed at Six Flags.
But in this picture, this is before 1998, correct?
I guess, yes.
Okay. So this is before Melissa ever called the police on Chris for hitting her, correct?
I don't know.
And some of these pictures are after 1999. Is that fair to say?
Yeah.
After Melissa's body and head was found on Avon Street?
I guess. I mean,
After her torso, which has never been found?
I guess. I mean, I don't know. I don't know.
Melissa didn't have the opportunity to participate in her children's lives because she was dead, correct?
I guess. I mean, I don't know what happened to her. I mean,
Sustained.
It's argumentative.
I already said sustained, but thank you.
I have no further questions, Your Honor.
Thank you. Anything else, Mr. McDermott?
Nothing for this witness, Your Honor.
Okay, thank you. You may step down, ma'am. And the witness may be excused. Mr. McDermott? Okay, the witness is excused. You can just leave that there, ma'am. Thank you. So, it is my intention. It's nearing on 12:45, and so I was going to go ahead and break for lunch. And so, ladies and gentlemen, it is about 12:40. I'm going to have you back in here around 1:40 to resume the afternoon. So we're going to break for 1 hour for lunch. Enjoy your lunch.
Well, we got a lunch break, so now what we're going to do is we're going to go back over to Donna Adelson.
Before I turn over the inquiry to the attorneys, let me remind you to please answer their questions honestly and forthrightly, and also volunteer any information that you believe may be important. Is counsel for the state prepared to inquire?
It's hot in the courtroom. She's hot, she's cold, she's hot, she's cold.
It's a compliment, I think. So I'm going to ask you some questions about some legal concepts today. It's not the trial. You're not going to hear any evidence in the case today. As the prosecutor, it is my burden to prove the case to you beyond a reasonable doubt through evidence, which we will do. I'll be assisted by Sarah Catherine Dugan in doing that when the trial actually starts.
Wait. Okay, wait. Got some drama going on. I'll go back over there. Got drama going on.
In terms of his intentions regarding testifying, is that a conversation that you already had with Mr. Wolfenbarger, and that's a decision that's been made by Mr. Wolfenbarger to your satisfaction?
Not quite.
Not quite.
I want to talk with him.
Okay, so talk about it over lunch, and then perhaps we'll revisit it when we return from lunch before the jury comes back in?
Yes.
Okay. Anything else the parties want the court to take up before we adjourn for lunch?
Nothing from the state, Your Honor.
Nothing for the defense.
Okay, thank you. We are in recess until, for that reason, if you guys.
But for jury selection, we're just trying to get sort of your ideas about concepts and issues that we think might come up during the course of the trial. And it's important and will be less painful, certainly for me and probably for you too, if you guys will participate and raise your paddles and answer. And I'm going to attempt to not say names and only say numbers. So this is obviously an important case. I know some of you probably don't mind speaking up. Many of you probably are shy and less likely to speak up. So I would encourage my shy guys to please participate as well, because your voice is just as important. Let's see. So I want to identify sort of like my leaders on the group. Do I have folks that supervise people at work or have supervised people in the past? Start on the first row because I'll probably have several of you. Juror 2.
Yeah, construction managers, local volunteers, 30 volunteers all day, Saturdays, building houses. So.
Some cats to herd there.
Yes.
Okay, thank you. Anybody else in the first row? Yes, sir. Number 7.
So coordinating, organizing volunteer teams, and then I've had as much as 6 staff report to me.
Okay. All right, thanks. Anybody else? First row, second row, leadership staff, and I would include head of an organization or something like that, if that's part of your resume. Number 8.
I'm a GIS project manager, so I have about 8 people that work under me. They're all students. Some of them are paid, some of them are unpaid.
Okay, thanks. 9.
I work as an impromptu team leader for our department whenever there's any issues or need assistance.
All right, how many members of the team?
About 10 on a good day.
Wait. What did he say he worked? I want to hear that.
As project manager, so I have about 8 people that work under me. They're all students. Some of them are paid, some of them are unpaid.
Okay, thanks. 9.
I work as an impromptu team leader for our department whenever there's any issues or need assistance.
All right, how many members of the team?
About 10 on a good day.
Number 23.
I supervise 2 spray technicians at FSU.
Okay, thank you. Anybody else? Second row. 11.
20 years in the military, about 15 of those in various leadership roles.
Okay. Thank you. Thank you for your service. 13.
Did 8 years in the military, about 5 of that in leadership roles. Currently a lead pastor of our church.
Okay. Do you supervise the staff there?
Those volunteer staff, and then I'm the lead
Pastor in the church.
elders that we have at the church. I'm the lead elder as well and supervise that.
Okay, thank you. Anybody else over there? Third row. Yes, sir. 16.
Previous work, I was in charge of a team of 3 for a warehouse, and current job, I am frequently one of the people training new employees.
Okay.
There are a lot of males.
Thank you. Anyone else in the back? 17.
I currently have a direct reporting team of 6, as well as a number of matrix resources as part of my work.
Okay. Anybody else in the back row? Yes, ma'am, but you're not going to tell me, or I know. Anybody else? Okay. All right. Anybody consider yourself a leader, like you just identify as that type of personality, even though you haven't raised your hand as somebody that necessarily supervises others at work? Okay. For my guys that haven't spoken up, obviously we want a jury that delivers a verdict that's your verdict, right? Even if you're a shy guy, I feel like maybe you qualify. Number 6, shy guy? Probably not so shy at home, but shy in this setting. Okay, do you find this setting a little intimidating? Anybody find this setting a little intimidating? Show of paddles? Okay, I mean,
we're out.
Right? Nobody likes to speak in public to begin with. And then we've got a lot going on here, a lot of people in the room and so forth. So if you were feeling shy or feeling intimidated by this setting, but you were chosen to be on the jury, would you be able to sort of stick to your guns, have your voice heard back there, make sure the verdict that comes back is your verdict? Anybody feel like they would struggle with that? I'm just not the guy that's going to push against the grain. Okay, 21, tell us. Okay, this particular setting. Do you think if once we kind of roll along, if you're selected, you start hearing evidence and all that, you'll start developing opinions, and at the end when you're asked to deliberate, would you feel confident speaking up if you had a difference of opinion with your fellow jurors? Okay, so you think you might struggle with that. So whoever was in charge back there would really have to ask you, what's your opinion? Okay. Anybody else feel like juror 21, like you might struggle to speak up? Okay, 3, tell us about you.
I have pretty bad social anxiety and actually public speech.
Woman.
Special accommodations public speech class when I went to FSU.
Okay.
Like 500 people in the class, 20 people had to do that. And of those 20 people, I'm the only one that cried. So
Well, you're doing great. You haven't even cried yet. We're on a roll. Okay, so the foreman may have to draw it out of you, but you would be able to speak your opinion if called upon to do so. You're just not the guy that's going to interrupt and yell and get over everybody else.
Right. And
okay.
I don't know when the appropriate time to ask is, but on Tuesday, I mentioned a medical constraint, and I did bring a doctor's note with me.
Okay.
And I haven't had
All
an
right.
opportunity to mention that yet.
Okay, thank
So,
you for mentioning
yeah.
it, and we'll probably take that at sidebar at some point. So, yes. Anybody else have something they need to tell us at sidebar, medical or otherwise? All right, so for my folks that have been on a jury before, raise your paddles again, front row. Yeah, okay. Was it a good experience, a bad experience? Don't really remember.
It's good. Yeah, I have an experience to see how the inner process works and go through it. Yeah.
All right, that's number 2. Number 22? Was it an okay experience for you?
It's not bad. Something new. We consider we come from different countries,
Mm-hmm.
different government system.
Yes, so helped you learn about our system a little more, see it for yourself. Okay, that was a 1-day trial, I'm guessing. Okay. It's a good primer. Second row? Yes, number 9. Did you have a good experience or otherwise?
It was interesting, to say the least. I think it was
Okay.
done a bit differently than usual, but the
Was
judge.
it here in Leon County?
Yes, ma'am.
Okay.
I think the judge had the jury excused every time the lawyers needed to speak with him, which was pretty much every other 10 minutes.
Oh, so it was a lot. You got your steps.
Yes, ma'am.
Okay, well, better than going to sleep in the chair, I guess.
Yes.
Okay, second row, third row, good experience, bad experience, number 17.
Yeah, it was a positive experience. It was a 1-day trial.
Yeah. Oh, those are nice for jurors. They're no better than 2 to 3 weeks. I think it's going to be more on the 2 side. Don't hold me to that, but for your planning purposes. All right. Anybody else? Jury service people. Yes, 19.
It was okay. Not something I want to do again.
Yeah, I'm not going to deduce from you saying it was okay that you want to do this. I know it's a big ask and a huge imposition on you, and I don't mean to minimize that at all. I just want to know if it was okay. Sometimes
I don't want to do this again. Don't make me.
Traumatized or.
No, please. Don't make me. Don't want to do it again. Boot me.
They argued back there.
That's how I heard that.
Or whatever. So I just want to know if it was anything like that. So you didn't have any.
No, there was no like yelling or anything.
Okay, good. And for all my folks on a jury, without saying what the verdict was, were you able to reach a verdict? The ones that deliberated, everybody did. Okay. All right. Anybody have any legal training on the panel? Okay. Number 22, you said you work at the AG's office, but I don't think you said in what capacity. What type of work do you do? Okay.
Oh, he ain't going to be on there.
And your husband, state of Florida, but what type of work?
He's working public record in Bangkok.
Okay. All right, so I touched on this a little bit already. The burden, and I think the defense will emphasize this, is mine. So that means that I have to prove the case to you with evidence. It's completely my burden, the whole thing. So they don't have to do anything. They don't have to put on witnesses. They can do their nails, read the newspaper, not participate at all, which of course we don't expect they'll do, but they don't have to prove anything. That's really important. So you've heard no evidence right now. If you were asked to render a verdict right now, it would of course be
guilty,
right? Because you've heard no evidence. And the only place the evidence is going to come from is this table, right? The state. It's innocent until proven guilty. We prove the case. Would you like to hear from the defendant? Sometimes that's a question. Human nature, yes, but you cannot require the defense to prove anything. Everybody understand that.
Yes.
It's the way our system works. Okay. All right. Reasonable doubt. You heard an instruction on this, and lawyers tangle with this at jury selection all the time and do a pretty poor job. Probably will not be an exception, but the idea is nothing can be proven to you beyond a mathematical certainty, right? If you knew for sure that a thing happened 100%, it's because you saw it with your own eyes, and that makes you what? A witness, not a juror. So you're going to have to make a decision based on the evidence. And it is a very high burden. It's the highest burden in the land, right? It's a high burden, and it should be. But it's not impossible to convict a guilty person through evidence. You're not going to have 100% mathematical certainty because that's not possible. So the example I use, which probably isn't a great one. Number one, did you drive here today?
Yeah.
Where'd you park your car?
Parking garage.
All right. Is your car still there?
I hope so.
You hope so, right? Do you have a reasonable doubt that your car is there where you left it?
No.
Okay. No. Right? Because the evidence is he parked his car there. Did you lock it?
Yeah.
You locked it. Is there any security there?
I mean, yeah, I think so, but who knows?
There's security there. Okay, so he has no reasonable doubt that his car is where he left it. If he gets there and it's not there, he's going to be really surprised. Now, if we change the facts, he left his car there. He didn't lock it. There's no security. There were 2 or 3 very suspicious looking guys lurking around the car when he left. And when he left, he said, you can have it if you want it. I left the keys in it. Okay, now we're starting to change the facts, right? Now he has a reasonable doubt that the car is there. You basically invited somebody to take it. All right, so you as the jurors will decide, is this doubt reasonable or not, right? So I'm going to say a bunch of words and they're going to say a bunch of words, but ultimately at the end of the day, when you get back there and you're assessing a doubt, I have a doubt. Well, tell me about it. You talk about it. Is it reasonable? That's your question, right? And you decide what's reasonable or not. Okay? Shaking of head.
Part is, can approach briefly.
So we have a little sidebar.
All right.
Who was mission and hired from.
Juror 24, what is your occupation or your type of work? Juror 24, what is your occupation or your type of work?
I'm retired from the United States Postal Service as an electronic technician and as a veteran in the United States Navy.
What is your marital status?
I'm married.
What is your spouse's occupation if they work?
She's a nail clerk.
Do you have children?
I have an 11-year-old boy.
And he does not work.
He does not.
How long have you lived in Leon County?
Since 97.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
I do not.
Have you, any close friends or relatives, ever been charged with a crime?
I have a brother who was convicted of armed robbery.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Also, to inquire as to the other matters that the court previously raised, have you ever served as a juror previously?
No.
As to the attorneys, are you related by blood or marriage to any of the attorneys, or do you know the attorneys or any of the persons that are part of their staffs?
No.
Are you related by blood or marriage to the defendant, or do you know the defendant?
No.
Concerning the names of the witnesses that were previously read out loud, do you recognize any of the names of the potential witnesses?
No.
Thank you. Juror 25, what is your occupation or your type of work?
I am a sales account manager.
What is your marital status?
Married.
If you can just say it again and try to speak up as much as you can.
I'm a sales account manager.
Thank you. And your marital status again?
Married.
What is your spouse's occupation if they work?
He works in sales.
Do you have any children?
I have two. I have a 4-year-old and 11-month-old.
And I assume they do not work.
No, sir.
How long have you lived in Leon County?
5 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
No, sir.
Have you, any close friends or relatives, ever been charged with a crime?
My 4-year-old's father has previously been charged with felony drug-related stuff.
So you don't know the exact name, but something relating to the possession of drugs.
Yes, and distribution.
Have you, any close friends or relatives, ever been a victim of a crime?
No, sir.
Going back to the other questions that the court previously raised with the group, have you ever previously served as a juror?
No, sir.
Are you related by blood or marriage to any of the attorneys, or do you know the attorneys or their staffs?
No, sir.
Are you related by blood or marriage to the defendant, or do you know the defendant?
No.
Concerning the names of the potential witnesses that were previously read, did you recognize any of those names? Right. Ms. Kappelman, you may continue at this time.
For my new folks, any leadership or management experience, maybe in your time in the Navy or elsewhere?
I was a supervisor for several departments when I was on board the aircraft carriers.
Thank you. And number 25, do you manage anyone currently?
I probably have children.
Yeah,
Not-
that's-
Not currently, but I do have about 7 years in like leadership experience.
Okay. And is that in the sales world?
Yeah, sales, customer service related.
Okay. Did you hear my spiel about reasonable doubt? Feel like you're getting your head around that one a little bit? Okay, same with you, sir. Okay. All right, well then we will keep it moving. Jury decides the facts, so you'll be the judge of the facts, not of the person. We're not asking you to render judgment on anyone. But still hearing that, some jurors sometimes feel like this is too heavy, this is a very serious case. Is there anybody that feels like, I'm not sure I could make a decision knowing how serious the case is? For whatever reason. First row, second row, third row guys, no, okay. So your job will be to hear the evidence and to make a decision. Is this, have these crimes been committed?
What?
And is this the person that committed the crimes? Judge of the facts.
Matt?
And the judge is going to give you all the law that you need. You don't need any legal training. Please don't do any research on the law. And his job is to sort of referee what comes in as evidence and make sure the rules of evidence are followed in the courtroom. The judge's job also includes sentencing. So you will not be asked to make any recommendations or determinations about sentencing at all in this case. Does anybody feel like I would still be worried about sentencing, even knowing that you're not being asked to make any decisions about sentencing? Number 20, would you be worried about that at all?
No.
Wouldn't worry about it. Can you set it aside? Number 18, or is that something that would weigh on you?
Set it aside.
Okay. Anybody feel like I would worry about that? All right. Many of you have had some kind of interaction with law enforcement or close friends or family members that have. Have any of those been significant, meaning they've impacted you in some way personally? I mean, if you had a DUI 20 years ago and it was handled fairly, I don't need to know more about that. But if something has really colored your view of the criminal justice system or impacted you personally, we had some folks that had some quite serious cases that friends or family members have been involved in. I want to know, was the person treated fairly? And how has it impacted you? First row, anybody volunteer to say, I've been impacted by crime in a way that has deeply affected me? Okay. Second row, anybody treated unfairly? We had somebody that was falsely arrested. That's a big one.
My brother got pulled over in a vehicle and didn't present ID.
Matt,
until
I
he
need
was
help.
in- He was in possession of drugs.
Fell.
For some reason, they let him go.
My
gonna be
Nintendo
wanted
fell
for
back
him
in
or
that
something,
corner.
I don't know, and then they couldn't get a hold of him. Naturally, they issued a warrant for me. because he used my ID.
Yes, sir.
So once I found all that out and got a hold of the right folks, the system actually worked well for me once they got dash cam and body cam video and was clearly able to see it wasn't me. I was able to get everything resolved. So
Sure, but
really
what a
bad
headache to
experience
get
early
there.
on and turned out pretty positive because the evidence did.
Okay.
prove
Anything
like it is.
about that you think would bleed into your deliberations on this case? Oh, I think the cops are all crooked, all arrests are false, anything like that?
No.
Okay. Second row, anybody else deeply affected by crime? Any crime in your life? Okay. Third row, anybody fall into that category? Who thinks there is a significant problem with the criminal justice system? It's broken, doesn't work well. Just raise of paddles. I'm a little broken. Okay, I'm seeing a couple little paddles. Little broken, not perfect. Not perfect. We can all agree with that one, I think. Anybody feel like you have such strongly held views in that regard that you think it could impact your ability to follow the law and render a fair verdict in this case? Seeing shaking of heads. Okay. Anybody had a bad experience with law enforcement? I know I'm asking the same question 3 or 4 different ways, but I just want to make sure I'm catching everybody. Yes, sir, 24.
I was pulled over. My plate came up with a stolen plate from another state. And I had guns drawn on me, and they figured out that it was from another state finally. But when you have guns drawn on you, it's not a fun thing.
It's a bad experience.
Yes.
Anything about that you think might interfere with your ability to do your job in this case?
They offered a lot of apologies after that. And God said,
too little, too late.
Yeah, it was. And I was headed to work, so
yeah.
Luckily, I was not late.
You were not falling asleep at your desk that day.
Before you continue, I'm curious, did you have on the mail carrier uniform?
I had my uniform on, but I'm an electronic technician.
I see.
Fix the machines.
Please continue, Ms. Kaplan.
All right. Law enforcement officers. So several of you have either backgrounds in law enforcement, yourself or a close friend or family member that's been in law enforcement or is in law enforcement. And the reason why we inquire about that is because we want to make sure we have jurors that, obviously you heard my list, there's quite a few law enforcement officers on the list. So jurors that can listen and be critical of law enforcement. So open-minded. If you learn that they have specialized training and experience and are qualified to, have authority on some topic more than the average person, then great, you can believe them more than the average person. But we don't do that just because they're wearing uniforms. So we don't automatically believe everything they say. We don't automatically disbelieve everything they say just because they're law enforcement. Anybody feel like they struggle with that? And the defense may get up and say, so-and-so, your father was a law enforcement officer. Somebody was. Whose dad is? Okay, your dad isn't a law enforcement officer. Don't you automatically believe what law enforcement says? And maybe that was true before coming in here. Probably not for you, but the instructions of the court are level playing field. Can everybody apply the instructions of the court on law enforcement? Okay, they can make mistakes, right? They're also not perfect, like the system. Okay, what are undercover operations? Anybody know? Volunteers, just let me flounder up here. Number 1, undercover operations, like a law enforcement operation that
people don't know that the cops are there trying to figure stuff out.
Yeah, like the cops are posing as not cops,
Right.
posing as someone else. So they're tricking somebody, right? Anybody uncomfortable with the idea that law enforcement is permitted legally to pose as somebody else and trick criminals to get information and to solve cases? Anybody feel uncomfortable with that? What do you think? 13.
I see the benefit of it.
Welcome. Thanks for joining us.
I think the technique in which it is executed is the one that catches my attention.
What do you mean?
So if somebody, it all depends on who it is that they're going after and the subject themselves. Right? But if a law enforcement officer is posing at somebody in order to try to entrap people.
Yes. Okay. Entrapment would be crossing that line.
Who are not intending to commit a crime. I would take issue with that.
Okay. So entrapment would be exceeding their authority to pose as someone else. But for the sake of this argument, let's assume it's not an entrapment situation, but it is a situation where an officer is posing as someone else.
No problem.
Okay. Anybody feel like that's not fair? That's not cool? What do you think, 11?
I think if there's justifiable means to be there doing undercover work, then I'm okay with it.
Is it necessary though? What do you think? 5.
It depends on the context of it. Sometimes it is necessary. I mean, like for police officers to, because I mean, depending on the crime that's committed, police officers not always go in. I mean, it depends on, like you said, entrapment. It depends on the context.
Sure.
If you're trying to entrap criminals, whereas if you're trying to just, how do I word this? Depends on the context, right? Because you can't legally like try to coerce someone to a crime.
Right.
You are.
Hey, I'll give you $50 to take this crack rock over there and sell it to that guy. That wouldn't be okay, right? But what about like posing? Typically, we think of narcotics operations. If you're trying to infiltrate these higher levels where you really can't have access to investigate those people unless you send someone in posing as a fellow Confederate, right? Everybody okay with the concept, within limits, of course. Okay. What is premeditation? This is a premeditated murder. What does that mean?
It's like you planned it.
It's like you planned it. Okay, that was juror 23. So what type of evidence would show premeditation?
Bloody footprints, clothes, a weapon.
Okay, how does that show the operation of the mind, though, the intent?
Well, if you find somebody with their fingerprints on the weapon,
Mm-hmm.
then that's not admitting full guilt right there. I mean, but that's pretty damning evidence.
Okay, yeah. What about for intent, though? Number 16, what do you think? How do I prove premeditation? I didn't just haul off and kill someone on a whim. I thought about it. I had a conscious intent that crime be committed at the time it was committed. How do I prove that? How do I prove what someone was thinking?
I think we would have to rely on evidence that predated the moment of the attack. So if you had like any sort of records or definite plans or things that were found, like
Map of the bank, right? That's how they do it in the movies. They roll it out on the table, get the blueprints and that sort of thing. What else? What other type of evidence might prove intent? 15? You think of anything else? Conversations. I'm going to kill that guy, right? That's pretty good evidence that you plan to kill the guy. What about motive? Motive, would that be important to your consideration, number 7, of intent?
Yeah, I think so. There would have to be some sort of justifiable cause where you could empirically say that would lead a person to premeditate and act with aggression on the victim for X, Y, and Z reasons.
So you kind of want to know why, right?
I think you have to know.
Well, I mean, sometimes you can imagine a scenario where the manner of the killing might prove intent.
Sure.
Shooting once is different from shooting 100 times, right? As far as if you're trying to evaluate intent. So that could be part of it, but certainly motive is very important and jurors want to know why. So the why could potentially be important. Everybody agree with that? What do you think? 12. Any other ideas of what type of evidence? Like, how are you going to prove? You see the problem. How do you prove what someone was thinking?
Right, certainly in the records that they've considered and discussed it, solicited someone to help with it, or
Mm-hmm.
done searches about how to efficiently execute the crime beforehand and that sort of evidence.
Okay. Would you be open to all those types of circumstances to try and show what the person was thinking, as opposed to the type of evidence I laid out right away, which was, I'm going to kill that guy.
Right.
And that's great. But if you don't have that, can you evaluate all the other circumstances?
Yeah, and you have to see if they push you beyond the reasonable doubt.
Yeah. Any other type of evidence? Let's get away from premeditation, but in general, that you would expect to see in a case like this, a particular type of evidence. Number 23 mentioned fingerprints, clothing, anything else like that you guys are kind of expecting?
Financial records.
Gun residue,
Financial records.
financial records? If it's, what kind of financial records? Why would you be expecting that in this case or a case like this?
If, from what we were told earlier about the case and the charges, if you're soliciting it, setting aside money, or transferring money to someone. or
Right. So if it's a murder for hire, you'd expect some kind of money to be involved, some type of transaction. Okay. Somebody else down here? Text messages, phone calls. Okay. Yes, sir. Number 6.
If I remember correctly, I remember hearing coming from Miami to actually saw
Mhm.
the gas station receipt.
Okay. Some evidence of that travel. Okay. What else? It's so fun when y'all help me better. Okay. So it's a murder for hire. There's more than one person involved. You, though, as jurors in this case, will only be asked to decide the involvement and guilt or not guilt of one criminal defendant. Are you able to set aside your thoughts and feelings about the other people that may be involved in the case and focus your verdict? How does the evidence relate to this defendant? Everybody feel like they can do that? Okay. if the evidence shows that the defendant is not the one that pulled the trigger. Does that make a difference? What do you say? Why are you shaking your head no, number 15? Why does that make a difference? Okay, so even if you don't pull the trigger, you can be charged with murder? But what?
Please speak out, number 15.
Okay, you could be charged with accessory, but you don't think murder. Who else, by a show of hands, thinks if you don't pull the trigger, you cannot be charged with murder? Nobody? Why not? Number 2.
That is a very important question. Huge question.
If you're, if you hire someone or something like that, definitely you're not committing the crime personally, but if you're telling someone else to do it and they do it, that I think something pretty close to it. Yeah. Maybe
Okay.
not murder itself. There might be some type of
Maybe not murder itself, but it might be something close. What do you think? Number 20.
It's the way the law is written.
Mhm.
You don't have to pull the trigger, but still be charged with what the law allows that you can still get charged with what you did.
Okay. According to the law of our state, and the judge will give you the law. You do not need to know the law. I tricked you, and I'm sorry. But you can be charged just the same as if you pulled the trigger. If you also did some act or said some word to cause that murder to be done, some affirmative act to cause that murder to be done, and you intended it to be done. Okay? It's called a principle. So, court reporter and I are going to do a bank heist, and we know when we go in there, the first thing we're going to do is kill the security guard. Okay? That's our plan. We both understand that that's what we're going to do. But I'm the shooter. She's the bag lady. She doesn't get the money. We go in there, we do it, we're successful until we get caught. We can both be charged with first-degree murder of that security guard, the same as if she had pulled the trigger. Is that fair? How is it fair? 23.
Y'all planned it together.
But I pulled,
Y'all planned it together.
but I'm the one that pulled the trigger. Shouldn't I be worse off than her?
She knew what was gonna happen.
She did. That's been.
Breaking news.
You guys, we have some serious breaking news. Sorry to break in with you. You may not have heard. We have an active shooter at Chattanooga Police working the investigation. Let's listen.
We're on the way to the green dotted white line way to the scene there. So lots of different pieces of information coming in. As we said a little bit before, you'll see me typing and looking down from time to time, just trying to gather the most up-to-date information that we can get to you in this moment as we work with police and our crews on the scene to try to figure out what happened. Let's take a quick look at the UTC campus map. Right in the center of your screen there, you can see the roads with the green dotted white lines. Right above that is the UTC library. And then right above that, the University Center. Those are the two locations that the UTC alert pinpointed that the possible active shooter might be. So right in the center of UTC campus there. We also have a picture from someone that was at the UTC of Tennessee at Chattanooga, where an alert has gone out from the campus saying that UTC is in a current lockdown. Please avoid the UTC campus until further notice. Another alert telling students and staff on campus to, quote, run, hide, fight, as a suspected active shooter is possibly on campus. Now, we just got word from Chattanooga Police that it started as a shots fired call, But the good news, at least for now, is that Chattanooga police say at this time, no victims have been located. So while they are investigating whether there is an actual active shooter, they say at this time they have not found anyone who has been shot or injured as of yet. What you're looking at on your screen is a picture from someone on the UTC campus who was inside the library when this started, when police came and started escorting everyone inside the library out. The viewer who took this picture and sent it to us told us that police had their guns drawn, telling people as they were escorting them out, quote, "This is not a drill." So we are hearing from people who are on lockdown at the campus right now, trying to get as much information as they can. But again, 12:40 this afternoon, CPD police saying it was a shots fired call, sending campus police, sending CPD police, Hamilton County Sheriff's deputies. They are all to the scene as they are trying to figure out what is going on. We know police are staging in a specific area to try to get to the different locations. Here's a map of UTC now. I'm trying to see here if I can zoom in on this for you, but I don't think I can in this format. So they're saying that the library, which you see right in the corner of your screen with those green lines around them there, that is one possible location. Also, the University Center right to the north of that there on UTC campus. That is where the UTC alert said that they were looking for at first for this possible active shooter. Oh, new tweet from UT Chattanooga. Let's go and see what that says. Give me Fulton County EMS post here. Multiple agencies are on the scene at UTC for reports of a possible active shooter. Stay away from the area. More updates will be coming in as they, before we show that, just to make sure what's in it.
Oh, is he set up? What's your first and last name? Ainsley Craig. And just kind of describe the feeling right now in the scenes that's going on.
I'm just nervous for my friends because I was on the phone with one of my friends. She's in lockdown, and people aren't taking it very seriously. You can hear all the people talking in the background.
And then you said you were just in the library.
I was just in the library like 10 minutes ago.
Wow. Any other thoughts and feelings?
I hope this is not real. I hope it's just fake.
I don't like it when they get in their faces. So, I just wanted to give you all that information. There's no new real information. So we'll go back to our trial. Our prayers and thoughts are with the staff and faculty and the students of the college, the police, fire, and EMS, and all first responders. Right now, there's not a report of anyone that has been injured. So thank God for that. But if any new information comes up to contradict what we know now, I will pop back in. In the meantime, let's get back to the Adelson jury selection.
Proven beyond a reasonable doubt. So you agree with that law? Anybody disagree with that law? I do not think it's fair. It should be, as juror number 2 thought walking in here, something close to it, but not exactly the same. Okay. Now that I gave you the spoiler, you won't admit it. All right, so number 2, knowing that now, would you be able to follow that law? What do you think, number 15? If the law says we can both be convicted of first degree murder and it's proven, would you be able to convict her of first degree murder even though she didn't pull the trigger? You would be able to follow that law.
Number 15, please speak up as much as you can.
Yeah. You would. If there was a law that the judge read you in this case that you did not agree with, would you be able to follow it anyway, or do you think it would be incumbent upon you to do what your gut is telling you? What do you think? Number 16?
Since it's rear to the side, if something followed or broke the law, would go with the law.
Go with the law. Number 8?
Yeah, definitely.
Follow the law no matter what, even if you don't like it?
Yeah, it's not me to decide the law. It's just for us to stick to it.
Okay. It's the legislature's job. We're going to leave that to them. Okay. What is a conspiracy? Volunteers for that one? How about you, number 14? What's a conspiracy?
I'm not sure.
You don't need to know the legal stuff. Just what's your idea of it? Come and speak.
A group of people getting together or saying if they have anything that maybe.
Please speak up, number 14.
A group of people try to say that things without using the word conspire.
Yeah.
Get through 9/11 and something to do.
Getting together to do something?
To make something happen. With
Okay.
Other reasoning behind it.
Okay.
I'd like to say that it doesn't even have to be a group. You can conspire to do something alone.
Number 8. Okay. You could, is that what you're doing right now? You want to tell us something? Okay. Do you all agree that a conspiracy can be evidence circumstantially? And what I mean by that is, and this is hard because we can't talk about what the evidence is. I'm asking you to imagine that it could be proven to you that people conspired to do something without an express, we're going to, go in and kill the security guard without that being expressly stated. Can you imagine other evidence, circumstantial evidence? For example, we walk in and I walk directly over to the security guard and blow him away right to the head, right? Immediately. And she says in front of everybody, yeah, just like we planned. Okay. Okay, we did. It's not in the plan. The conspirators generally don't write out a manifesto where they say, this is going to be my role, and this is going to be your role, and this is what we're all going to do. But you can infer it from the circumstances, the way the crime was done, the other communications in the case, the other evidence in the case. Can you be open to that? Nodding of heads. Yes. Very good. Thank you. Does it matter how long it takes to make an arrest in a criminal case? You guys all heard the statement of the case. This crime occurred in 2014. Number 6, how old were you in 2014? 9. Can you even care about something that happened when you were 9? Can you, sir? Does it matter how long it's been?
I think as long as the crime that you're being charged for is within statute of limitations, I think it's fair to be arrested for a crime you could have committed. It takes years to build evidence and things like that.
Anybody feel like it's too long? I just can't consider evidence from 2014. I was 9. Everybody else, can you keep an open mind to evidence and a long investigation? So it is a circumstantial evidence case, and I do a cheesy analogy for circumstantial evidence because what's better, direct or circumstantial evidence? Direct. Everybody knows that, right? So powdered donuts. You have 2 kids. Who's got 2 kids? Well, your kids are too young to do this scenario, but let's imagine they're older. All right. So 2 kids, a bag of powdered donuts. They're not supposed to be eating the donuts before dinner, but you walk in, and one kid who happens to be the kid that really loves powdered donuts and asked you 20 minutes ago if you could have a powdered donut, to which you responded no, is covered in powdered donut dust. And the kid says to you, my brother did it. What type of evidence is that? The statement, my brother did it. No, it's not. That's direct evidence. Direct evidence. I was here. I saw him eat the powdered donut. Never mind that I'm covered in it, right? That's direct evidence. As opposed to circumstantial, which is, what are the circumstances? Circumstances are, this is a kid that loves powdered donuts. This is a kid that just asked me for a donut. This is a kid that's covered in a donut. All that's circumstantial, right? So in that case, which evidence is better? Okay, so can you keep an open mind to circumstantial evidence? It gets a bad rap, but I need you to be open to it. Can everybody nod? I can be open to that. Thank you. All right. Somebody say something? Okay, witnesses. Cooperating defendant testimony. What? I guess I just want you to agree to keep an open mind to it. this is a person who's been involved in the crime, and you absolutely should consider that character of that person and what motivations that person may have in play. You should consider that. But can you keep, that doesn't necessarily mean they're lying, right? They can also be telling the truth. Can you agree with that? Okay. Is there anybody that feels like I cannot keep an open mind to the possibility that a cooperating co-defendant might be telling the truth? What about you, number 6? Can you keep an open mind to that? Is it possible that a cooperating co-defendant could be telling the truth, maybe to try to get something for themselves, but could be telling the truth? 15? 14? 13, why does a cooperating co-defendant come forward?
Could be cover their own tracks.
Could be what?
Cover their own tracks.
To cover their own tracks. Yeah, to put it off on somebody else. Okay, good. What else? What else could motivate a cooperating co-defendant? 19? You're on ice, 19. I actually have a volunteer, number 6. They have a deal?
Please speak up.
They got a deal.
Yeah, they might be trying to get something to help themselves. Does that mean they're lying? No, it could mean that. But it could mean they're telling the truth to get something. Is that right? Do you agree with that, 19? Okay, can you keep an open mind to that type of testimony and weigh it with all the other evidence in the case? You're going to observe the witness. You're going to hear what they say. You're going to see if it fits with everything else. And you're going to make a decision about their credibility based on all that, including the fact that they have this motive or whatever. Can you do that? Everybody feel like they can do that? Okay. Unsavory witnesses. That's a very nice way of putting this topic. So there could be witnesses in the case that you all do not want to have a beer with or a cup of tea with. Okay. Can you keep an open mind to the testimony of someone who is different from you and lives your life differently from the way you live your life? Number 1, can you do that?
Yeah.
2, can you do that? Everybody? If you don't hear a particular type of evidence that you're expecting, can you keep an open mind to the type of whatever evidence that there is and render a verdict based on that? I just don't want you guys to walk in thinking, oh, there's no gun. Can't convict of a murder without a gun. Is there anybody that's like that? There's a particular thing that you require. Okay. Inconsistencies. Would you all expect the testimony to be completely consistent or there to be some inconsistencies? Let's say we're going to have a 2-week trial. You're going to hear from witnesses every day, all day for the period of 2 weeks. Are we going to have any inconsistencies? 17.
Purely a guess, but based on the duration, probably somewhere in.
Okay. Every single one of you went back in the room back there and answered the questions in private. And I was sitting back there, Ms. Dugan was sitting back there, and we were wearing the same outfits all day. If we isolated each one of you and asked you, what can you tell me about what Ms. Dugan was wearing yesterday or the day that you were back there? Let's assume it was all the same day. Do you think we could get some inconsistencies? Might get some blue, some black, dark pants. I think it was, we might get a lot of different answers, right? Does that mean that anyone's lying? Okay. Now, you all will have to weigh inconsistencies, which are going to occur naturally in a case like this. And you will decide, is this a point on which this inconsistency is important and equals a reasonable doubt versus this doesn't matter at all, right? Can you do that?
Thank you
All
for
right, so all crimes have
sharing.
elements. The judge will give you
Liking.
the elements of the crimes, and I will be responsible, and with Ms. Dugan's help, of proving each of the crimes were committed. And that means proving each of those elements beyond a reasonable doubt. Number 7, what does a killer look like? Yeah.
Please speak up, number 7.
The louder.
There's no default for what a killer would look like in just appearance.
No default. Really? They can look like anything?
Yes.
Who disagrees with that? Can a killer look like anything? Number 1?
Yeah. Anybody.
Anybody. Can it look like your grandmother? My young people? Number 5. Can a killer look like a granny?
I mean, it's all you in picture, but like anyone who's capable of like has the capacity.
You could keep an open mind to the possibility that a grandmother could be a killer. And that's kind of a tough one. And everyone keep an open mind to that possibility.
Yes.
For my folks that have been divorced, any custody battles? Raise your paddle if you've been involved in a custody battle. Okay, so just divorces. Anybody in a particularly messy divorce, ugly divorce, highly litigious divorce? Anybody go to court for their divorce? Did go to court, okay, but it was not particularly nasty.
She never showed up, so
Oh.
it was very.
You won.
Yeah.
Okay. Okay, so you guys haven't personally experienced this, but does everyone agree that those types of issues, domestic issues, divorces, custody battles, those are things that are highly emotionally charged? Yes. May I have a moment to confer, Your Honor?
Go ahead.
Okay, guys, so this is very interesting. We normally do not get to see this kind of interaction between the potential jurors and the process of selecting them. So this is way cool. I'm really enjoying this. I want to thank everybody for joining me today. That's why I have the thank you
For
up
my
there.
folks that have been on a jury before, what is a hung jury? Number 22?
The jury cannot reach a decision.
Because the jury has to be what? Unanimous. And that means it has to be the verdict of each juror as well as the jury as a whole. So, my shy guys, can you speak up and make sure this is your verdict? Not sure I've identified exactly who you are. I think number 6 is a little bit of a shy guy, and you already told me you could do it. Who else considers themselves a little shy? Nobody?
At first I am, but once you get to know me.
Okay. Are you going to return a verdict that's your verdict?
Yeah.
What if you get back there and everybody's against you?
Well, this is someone's life, so I don't really care about it.
Okay. I would encourage you to listen to your fellow jurors, and if you
Sure.
change your mind, great, because your mind's changed, and it's then your verdict. But I just want to make sure I've got folks that aren't going to be like, it's Friday night or whatever, Everybody promise to do that? All right. Anybody have something you feel like you need to tell me? I didn't ask the right question. I didn't call on you. Something you think I should know about you that's related to the topics we've touched on. All right. Thank you very much.
For the defense inquirers, we are going to take a brief break for about 10 minutes. You'll have an opportunity to stretch your legs, use the restroom, or look at your phones or devices.
Okay, so we have both people on break. So yay, everybody. Why don't we do this? Everybody get up before you do. Hello. I'm gonna pull that down. All right, guys, it's time to get up, stretch. Get up, move around, stretch, take a little 5-minute break. I'm going to go to the ladies' room. Be right back.
Can everyone here agree that 12 heads are better than one? Shake your head.
Yes.
Yes, okay. Now it's important right now for you to understand that. We're not trying to trick you. There are no right or wrong answers. We want to know what you believe. Now, during this process, would it be wrong of me if I were to ask you for your each individual own worldview? You know, we all have our own biases, resentments, beliefs. And I need to know, and I'm going to ask you to share with me, whether or not you're going to carry that with you into the jury box. Now, there's a concept that has gained momentum recently, and that is the concept of implicit bias. Does anyone here know what that is? No? Okay. Well, I'm going to try to explain it briefly. Now, we all want to see ourselves as fair. Can we agree to that? Yes? Okay. We all want to believe that we're rational. Can we agree to that? Now, unfortunately, studies have shown that despite our best intentions, none of us are free from these biases. Implicit bias refers to unconsciously held beliefs that don't necessarily reflect our conscious belief. So, for example, you walked into the courtroom either Tuesday or Wednesday, and you saw a gentleman in a black robe. When we see someone like that, we can assume that they're a judge. And you made that decision pretty quickly. Is that correct? Okay. So what if you were to walk into a supermarket and there's a big burly guy with a long beard, clad in leather, and he's walking to a motorcycle? Let's see. Number 5, when you see that, do you see someone who's adventurous?
Yeah, I mean, I guess they're riding a motorcycle.
How about dangerous?
Not necessarily.
Okay. Now, you're making a quick judgment when you see someone like that, right?
Yeah, that's an implicit bias, right? Like,
I'm sorry?
That's kind of almost an implicit bias, right?
Yes. Yes. Now, in that same token, you all walked in, whether it was yesterday, Tuesday, or today, and you look over at the defense table and you see my client, Mrs. Adelson, do you wonder to yourself, I wonder what she did? Number 2, you think to yourself, I wonder what she did, or I wonder what she is accused of doing?
I don't look that far into it. I mean, I don't know her from the next person, so I'll just treat her like another person.
Okay. What about number 9?
No, sir, I didn't have that question.
Well, which one did you ask yourself? I wonder what she did, or I wonder what she's accused of doing?
Neither.
Did anyone ask that question of themselves or say that to themselves? Number 23.
Yeah, I was wondering, what she is accused of.
Okay. I saw a paddle over here. Number 25. What did you think?
Yeah, like initially, I mean, it's just human nature to be curious. It's like, I wonder what this person was.
Now, do any of you have anxiety or are claustrophobic that if you're in lengthy deliberations that you might want to just leave the jury room? Anyone at all? Now, going back to implicit bias briefly, does everyone here agree, let's start on the first row, that you will make an effort to be conscious of implicit bias when you're considering the evidence in this case? Second row. Third row. Thank you. Now, when we were back in the jury room the last couple of days, some of you answered some of the questions. I think I might be able to, or I believe so. And you recall that we asked you to clarify that. First row. Okay. Why do you think we asked you that? Anyone?
Because sometimes, I'd say just about every day in our lives, we face bias, because we, have a perspective of what the world should be, and we can only deal with bias if we can consciously are aware of how we feel and what's going on around us.
Okay, we are now back. We are now back to the
Before we
Wolfenbarger.
adjourned for lunch, I had asked Mr. McDermott if you'd had a chance to discuss with your client the choice to testify or not testify, and if a decision had been made in that regard, so that I could go ahead and have a conversation with Mr. Wolfenbarger about that. And so you requested at the time to wait and let you have further conversations with your client during lunch. And so have you had a chance to have those conversations, Mr. McDermott?
Yes, ma'am.
Okay. So is now
And up.
acceptable to you for me to inquire with Mr. Wolfenbarger?
Yes.
Okay. Mr. Wolfenbarger, so I'll tell you like I tell witnesses. I'm fixing to ask you a series of questions, and when you answer, I'm going to need you to answer out loud so that the court reporter can take down your response. Do you understand, sir? Okay. So, Mr. Wolfenbarger, do you understand that you have a right to testify in this trial, and that if you want to testify, that nobody can prevent you from testifying? Okay. And do you understand that nobody can make you testify? That is, you have a right to not testify if you don't want to.
Yes, ma'am.
Okay. And do you understand, sir, that you, not your lawyers, are the person who makes the decision whether you will testify or not testify? And do you also understand, sir, that if you do not testify, then upon request by you or your counsel, that I will instruct the jury that your decision not to testify cannot be used against you in their deliberations? Okay. So you do understand that? Okay. And do you understand that if you choose to testify, you won't just get asked questions by your own lawyers, you will also be subject to cross-examination by the state's lawyers? Do you understand that, sir? Okay. Now, I don't want to know what you've discussed with your attorneys, but have you?
All right. I'm going to do it. Give me a split second. Before we all answer, I'm going to do this. I want to see what y'all give me real quick. Okay, take the poll. Yeah, I don't. This is a very relaxed courtroom, and I'm not for it. I'm all about formalities most of the time. Most of the time I'm about formalities. Okay, the vote. Y'all go vote. The poll is up. I'll give you a minute before we play this. We only have one vote. Come on, y'all, vote. Come on, you can do it. You can do it. Vote. Oh, come on, guys. I'm holding it for you. I am. I want y'all to vote. We're at 50-50. Who's going to break that 50-50 tie? Come on. Who's he going to break it? Who's going to break it? I'm waiting. Misa waiting. Okay, I'll go ahead and do it since nobody's biting. I thought y'all'd bite on that.
Had a chance to discuss with your attorney the
Hey,
decision,
Welcome
whether you
aboard.
will testify or not testify. Do you need any more time to talk to your lawyers about that decision? Okay. Having had an opportunity to talk with your attorneys about that decision, do you wish to testify in this case, or do you not wish to testify? You do not wish to testify. Is that correct? Okay. So thank you, Mr. Wolfenbarger. Based on your responses to my questions and your representations regarding having had ample time to discuss that issue with your attorneys, I find that Mr. Wolfenbarger has made a decision to not testify. That decision has been made with an understanding of his rights, and that decision is knowing, voluntary, and intelligent. The second issue I wanted to take up with y'all is, it might not matter.
Okay, I'm going to say this right. I kind of thought he may not, because I don't think the state has done a good enough job in proving their case. I think if he testified right now, it probably would hurt him more than help him. But a lot of people, though, are so headstrong about proving their innocence that they get on the stand. Rubber Ramada, where are you from? I don't think you've been in here before, or if you have, it's been a while. Welcome, welcome. Tell me where you're from.
At this late hour, but my understanding is that the sheriff's department has now acknowledged that warrant and said they are taking care of it. So I don't know what that means, but it is what it is.
That's what the deputy told me as well, and it's unclear how we can kind of monitor it, but I know in the past when I try to call the warrant division, they rarely.
Okay, so they have a person that they have subpoenaed to testify, did not show up in court yesterday, did not show up in court today. They do not want to testify. The judge has issued a warrant for their arrest to bring them into the court and force them to testify. Yes, the judge can do that. You do not ignore the order of a judge to come in and or subpoena to testify. That is a no bueno, and I'm interested and I'm anxious to see who this person is and why they don't want to come in.
Give me much information, but I take their word for it. They're working on it, and we'll either stay in touch with you or maybe the DA's office, and I can try calling the warrant division. I just know they're usually very reluctant to give information on the phone. So.
Okay, thank you. Now, the other thing I wanted to take up, I don't know how long it might take and where we are in terms of how much more time we might need with the jury today before we would be ready to for the case to be done. But we do still need to revisit the matter of the motions that the defense wanted to put on the record in terms of any motions at the close of the state's case. As we put on the record earlier, in an effort to be efficient with the jury, we went ahead and reserved your opportunity to raise those objections or those motions after we went ahead and proceeded with the state resting in front of the jury and then y'all going forward with some witnesses that you had.
Yes.
Okay.
At this time, in light of the state's having rested its case, we would move the court for a directed verdict of not guilty on both counts. On malice murder, the state has not proven any, it has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. They've not given any evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death. And they've not proved the cause of death. In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
The state has given some evidence from which, what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that. But when you're considering what a reasonable juror, well, I think your jury instructions covered as well, as far as what a reasonable juror would be allowed to consider as toward the elements of the crime. They cannot consider or infer character. They may not infer from those things that he had the character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, you know, he may have hit her on one other occasion, so he must have done it later. And therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling between the parties. So I would say there's an abundant lack of evidence in this case of intent and of the elements of the crime. And so we would request the court grant directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear from for the state?
Hey, Judge.
Mr. Fossett,
Yes.
your response?
Your Honor, I would cite two cases as a, then my computer goes. A second. Your Honor, I would cite two cases as authority for the court at the basis decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Appellate, 361, 2019 case. It ultimately speaks to the decision before the court when there is a conflict and when there is no conflict in the evidence that's been presented by the state. Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So first, the state is not.
Okay, they're arguing a motion right now. They're waiting. It's a typical motion. I mean, this is not a surprise motion. We are waiting for the hostile witness, for the lack of a better term, to show up via escort by a sheriff officer. So a sheriff deputy is bringing the person in. They're not there yet. So they're taking care of other housekeeping matters. And it is on the defense's side.
Required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of three different potential motives for this defendant to murder Melissa Wolfenbarger. First was the pending state court case from the July 1998 incident. There was a battery. And even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO, we know from the March 29th, 1999 date that that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case, the jury can consider that as possible motive. I think that the fact that this defendant was aware that Melissa Wolfenbarger was seeing an individual he referred to as Mike, we heard testimony from and confirmed and corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Wolfenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All three of those are independent, separate, possible motives for this jury to consider as reasons why this defendant would want to have Melissa Wolfenbarger murdered. There are prior difficulties, and those prior difficulties further corroborate the battery that occurred on July 1998. There are three instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Norma Patton describes seeing marks around the neck of Melissa Wolfenbarger. Vividly describes that. as does the officer Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person of Melissa Wolfenbarger. And then we have Thomas Dixon at the end of December 1998, which he's relaying information about the continual abuse that Melissa endured during that period, during that year. And also, again, how she planned on leaving him. I would say that from the testimony of the medical examiner's office, medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Wolfenbarger died of natural causes. That is from the circumstances of the facts that she reviewed, the fact that there were tool marks on the person, the bones of Melissa Wolfenbarger, on the neck, on the limbs, on the femur. The fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say, she couldn't say whether or not Melissa had been strangled because the parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death were just not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from Dr. Terry is that the circumstances lead her to no other conclusion, that it's highly likely that she died of homicidal violence. And I think that that in and of itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defendant's motion.
So I agree with you absolutely regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, which are issues for the jury. So I'm going to deny your motion on the count one for murder. I think for largely the same reasons, I should refrain from granting a directed verdict on the felony murder. But I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that any sort of weapon was used against her in any offensive manner. So how do I reconcile that?
Well, so it is not required for it to be a weapon. A per se weapon. So it's not required that the weapon be per se like a gun. Gun's per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of, for example, a jury could infer that from the circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death, whether that is poisoning. That would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her, the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be something that is man-made, like a gun, like a knife, like a belt or rope. And the point of the charging and the way the indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Wolfenbarger. That's why, because of the circumstances of this case, dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Well, I mean, not necessarily. The DA could have elected to just charge murder, because either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to allege it the way we did. That's if you chose to allege felony murder, right?
Right. Having made that decision to charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Wolfenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. The circumstances create really the only reasonable inference is that this was a homicide. And so I think
and don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide?
And I guess what I'm saying is it is impossible for her to have been murdered with an intentional act
without having also had an aggravated assault.
That is correct. That's correct. I don't see a scenario where that's possible. That's why I mentioned poison. Any object that would cause the death of Melissa Wolfenbarger with an intentional act would fit a category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says, if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me necessarily.
No, not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't have the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard, that you may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you, we have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category that they didn't charge. And this, I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about how it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner. And aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they've charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, can't be by poisoning. And they've not eliminated, by the way, that she died of a drug overdose in somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate. And that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr. McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia App 796.
Okay.
The other case is Wood v. State. It's a little older. 156 Georgia App 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case law, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment.
Understood.
Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one. He's just not going to be available except maybe by Zoom. Did we discuss that?
He did. He said he would.
And then the one we're trying to arrest.
Okay, so if I tell you that we're ready to resume for the afternoon and you have your one witness when they're done and you don't have another witness, are you ready to rest? What's going to happen then, sir?
I still want that other witness here. I'm going to ask for a continuance if she's not here.
Okay. Obviously, does the state anticipate that there will be some rebuttal just from a timing perspective?
Yes, Your Honor.
Okay, like how much? Like a whole day's worth or?
No, I would say at most an hour, hour and a half.
So we're still thinking, other than perhaps this witness and the request for a continuance to find that witness or deliver that witness here, we're still thinking that today we can get the evidence closed in this case. Is that still reasonable to you, subject to this witness?
Well, I mean, assuming my witness, yeah, subject to the availability of that witness.
Mhm.
If she were here, I would probably need an hour, maybe 45 minutes with her.
Okay. Okay. So anything else we need to take up before we bring the jury back in?
Nothing from the state, Your Honor.
Nothing from us currently.
Okay, we're ready for the jury.
Does it sound like crickets to you? Because that's the way it feels on my ears. It feels like it's a brrr, brrr. I mean, like a cricket, like how a cricket would feel in my ear. By the way, we are going to be having movie night tonight. Whoop, whoop, and we are going to be watching My Oxford Year. Come join us at 6:30 p.m. on our Discord in the movie channel, and we will bring your popcorn, get cozied up, and come join us. Well, I thought there was going to be some sound, but I guess not. I'm going to give them a minute and see what they're going to do, and then if they're going to be on break, we're going to send it back over to the Donna Adelson jury selection. I have a question for you guys. Since I'm having to move the studio home, for those of you who don't know, we are closing down this business, and I will be moving my office to my home office. And so this weekend, most likely, we're going to be moving the studio. That said, I don't have any ice at home. I don't have an ice maker. I have the little cube trays, but it's a pain in the butt. And I usually get ice at the restaurant next door, so no big deal. But I was wondering about those countertop ice makers. Did anybody have any good experiences? I have one here. It was a cheap one from Costco, and it died within a year. So I'm looking for a ice maker that's reasonable, because I don't drink water when it's not super
McDermott,
cold.
defense calls next witness. The defense.
Do you have any
calls.
suggestions?
That's okay.
There's one I want, but it's $300, and I'm like, nah, not. Throw the Amazon link in the comments. I'll go look at them.
Come on up, sir.
If you can throw the Amazon links in the comments, I'll go look at them. Thank you.
When you reach the witness stand, if you'll do me a favor before you sit down, turn around and face the deputy and raise your right hand. He'll swear you in.
This is the witness, I think, that the sheriff had to bring in. Look.
Your Honor, I think I need to get Mr. German to admit me to the Zoom.
Ms. German or Mr. Freehoff or Ms. Johnson, can somebody admit Mr. McDermott to the Zoom?
I think I'm with the state and you think I'm the defendant.
Yes, exactly.
Please teach the state and spell your name for the court, please.
Joseph Wolfenbarger. That's JOSEPH WOLFENBARGER.
And if you would, while you're testifying, if you'll just try to lean forward into that microphone to make sure that we can hear you. Okay, sir? Thank you. Go ahead, Mr.
Yeah, he
McDermott.
didn't want to be there.
Mr. Joey, do you know the defendant?
Yes,
How do you know him?
that's my father.
Okay. And do you know Melissa Wolfenbarger?
I've no ever.
Okay. And do you know Kathy Wolfenbarger?
Yes.
And how do you know her?
That's my grandmother.
And do you live with her?
Yes.
Okay. What do you do for a living?
Mechanic for the most part.
Okay. Did you grow up with Kathy Wolfenbarger in her household?
Yes.
Okay. Do you remember at any time growing up, say around the early 2000s, that she took all the pictures of Melissa Wolfenbarger down from your house?
I don't really recall ever seeing pictures of her like in the house.
Okay. Do you remember at some point in your life being told what happened to your mother?
Yes. More so at a young age.
And what were you told at a young age?
I mean, I would say I was at least about 4, 5, maybe.
And what were you told about
Your
her?
Honor, I
It
am
was-
going to object to that. That would be hearsay.
Yeah, don't know exactly.
Sorry, I apologize, sir. When there's an objection, I have to just wait and not answer the question. Can y'all come here for a second, please?
Sidebar. We got a sidebar. Welcome, Dina, to the family in Discord. Thank you so much for joining us. We're so glad to have you. Hopefully, we'll see you for the movie night tonight. You know, I have to say I'm getting pretty addicted to the movie nights on Discord. I love watching them with you guys. You can either sit there and be quiet and just watch, or you can join us in the chat. So that's up to you. No, he did not want to testify, and he's definitely there against his wishes. So let me zoom this up a little bit.
Sure. I'm going to attempt to get back in, if I may.
Sure.
It might help to have the current day, right?
That would help. There's a new one every day.
Thursday, August 21st.
Yes, sir.
All right, we'll see if
That was snippy. That was really snippy.
Okay, I'll repeat the question. Do you remember what you were told happened?
That somebody had killed her, and that it's only so much you can tell a small child, but it was more so that it was done in a very horrific way.
Did you at some point move in with your father?
I mean, yes.
And about how old were you when that happened?
It was after high school. It was.
Okay.
Yeah, I can't recall the exact dates, but.
Do you remember where you lived at the time?
Yeah, same place he was found.
Was it
in Griffin?
in Griffin? Okay. And did anyone else live with you at the time?
Yes.
And who were they?
My little brother, Alias, and it was mainly just us 3.
Did your sister live with you at any point?
No, that was before.
Did she come visit you at any point?
At what time are you referring?
This is afterwards.
Like,
okay, let me try a different line. Do you remember at some point the defendant making a comment while watching a TV show that he knew how to dispose of a body by burying it under concrete or something to that effect?
it wasn't necessarily from a TV show. It was more so we were discussing about how Carl had gotten away with other murders, and we were talking about different scenarios. And my sister had walked in later on, kind of caught half of the conversation, and kind of been standoffish about the conversation.
Okay, so a couple questions just to clarify. The context of the discussion was Carl Patton's murder.
Right.
Okay, and at some point, Chrissy walked into the room and overheard the conversation.
Yes.
Okay. Your Honor, I'd like to share screen, please.
Hey, Are you in?
I am in now. And what I want to share, as previously discussed, self-authenticating document is a nationally reported news article. I emailed it to you as you requested.
Y'all come in.
All right.
Just a moment. Thank you.
All right, the jury.
You can sit there. Yes. You just stay right there.
So now we're coming in for the jury.
Outside for just a moment, please. Thank you. But don't wander far, okay?
Okay, so we now have technical difficulty, so we'll go over to this trial until they come back.
Thank you. Does everyone agree with that response? I need verbal.
Yes.
Thank you. So if a witness were to say, I think I saw this, is that the same as them saying, I saw this?
No.
Another important point, and I'm going to go to number 6. If you are selected as a juror and you hear the evidence and testimony, you go back into the jury room, are you able to say to another juror, well, that witness didn't say that they saw it. They said that they thought that they saw it.
Yeah.
Or they didn't tell you what somebody said, but what they.
All right, we're back.
To evidence. I think he can ask if he knows. He can ask what his personal knowledge is of articles on the. But to put that article on there and that somehow give it a self-authenticating extra level of authenticity, so to speak, that's improper, Your Honor. I mean, because that's what they're doing. They're bolstering. They're trying to bolster testimony by using a news article, which is not really how it should be done.
I also, so at the time I did review the article, and I looked at some case law. And the concern I have here is that there are ways to ask Joseph Wolfenbarger, were you aware that your mother had been found? Did you become aware that your mother had been found in a bag sometime before 2021 or whatever? There are ways to establish that. There are even ways to establish that news articles that were widely available existed. But The only purpose, in fact, I mean, the only purpose to offer a news story like this, the only reason that it's self-authenticating is because the idea is that the facts in there are true and can be relied upon because they are in, widely available, reputable publication. And what I need to pull up the case law that I was looking at because that was like a week and a half ago. I was looking at it like a week and a half ago, but ultimately my concern is that this is going to confuse things because it is a long article with lots of detail, some of which may or may not be in front of the jury. And I would be worried about confusing the jury when really what I understand you to be talking about is what you're trying to establish is that the fact that Melissa was dismembered and found in bags was publicly available knowledge prior to 2021. And there are other ways to do that without injecting all of this narrative information that's been wrapped up in a pretty package by Dateline NBC.
Okay. A couple of things. I just want to backtrack to what you said about self-authenticating and the purpose of it being that the facts in there are true. That's not an authentication question.
I understand it's not an authentication question.
The self-authenticating just goes to, is the source what it claims to be?
I understand, but
we're not entering any true facts. Now, as far as the whole article coming in, I began this discussion several days ago with Mr. Fawcett. I shared with him the link and I said, I don't want to put the whole article in. I just want to have a screenshot of the one paragraph that says the body bags. And of course, this discussion is drug in the course of trial, you know how things go. I haven't gotten a ruling back and all that stuff. So my intention is not to put all these facts before the jury. It's just that one, and that's why along with the link, I sent a screenshot of just the beginning of the article that has nothing more than introductory material and one paragraph that mentions the bags. That screenshot also has the date on there, so I can ask him what date was this published.
Well, that's exactly why it shouldn't be let in, because he's using that to supplement questions that can be asked of this witness.
I'm sorry, say that again, Mr. Wilson?
Well, he's using the date, for example, the date of the article. He can certainly, as the court has already said, he can ask questions. Are you aware of these articles? Are you aware of these things? Rather than putting in an article itself.
So if I understood your honor, that you would have a problem with confusing the jury, I think providing just a short screenshot of only the relevant information solves the 403 problem.
I'm sorry, I am trying to find my prior research, and for some reason, the Westlaw is not cooperating with me, so just give me a moment. Okay. Now I found it. So I want to take a look at that. Mr. McDermott, what were you saying, sir? I was trying to look at Westlaw and pull up my prior research.
My apologies for interrupting. I was just appending on to what we had discussed, that you had discussed the problem of confusing the jury with facts that may not be in evidence. And I think providing only the screenshot with the one paragraph and the relevant information solves that 403 problem, so there's no confusion.
Well, I mean, the screenshot that you've provided says that Mr. Wolfenbarger was arrested on August the 7th. It says he's currently in custody. It says, it tells a story about Christina when she was 3 years old, that I don't recall her testifying to. I mean, I'm looking at the screenshot that you attached to your email.
Yeah, I'm a little, don't remember those being on there. Can I approach, Your Honor?
Well, I'm going to share my screen so you can see what I'm talking about. So this
May
is,
have gotten an earlier version of the screenshot.
okay, well, the email that you sent me at the end of our pretrial conference on
Oh, that's right, the update.
last Monday,
Yeah,
that's the screenshot that you sent me, and it has lots of information that is not in evidence and or inadmissible.
that is true. Could I just redact that and leave what's below?
So again, I don't understand why you need this news article to establish the fact you're trying to establish, which is that at least as of May of, does that say 2001?
Yes,
Okay.
2021.
2021, because
And so the point I keep trying to make is that this was published 3 days literally before they went down and interviewed him on this point.
I understand that, but also couldn't you have established that with Calhoun or Shepard?
I didn't interview Shepard and, yeah, it could have been.
I just mean, there are other witnesses in the case who could, okay. Here's the, yes, sir.
I don't want to hold up the court any
Okay.
further. If you want to rule against it,
Okay.
so be it, and we'll move forward. But it's authentic.
No question it's
It's,
authentic, but it still has to be relevant and non-prejudicial and
It is
not,
relevant, but it's prejudicial. I understand that.
and not hearsay or subject to an exception. And just because it can be authenticated doesn't make it not hearsay. And what I'm primarily concerned about is that it has minimal relevance for the concern. I think that the prejudicial nature of the facts that are contained in here, which are either not in evidence or would be subject to some sort of limit. I mean, like I said, I related the stuff that was there, but even if you were to limit further what it shows, what I think I understand is that the purpose of this article is simply to demonstrate that in 3 days before the police talked to Mr. Wolfenbarger in 2021, there was a news article that said that she was found in bags. And there are other better ways that are less inflammatory and prejudicial than this narrative that's been put together and made all shiny and pretty by Dateline NBC. Okay. Anything else that we need to, and just to be clear, I understand I didn't give you a ruling, but I need y'all to let me know again when you need a ruling, right? Like that was 2 weeks ago. So, or, so.
In all fairness, I definitely tried to make that happen.
Well, I mean, you sent me an email, I understand that, but I've asked any number of times what other matters the parties need me to take up, and at no point did somebody say, oh yeah, there's this news article I want to ask Joey Wolfenbarger about, and you haven't ruled on that, Judge. Nor, in fairness, did the state say, hey, Mr. McDermott wants to offer this news article that we object to. Nobody brought that to my attention, so I apologize that we had to do it on the fly with the jury stepping out, but there's a reason I ask 87 times, is there anything else that y'all want me to address before we do whatever we're doing?
Understood.
Okay, thank you. So are we ready for the jury to come back? Mr. Wilson?
Yes.
Mr. McDermott?
Let me ask one more question.
Yes.
I don't have any other questions for this witness except one. I was going to take a previously admitted exhibit, the weather reports, and see if he would be able to read that for the jury. It's perfectly common sense. Any average person should be able to do it. And the detective, it's to impeach the detective who sat there in Hamden Hall and made a big deal about it.
Isn't that document and evidence?
Yes.
So the jury can see it.
Right.
Can they not?
Yeah.
And if it's common sense, won't they be able to figure that out?
So you say no do it.
I mean, I just don't know any, I mean, other than that if it's common sense, your average person should be able to read it. But if I recall correctly, the detective struggled a little bit to read it too. And so I'm not sure I understand why Mr. Wolfenbarger, hang on. I'm not quite sure I understand why Mr. Wolfenbarger would be able to understand it and relate that either. Joey Wolfenbarger.
I think that's the point. I think the detective was being dishonest. And I think if an average Joe mechanic can read it, it would impeach the detective's credibility.
Mr. Wilson, that noise you just made is not an objection.
I understand, Your Honor. Your Honor, I do object to that. I don't think, I think it's been put into evidence, it's already been questioned about, and I think it's been, to have a witness read it when the jury can read it is cumulative, repetitive, and argumentative, Your Honor. So I think, and it's not I don't think it would be appropriate for him to do it with his witness in front. I mean, obviously the person he did cross, Detective Callan.
Okay. I feel like you've made, that document's in evidence and you can argue that to the jury and you don't need to inquire with Mr. Wolfenbarger about it, Mr. McDermott.
Fair enough. So bring it back
Anything
in
else?
here. I will say no more questions.
Okay. Could you get Mr. Joseph Wolfenbarger back for me, sir? Thank you. Deputy, we're ready for the jury again. Obviously, once we get Mr. Wolfenbarger back on the stand.
So you had
Thank you, sir. Sorry for that delay. Come on back. And you can just come on back and have a seat on the witness stand.
you had a sheriff deputy, excuse me, go and pick this guy up for this testimony. I thought there was going to be something really good. It was going to be a banging testimony. I don't hear anything yet.
And deputy, now we're ready for the jury.
I don't know. Haven't heard anything in this. I gotta be honest. I think it might be a hung jury. I do. Oh, I'm looking at the video and look at the video in here. All the different angles.
Thank you all. Please be seated. Mr. McDermott, you may resume your examination.
Thank you, Your Honor. No further questions for this witness.
Thank you, sir. Mr. Wilson, questions for this witness?
Yes, thank you, Your Honor.
That's horrible.
Now, you were born on July 5th of 1996, isn't that right?
Yes, that's right.
So you would have been about 2.5 when your mother went missing, correct?
That sounds about right.
And you have no personal memory of that, correct?
Not of her, no.
So you have no memory at all of your mother?
Whole posted.
No, like not like a living version of her. No, there's little bits here and there I can remember, like of the ceremony, but that was it really. I didn't really understand, who she was,
Yeah, because you were only 2.5 when it happened.
Right. But it was later on when the ceremony and whatnot.
Now you lived with your mother. Well, excuse me. You never lived with your mother.
No, not really. No.
Yes, you lived with Kathy Wolfenbarger, your grandma.
Right.
She wanted you to call her mom.
Not exactly. It was just more so it was easier that way.
So you did call her mom.
Yes.
Okay. And you never saw pictures of your mom at all while you were growing up?
I seen some, but they wasn't like displayed all over. There was, the rare occasion that we would go through photo albums or whatnot, but that's the only real time that I've seen them early on.
And those photo albums were located in the house, correct?
Yes.
Okay. And you were 4 when you were told that your mom had been murdered?
I would say that's about right. 4 or 5, somewhere around there.
And you were told by Kathy Wolfenbarger, correct?
Not Not really. I mean, it was more so of Rachel. Like she got more into detail with it.
Okay.
But I mean,
And so you heard a bunch of details
yes,
when you were 4.
yes.
And did you never asked your dad about what happened, correct?
I mean, it'd always been a touchy subject for, talk about with anybody, it's not really,
Okay. So you really never had conversations about your mom's death with your dad, haven't you?
I mean, bits and pieces,
But nothing extensive.
right,
And that over the years?
right.
Okay. And after high school, you moved in with your dad,
Yes,
and you haven't had conversations with him about it, only bits and pieces, correct?
correct.
And you were still living with him. You're still living at that address?
I mean, not at the moment, but, I was off and on for a while, shared 2 residents.
Who was the other residence was Kathy Wolfenbarger?
Yes.
May I just have a moment?
Sure.
Right now, you live with Kathy?
Yes.
Okay. And who is Rachel?
That was the woman he got with after my mom.
Okay. So you've talked about it with your dad's girl, kind of living.
Right. They were living together and they moved in across the street.
Okay.
Yeah.
One more moment.
Sure.
Thank you.
What year were you born again?
96.
96. So when Melissa's remains, or when you went to the ceremony, you mentioned the ceremony a while ago, and you said you had just faint memories from the ceremony. And that would have been in 2003, correct?
Yes.
And so you would have been about 6 or 7 at that point. What have you been 6?
Yeah, give or take, yes, about 6.
So you wouldn't have heard anything about your mother's, how she went missing until after that point, correct?
Yes.
Okay. And is your memory still fuzzy from all that stuff?
Right, right.
Okay.
Like I can remember like bits and pieces, like kind of where we were standing or whatnot, but just.
And so is it safe to say that the discussions you had with Rachel would have come after that point?
Right.
Okay. No further questions.
Thank you. Anything else, Mr. Wilson?
Just very briefly.
Sure.
Now you have a full sister, correct?
Can you?
You have a full sister. You have a sister.
Yes.
And what's your age difference
10 months.
between you and Chrissy?
Yes. 10 months.
Okay. Nothing further.
Mr. McDermott?
I'm nothing further. You may be
Okay.
excused.
Thank you, sir. You can step
Thank
down
you.
and you are excused as a witness. Mr. McDermott, defense may call its next witness.
So may we approach, Your Honor?
Yes.
This is a nothing burger to me. Absolute nothing burger. I don't understand. We'll see. Y'all don't forget, we are going to be having our movie night. Dun, 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 dun. We watched a movie together last night. It was kind of a last minute thing. But we watched What did we watch? Oh my gosh. I can't believe I can't remember what we watched. Oh, Mrs. Doubtfire. Mrs. Doubtfire.
Simpsons
It was
today.
so
Thank you very
awesome.
much.
Yeah, I got it just as you did it. Yeah, I don't understand why they called this guy. I don't know why they called him either. I'm perplexed. I thought he was going to have the scoop or something was going to be, seriously amazing, and it's nothing.
Thank you. You may be seated. The jury's clear. Deputy, can you do me a favor and check on the status of efforts to locate that witness or bring that witness
Oh,
here,
that
because
he's not that
that's
witness.
the next witness they want.
Oh, so that was not. Oh, I'm sorry. I'm getting loud. I'm sorry. So that was a regular scheduled witness that showed up. The witness that hasn't showed up and had to be gotten by the deputy sheriff is not there yet. Oh, spicy might be coming. I think you're right, Angela. I think you're right. I'm hoping. Witness on the run. Witness on the run. We got a witness on the run. Run, 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 run. Witness on the run. I'm deliriously tired. Deliriously tired. In the last 3 nights, I've gotten right about less than 10 hours, actually. Less than 10 hours in the last 3 nights. So tonight's going to be a crash night after the movie. I'm going to stay up to a specific time, and then I'm going to go to bed. I'm going to kick everybody out of my life, my womb, everybody out of everything. I'm going to go on the run, 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 run. I am. I'm running to my bed. I kid you not. I'm going to run and get in my bed, and I is going to call it a night. I've got clean sheets I put on my bed. I got my clean sheets. And I put them on my bed, and I'm happy for it. Yeah, probably nothing burger too. I know. I know. I know. I didn't mean to pause it. My bad. Must have hit the computer.
Okay. I'm gonna, because it's time sensitive, is it okay? I'm gonna ask that we leave that deputy here and you go take care of that while I take up some other matters with these individuals. So if he goes, then I can't take up these other matters with these lawyers because he's not here.
Yes, Your
Honor. Miss German, can you get another deputy in here? Because if you leave, then I
see my problem.
Thank you.
Your Honor,
Yes, sir.
I'm curious about the rebuttal. I just want to make sure the rebuttal rebuts something that occurred today because we didn't have a case yesterday. So the rebuttal has to be something in response to something that happened today.
Obviously.
And I'm curious. I don't think they have to pre-clear it, but I guess I'm preemptively filing a motion that they don't get to just start putting up new witnesses or dealing with issues that came up yesterday or last week, or it has to be rebuttal of today because we didn't have a case before.
I think we all know that that's what rebuttal's supposed to be.
It is.
Okay.
Wow,
What
snarky. I love it.
of our other witness? They're not here yet. Mr. McDermott or Mr. Samuel, can one of you tell me who that witness is? Because I'm having the deputy check now by some miracle.
Someone is coming to believe me.
Thank you, sir. By some miracle, maybe he goes upstairs and finds out that that person is already in a sheriff's car and is on the way here from wherever it was that I saw that they were from, which was, yeah, far away. No, I thought it was out the west side toward Alabama.
Wow.
It's Covington? Okay, so east side. Okay. But that's far. In any event, so let's say by some miracle that person is somehow going to be produced here today. But it's very likely that that person is not going to be produced here in any reasonable time to be testifying today. And so my understanding from you, Mr. McDermott, is that it would be that y'all would be moving for a continuance. Is that correct?
Yes, Your Honor.
Tell me who this witness is and why you believe that a continuance would be justified to allow that witness to testify.
So one of the undercurrents in this trial has been the relationship between Melissa and Christopher's family, Melissa and her family. A huge part of that is this custody battle, and I think the jury's going to have to decide at some point. One side was pressuring her to do this, and one side she wanted to be with, or maybe there's some other complex dynamics. In my opening statement, I gave basically said that the evidence is going to show that there's strong evidence of a very poor relationship between Melissa and her mother at the early stages of her life that ended up leading to her running away. Okay. The state has been able to counter that by presenting these evidence of these cards and the letter, et cetera, et cetera. But I have relied upon this witness to provide the evidence I need to sustain what I told the jury was going to show. And I think it's a relatively important piece of evidence to show that she did have a poor relationship with her mother. And so this witness was a next door neighbor to the Wolfenbarger, or to the Pattons.
To the Pattons.
At sometime in the 80s up until maybe the early 90s. She was best friends with Melissa. She is going to testify that all the things I said in my opening, including some that are arguably worse, that they were locked in their rooms, they were not allowed to leave to get water. Melissa was not happy. Melissa began running away with her. Eventually, on at least one occasion, did drugs with her and got into some other things. And she's going to testify that the locking in the rooms specifically went on from about age 7 until about age 12, every day that she came over there, all day. And there's a considerable amount more of backstory to that. So, and then at some point after the finding of the baby, Melissa started running away.
Well, that's in evidence. I mean, that part very clearly is in evidence. I've heard people discuss it multiple times, and not just through lawyer questions.
I don't need her to establish that point, but it does establish it in the context of the timeline of what she calls Melissa's neglect and abuse. She will also testify that there were times that at some point her mother would not allow her to have makeup. She had to use colored pencils on her eyes. She's going to testify that her mother would not give her feminine hygiene products, that she had to use socks for pads.
Oh my gosh.
I think those are all relevant as far as
Oh my gosh.
and the feeling
Ew.
Melissa would have had to her mother.
I'm sorry.
I cannot.
I can't
fulfill
unthink
what I
that.
said in an opening statement without this witness. And so I think for that reason alone, not to mention the extremity of what she's going to testify to.
Wow.
I think it warrants a continuance if we need to have it.
Do we have any information about why she's not here?
I do. So when I initially contacted her probably 2 weeks ago, I was actually shocked that I finally got through to her, and she was effusive to me. She was like, I want to tell my side of the story. I want to tell this. She's very clear. She's not a fan of Chris, and she's not on his side in this trial. But that she said, I will show up and tell the truth. I said, well, would you testify? She said, for him, no, but I will tell the truth. And I said, if I subpoena you, will you come? She said, yes. And she, on a couple of occasions, kind of went silent as I was trying to communicate to her what days to be here. But she came back a couple evenings ago and told me that because so I think it was her stepson died at the beginning of July. She's been dealing with depression and things like that. And that she just needed to spend a day or two in bed. But she texted with me. She sent me a bunch of pictures of Melissa and them growing up. She was very open about it. I shared with her that, if cost is a problem, we're allowed to reimburse you for certain things, travel, whatnot. And she said, okay, fine. And it was clear to me at that point she was going to come. And then yesterday, she didn't come. And then I contacted her last night, and she gave me a hard, trying not to use the word she used, but it was basically
Not just no, but
I think I think she's realized that what she has to testify to will help Chris in some way, and so she's refusing to come. And I did not tell her I was going to send a deputy because I don't want her to run and hide somewhere. And that's the long and short of it. So the short story is that it was not until the day, or I think it was early this morning, that I got text from her saying I'm absolutely not coming, and variations of that.
Okay. So realistically speaking, though, I mean, let's play this out logically. Are we confident that even if a deputy did go to her house and force her to come here, that she would willingly testify?
Wait, what if the deputies already got her? They're on their way from Alabama.
I mean,
I fully expect she's going to be resistant, and I would ask for to treat her as an adverse witness.
Hostile witness. This will be if he gets to do this and treats her truly as a hostile witness. In the little over a year that I have been doing this, by about a year and a month, we've never seen a true hostile witness. That will be freaking awesome.
I have our conversation recorded, and I've made a transcript of it. So I'm prepared.
Well, if she's refused to, well, she wasn't. I mean, she isn't available if she's refusing. But anyway, what are your thoughts, Ms. Hilton, or somebody from the state?
I'll just add, if the state will waive cross, we'll be happy playing portions of the audio.
That won't happen.
She said that won't happen.
Your Honor, we don't necessarily object to a continuance if this witness is under subpoena and can get here. So we're not opposed to the continuance, Your Honor. We would ask if we can have a copy. At this juncture, can we have a copy of the recording and the transcripts of this witness's interview so that we can prepare? So that's
It was sent 2 days ago, Your Honor. They have the email.
Obviously not if she's asking
You mean
for
you
it.
emailed them the audio file?
Yes.
Thank you. Okay, so one other question that I had asked counsel at the bench, I mean, it's less than ideal, but if there is a chance, which I'm going to wait and see what I can hear from the state, from the sheriff's office about any progress that's been made to locate this person and go get her. But if there is rebuttal, is it possible we could just go ahead with rebuttal and come back to this witness if we could get her here later today?
I would not prefer that because I don't know what she's going to say, and my rebuttal witnesses may need to address what she's going to say. And so I wouldn't want to start any of my witnesses.
In fairness, Mr. Wolfenbarger did pretty much tell you what he was going to. I mean, it sounds as if the only knowledge that she could have if she knew Melissa when she was a kid is Melissa didn't get along with her parents and some specific facts about it.
But we never know what's actually going to come out on the stand. So we understand the recording, we understand what his proffer is, but I don't know what she's actually going to say, what's actually going to come before this jury. And so the state would prefer to have the defense finish their case, and then the state moves forward with rebuttal at the conclusion of their case.
Okay. Yes, Mr. McDermott.
Yes, Your Honor. Your patience is unlimited and admirable. And there's no reason they couldn't go ahead with the rebuttal witness. And if our witness is here or not, we can still hold her over to the next day. I mean, I'm saying we can still do the rebuttal if they want to.
Yeah, I think I know everything I need to know except for what effort, if any, has actually been made to go and find that person. So at this point, we're just going to have to let the jury cool their heels for a minute until I step off the bench so that Deputy Holt can go check, because for some reason there's not two departments that do that, right? Poor Miss Deputy Holt is stuck doing it himself, even though he's also got to be in here doing this part of the job. So in any event, I'm going to take a break for a moment so the Deputy Holt can step out and see what the answer is about this witness. And then I will come back and we will figure out what to do. I will tell you that I don't love the idea of a continuance, but if there's some reason to believe that she can be gone and gotten, and all I need to do is delay until perhaps in the morning, that's not unreasonable. But this case is going to the jury tomorrow. I mean, I just don't see a universe in which we can justify for what sounds to me like relatively narrow topic of inquiry for a witness, delay.
Especially after the example we just got from the last witness. Why were you even here? What was the reason other than maybe you want to see your daddy? Other than that, there was no reason for him to be there.
This jury beyond having the case tomorrow. But I might consider a continuance tomorrow if there's some reason to believe that she might be gotten and delivered here and cooperative. So anyway, I'm going to step off. It's 3:00. I'll come back in maybe 10 minutes when hopefully Deputy Holt has some information for me. Thank you.
I like the way she said being gotten. All right, here we go.
I think they overheard. You can point that out.
Mr. William.
Number 12. Could you do that as well?
That's my duty. That's why I'm here.
I'm sorry.
That's my duty. That's why I'm here.
Number 11.
Good.
Number 16. Yes?
Yes.
Number 17.
Yes.
Ms. Kappelman covered the leader, so some of what I was going to cover has already been addressed, so I'm not going to repeat it, and certainly not here to waste your time. Number 23, would you say that you're naturally skeptical?
Yes.
Okay, when I ask that, what do you think that I mean?
Like, today's going to be a great day. And sometimes you're like,
Today's gonna be a good day. Sorry.
yeah, there's something can go wrong. You better not, put all your eggs in one basket, so to say, and think everything's going to be great. You have to be open and know things can go wrong.
Do you question when somebody says something to you? Would you question whether or not they're being honest?
Yes.
How do you determine whether or not they're being honest with you?
The normal things, look a person in the eye, if they're fidgeting in their seat or, not able to stay still or, they have conflicting statements or whatever.
Let's see. Number 19. Would you agree with that? Are you skeptical? Are you naturally skeptical?
Depends on the situation.
Give us an example.
Oh, well, like he said, if it's going to be a great day, I have to keep an open mind because I have no idea if it's going to be a great day or not.
You trailed off at the end.
I have no idea if it's going to be a great day or not.
Are you hopeful?
Not really.
Today might be a bad example. Now, you previously served on a jury. You said it was in California?
Correct.
Things are a little bit different out there?
A little bit, yeah.
In trials, I mean.
Well, the way you guys did this time is different. I'm assuming it's because it's sensitive information. So.
You said that you didn't want to have to do it again. Is that accurate?
Yeah.
But it wasn't a bad experience?
No, I was not. I don't know. It was different than I was thinking, but it wasn't like horrible.
She don't want to do this, but she doesn't want to say no because she don't want to get in trouble by the judge.
Number 13.
I mean, get embarrassed.
How do you avoid misunderstandings with people?
Through conversation.
Can you give us some techniques?
Primarily through asking questions to not only hear what they're saying, but then to get at what they're intending to communicate as well, both verbally and then non-verbally.
So it's important to listen.
Yes.
Number 14. Do you agree? Any other examples of how to avoid misunderstandings? Anyone at all? I'm going to call it yes, number 16.
Being aware of what you've actually been told versus what assumptions you're making.
I couldn't hear you.
Being
Sorry.
aware of what information you've actually received versus what assumptions you've made.
Okay, so avoiding assumptions. Okay. Number 12, I saw your.
Oh, I was just gonna say that it's good to confirm your understanding of what someone has said, if that's possible.
So in other words, repeating back what somebody has said to you to confirm that you understood it the way they intended.
Exactly.
Number 23. I'm sorry, number 11.
Yes, sir.
When you were falsely arrested, how did you feel about the criminal justice system?
I was a bit irritated with it at the time.
Okay. How long did it take to correct?
About 3 weeks in total. I was bailed out immediately, so I only spent about 8 hours in a holding cell, but about 3 weeks of back and forth before I was fully cleared.
It's actually pretty quickly.
I thought so, but I was rather persistent.
Number 23, you agreed that that was a pretty quick turnaround?
Oh, yes.
Amen, sister. Preach it.
By a show of hands, does anyone think that the state could make a mistake? Yes. What about law enforcement? What about the state's theory of a case? Does anyone think that the state can be wrong in their theory of what happened?
Yes.
Did anyone not raise their hand? 23?
Oh, no.
Oh,
I raised my
okay.
hand.
Just making sure. Now, does anyone know people who keep large amounts of cash on hand? That's number 26. Do they have a distrust of the banking system?
Yes.
Now, I know at least my generation, my grandparents and my great-grandparents certainly had a distrust of the banking system. The Great Depression, people lost everything, right? I think we're starting to get into a point where I might not be able to relate with some people. Number 6, do you think that it would be inappropriate or illegal for someone to keep large amounts of cash? Number 24. Have you ever made or received a personal call while you were around other people? What did you do so that those individuals didn't hear your conversation?
Usually ask to be excused.
You walk away?
Mm-hmm.
That's a yes?
Yes.
What if you couldn't walk away? How do you convey what you're trying to convey?
Then I usually ask if I can call back to the person.
So you would either try to walk away or you would continue the conversation at another time.
Right.
What if neither one of those were options? Would you
well,
be vague?
Yeah, because if I'm trying to get, especially if I'm working, a lot of times I couldn't take a phone call, so I wouldn't answer it. So
What if the person that you're with is the one who gets the call or makes the call? How do you know what's discussed?
You can, a lot of times hear what they're talking about.
Well, what if you can't hear? They walk out, and you can't hear. Do you know what's discussed?
No,
Now, if the person comes back and tells you what was discussed, do you know whether or not that was true?
no.
By a show of hands, has anyone ever said something that they regretted? Thank you. I know that nobody, and correct me if I'm wrong, but nobody here has ever worked in law enforcement, correct? Okay. Has anyone received any courses or done any type of law enforcement training? Even those that were in the military. Number 13.
Yes, somewhat.
Can you tell us?
Sidebar. It would have to be a sidebar.
Okay.
Due to the nature.
Understood. Anyone else? What about private security, private investigation? Anyone? Does anyone here like to travel? Got a few that don't. You don't like to travel? Number 9?
No, sir.
Okay. For those of us who like to travel, let me pick on somebody. Who raised their hand? Number 25. Is it generally less expensive to stay in an Airbnb or a hotel for a lengthy trip?
I guess it depends on the area, but I guess recently Airbnbs kind of seem to be cheaper.
Now, there were a few people, and I didn't see the hands that have been involved in a divorce. Actually, number 11, you've been divorced?
Divorced?
Yes.
Yes, sir.
Okay. Did you have young children at the time?
I did.
But was it amicable?
It was.
Anyone not have an amicable divorce who's been divorced? Okay. Did you say things about your ex or soon to be ex that you didn't really believe?
No.
I'm sorry?
No, it was pretty cordial.
Oh, it's pretty cordial. Okay.
For me on my side.
Oh, on your side.
I was pretty nice.
What about the other side?
Yeah, so
Not quite as much?
I would not.
Do you know how she spoke about you during the divorce?
Yeah.
Was it nice?
No.
And that saying
Probably
note,
not.
by a show of hands, has anyone ever spoken poorly or said mean things about somebody else?
Who hasn't?
Pretty much everyone. Does that mean that you hated the person? Anyone? The fact that there are no paddles up tells me that doesn't mean they hated them.
I think it means we're just mad at the time.
Thank you. By a show of hands or paddles, has anyone jumped to a conclusion before? You hesitated.
Well, I don't like to admit, but I suppose I have.
We're human. We tend to do that. It's not just analytics. We also have emotions that come into play. And that's how we interpret things, right? Now, for all of us who have jumped to conclusions, was our initial conclusion always correct? No. By a show of hands, has anyone had a knee-jerk reaction? Said something in that moment? Pretty much everybody? Okay. Number 7. Did you later realize that you misinterpreted what was said?
There have been times.
You're human. By a show of hands, has anyone ever planned a party?
Sidebar. Please text me the link. I can see if I can get it through the phone. It's not working on my computer right now. Okay, so we have no,
Depends on how to weigh the evidence when we reach that point. You may continue.
Thank you. Now, presumption of innocence, we touched on it briefly. It's important. You must presume or believe the defendant is innocent. As we sit here today, you've heard no evidence. Mrs. Adelson is innocent. The presumption stays with her as to each material allegation in the indictment, unless it's overcome by evidence. So by things that you're going to get up there, beyond the exclusion of every reasonable doubt. Does everyone agree with that legal concept? Shaking the heads, yes, thank you. It's the state's burden to prove that. So a few moments ago, I asked if anyone could define reasonable doubt. It's there's a definition. The judge is going to give it to you. We'll probably go over it throughout different points in the trial. But I find it easier to use some examples. Because presuming someone is innocent is not how our mind usually works. So let's see. Number 5. Let's say this morning on your way in, you're pulling to the parking garage and you see a motorcycle cop pulling somebody over. What do you think? What do you think happened?
You presume they broke some type of traffic law or something.
You don't think to yourself, I wonder why that cop pulled that innocent person over, do you? Did anyone think that? Thank you. You probably thought, glad it wasn't me. That guy was speeding. That's the way our minds normally work. You see someone get pulled over, you're like, oh, they ran a red light, they were speeding. And as I said earlier, you may have done that when you walked into the courtroom this morning. Now, just because you think that way doesn't mean you're not qualified to serve on the jury. But it does mean that we can't have that kind of thinking interfere with part of your deliberative process. Does anyone here think that because law enforcement arrested Mrs. Adelson and the state has decided to charge her, and that we've got all the way here to trial, does that make you think that she is guilty in any way? And I'm going to start with number 22. Does that make you think that she's guilty in any way?
In a way.
In a way?
In a way. Because why the state wastes a lot of resources, time, and money to convict someone that might not be guilty.
Does anyone agree with number 22? Anyone else?
To an extent.
I'm sorry?
To an extent.
To an extent? What do you mean?
It wouldn't, in my mind, make sense for the state to spend, I'm assuming at this point, maybe 10, 11 years going after a person that they didn't believe was guilty, or that they had no reason to go after a person for that long.
Thank you for your honesty. Does anyone else agree with that perspective?
I don't think that it necessarily makes her guilty verdict, but I do think that to make it to trial at this point, there has to, at some point in our legal system, been enough substantial evidence or witness testimony or things that they found for it to be got to this point and not thrown out along the way. It's like, hey, there's not enough here. So there's something, but the burden of that again is on the jury to figure that out.
So with that in mind, is that belief that you have, is that something that you're going to carry into the jury room?
I think it's a belief that I carry into the jury room that we have to listen to that evidence and decide if it's credible or not. That's why you have a jury.
But I guess it was a poorly worded question. The fact that you believe that it's gotten this far, does that gives you some idea that Mrs. Adelson is guilty?
Not that necessarily, like I said, not that she's guilty verdict, but that there's credibility to some evidence that potentially may point that way, which is why we're sitting here today.
Okay.
I wouldn't just assume that it's just all farce.
Would you say that you're pro law enforcement?
Sure.
So law enforcement conducts an investigation. They believe that they have probable cause. They make an arrest. You give that some weight.
Yeah.
You also said earlier that they could be wrong. How do we determine if they're wrong?
By what we're doing right now.
And just to be clear, the defense doesn't have to prove anything to you.
Right.
Okay. Does anyone think that it's not fair that the state has the burden to prove beyond a reasonable doubt with evidence and testimony that the defense doesn't have to do anything? So let's go continue with the discussion.
Hold on one moment. Jury 26 have their paddle up.
I was just gonna say that, you know, somebody accused me of something, I'd want to speak up and say whether I did it or not, because I want to defend myself. And I want that opportunity to say, yes, I did it, or no, I didn't.
And that's fair. Now, concept in our legal system is a defendant has the absolute right to remain silent. The judge is going to instruct you that if my client chooses not to testify, you can't hold that against her. Can you follow that instruction?
No, it's, oh, yes, definitely, yeah, because personally, I think that, you know, there should be some kind of response, but you're obviously the response for this.
Certainly. And I think that's human nature, that if someone says, well, you did this, we want to speak up and defend ourselves. But in a courtroom in this country, defendant doesn't have to do that.
I think there's a time and place to speak up about things.
I disagree. Are you going to hold it against Mrs. Adelson if she doesn't testify?
Absolutely not.
Would anyone here hold it against Mrs. Adelson if she chooses not to testify? So let's go back to what beyond a reasonable doubt means. I'm going to give you another example. We've been in here for a while. There are no windows to the outside. So we walk outside when we're done, and the sidewalk and the road is wet. Is it reasonable to think that a fire truck drove down the road and sprayed everything to get it wet? Anyone thinks that's reasonable? No. That's not reasonable. In that context, can somebody volunteer what would be reasonable? Wait, we're in Florida. Does that happen?
Every day.
So we're defining what is reasonable. Does reasonable mean likely to happen? Is that what the judge is going to instruct you? Number 2. So would you disagree with the statement that proof beyond a reasonable doubt means most likely to happen?
No, it's not most likely to happen. There's rarely like the case where it has every single aspect of evidence to it to fully convict someone.
You know, I've been using these examples for a long time, and I think this is the first time that I haven't had to come back and say no, because most people would agree with likely. Standard is not most likely. It's not probably. It's not most convincing. So there are different levels of proof. And I think that you heard either the judge or Ms. Kappelman at some point talk about this. So at the bottom of the scale is reasonable suspicion. That's what's typically enough for an arrest. Or, I'm sorry, enough for an officer to stop someone, pat them down. Probable cause, what's necessary to get a warrant. Okay, so now, where on that scale we are, who knows? But that's enough to get a warrant, enough to arrest somebody. You got preponderance of the evidence, which is a civil standard. It's more likely than not. And you have clear and convincing evidence. That is what's required for the state to take your children from you. And at the top of that scale, beyond and to the exclusion of every reasonable doubt. That's the standard. So when you think about the state's burden of proof, how do you think about that from an operational standpoint? What is the state required to do? So let's go back to the chart. Who have I not called on? Number 8. Is the standard that you're going to be carrying forward into that jury room the side which convinces me the most?
No, your side doesn't have to convince me of anything. It's only the state that needs to provide evidence.
Can both the state and the defense make arguments that you disagree with?
Oh, sure. Everyone makes arguments.
That you believe that evidence does not support?
They could, yeah.
What are you going to do at that point?
Reconsider the evidence, deliberate with my peers.
And if the state has only proved something probable or possible, what are you going to do?
Well, it really needs to, I got to get the abiding conviction of guilt. So I really need to feel that conviction that your client would be guilty after seeing all the evidence and testimony.
But that's exactly my point. If the state doesn't do that, you stop. It's not guilty. You understand that?
Yeah, that's what it says.
So in the definition, one of the words that you're going to see in there is exclusion. The state has to exclude every reasonable doubt. They have to eliminate it. Does anyone here at all, starting on the first row, believe that they're going to have a hard time holding the state to their burden? They have to exclude every reasonable doubt. Anyone on the first row? Second row.
So when you say that, you mean that the state has to discount every other possible, like exclude to the exclusion of a reasonable doubt? Like prove to me that it's not possible?
No. Don't use the word possible.
Okay.
So if in argument, the defense were to say, give alternatives or a different explanation, and you believe that to be a reasonable doubt, if the state doesn't exclude that, then what is your response going to be?
Okay.
Does that make sense?
Gotcha. Thank you.
Does everyone understand that? I can make it real easy.
Before you go to the next.
No, I can go past it. Yeah. Not to the next slide yet. Okay, so one of the things that the court's going to instruct you is that a reasonable doubt arises from the evidence, a conflict in the evidence, or a lack of evidence. So this is another place where I like to use a hypothetical. And for this one, we're going to adopt the bank robbery hypothetical that Ms. Kappelman was talking about earlier. So the hypothetical is someone goes in and robs a bank. Witnesses identify the defendant. There's obviously surveillance video showing somebody that is consistent with the defendant's features. So
Please approach.
Hey guys, we're in a sidebar. I am in a meeting with my college or workforce. So you'll see me signing, but you will not hear me. We're going to stay at the Donna Adelson trial, and we're waiting for the Wolfenbarger to start. So you'll see me, but you won't hear me.
We are going, or excuse me, prospective jurors, we're just going to take a brief break for the moment. Give you an opportunity to stand up and stretch your legs if you need to. I recognize that we are going through this process and it has been lengthy. If you need to stretch or take a moment to do so, you have the opportunity right now. 5 minutes. Be quick.
Hey guys, we're in a break. I'm going to go ahead and take me off and put the music on. And when court comes back on both cases, we'll come back.
From the Sheriff's Department's warrant division as to the likelihood of getting that witness served with a warrant and or delivered here in execution of that warrant. And so here's what I have been told. So I've spoken directly with one of the higher ups in the warrant division, and that warrant has been given to the nighttime crew, the evening warrant server guys, and I'm told that they're also going to notify Newton County, which is and ask Newton County to write out, which is where Covington is located, I think. and that they believe that they will be able to provide the court with an update by, certainly before 9 tomorrow morning, that either they have secured the witness and are prepared to deliver her to the courtroom to testify, or that what I think is likely realistic, if she's that reluctant, is that they went to her house and knocked on the door and nobody answered. And that they have attempted to, secure her and not been able to. So for that reason, if the defense's request is that we have a continuance until tomorrow morning, then I'm inclined to give one. But as I said before I left, and you can make whatever record you want to make, I would not be inclined to, as long as a reasonable effort has been made to execute that warrant and secure that witness's presence here, I wouldn't be inclined to delay things any further beyond tomorrow morning. Questions, thoughts, concerns on that issue? Mr. McDermott.
Well, I mean, you've basically already given a ruling. I mean, your inclination is your inclination, but I think the witness is important given what's on the record and what we need to put on the record. And I subpoenaed her a long time ago. This is, I've made a great effort to secure her to be here. So, I would request, I understand the logistic aspect of it and the difficulty for the jury and whatnot, but I would request a continuance at least through Monday, if need be.
To do what, though? Right? If the warrant division, sorry, Ms. Hilton, if the warrant division is going to go to her house and either interact with her and say, come with us, or you have to appear, or get no response, then what would delay, if they're going to do that tonight and report back to me that they did that one way or the other, then what would there be a need for a further delay?
I mean, yeah, obviously you can't know if she's just not answering the door or if she's fled somewhere. So
right. And I don't know anything about her criminal history, but I don't, my point is it's a witness warrant, right? I mean, so yes, she hasn't complied with the subpoena, but
I mean, you have more power than just to grant a continuance for one day, though. There's lots of contempt power there that you can use, and I would request that there be more than one effort made knocking on her door. That's all I'm saying.
okay.
Now,
And that's
secondly-
really what I was trying to get to, is what else would you have me do other than what they're going to try and do tonight? So I understand further efforts.
I'm sorry.
Go ahead.
I'm really sorry. There's a provision, of course, in the evidence code in the same section on enforcing subpoenas that says that in such cases, secondary evidence may be used to supplement their, I know you can't give an advisory opinion, but I already talked about possibly playing portions of the tape. I'm not sure what other remedy there might be in that regard. I would be happy to hear your thoughts and anything you've done in the past in that regard.
Ms. Hilton, what are your thoughts, ma'am?
Yeah, we would be objecting to any, I guess, a couple of issues. So one, as far as a continuance, the state doesn't object to a continuance to 9 o'clock tomorrow morning. At that point, I think I was taught in law school, don't make promises at opening that you don't know if it's going to happen or not. And so, Mr. McDermott keeps saying, I made these promises in opening, I made these promises in opening. I don't think that determines whether or not this case moves forward in the manner that the court wants to, just because he said it in opening. As it relates to playing portions of this witness statement without the state being able to cross-examine, Your Honor, I think that we will be objecting. While she might be unavailable, we've never had an opportunity in any previous hearing to cross-examine this witness. And so we don't believe that the unavailability hearsay statute would apply in this case, because we have had an opportunity to cross-examine her. So playing this statement, we believe would be improper. I think that's it.
Okay. And then the next question is, with or without that witness, right? If the defense either has that witness and has her testify, or doesn't have that witness, and then I guess calls any other witness it may or may not have tomorrow morning. And then I guess we're going to delay the state's rebuttal until tomorrow.
Yes.
Okay. Have you actually had an opportunity, not that I'm necessarily inclined to, given the vagaries of what's been represented to me, but have you had a chance to actually listen to whatever that witness has said in whatever recorded statement Mr. McDermott provided to you?
I just started listening to it. I'm probably about 12 minutes in, so I have about 20 more minutes to go, Your Honor.
Okay. Okay. So I think what I'm going to do is excuse the jury, have them go home and come back tomorrow morning at 9, or 9:30, excuse me. And we will expect either a witness or the defense to rest. And then the state will have its rebuttal, which we've already discussed. We all understand will be rebuttal of something that the defense actually put on or created an issue about. And then we'll plan for the jury to get the case tomorrow. In the meantime, after I send the jury home, I would like to have the actual charge conference and any other matters that we need to take up. Anything else that y'all need me to address before I bring the jury in and send them home?
Nothing from the state, Your Honor.
Nothing from the defendants.
Okay. Can I have the jury, please? identify any typographical errors or anything, please bring them to my attention because I like to fix them where I can. Some of them y'all have already brought into my attention. Grave suspicion, which was requested by the defense. Witness impeached. So we discussed witness supported, which we agreed to jettison yesterday because it hadn't been, no one had attempted to rehabilitate a witness in that manner. We didn't actually discuss tailoring of witness attacked, but tailoring it to the evidence, I didn't hear, thank you. I didn't hear anything about, I mean, certainly I've heard some intimations of bias generally, but I've not heard bias in the particular way that it's contemplated here. What are your thoughts, Mr. Samuel? I mean, I don't think it should be there is my point. I've not heard, while I've certainly heard general implications of bias based on parties' relative alignments with one another. I've not heard bias demonstrated in the particular manner that it's contemplated by this instruction.
The state agrees, Your Honor.
State what?
Agrees.
Just 1 second.
Sure.
I'm just looking at 131. You don't mind if we sit down, correct?
No, not at all. Yeah.
The original version had 3 bullet points. I'm trying to figure out what happened.
Right, but well,
First
because
one's gone.
the first one's completely gone because nobody had any testimony about reputation for truthfulness.
Okay.
And this one is highlighted because I thought it was a closer call because obviously parties are always going to talk about that people have biases. But this bias is supposed to be presented in a particular way, and I've not heard any such evidence.
I see what you mean. Okay, so instances of conduct of the witness, right?
Right.
I don't see that.
So my inclination would be to take it out, and the only one that would be in would be criminal convictions. Excuse me. Prior statements. Okay, so Ms. Hilton, I had discussed with you yesterday this issue of immunity or leniency granted a witness. Mr. Samuel has made the argument that the case law is that the grant of immunity is so broad that it is essentially in service of any time that witness ever testifies about those actions, and therefore it's a relevant consideration. I had expressed yesterday that I wasn't sure if there was any particular case law on this point, but that at least from a plain language perspective, the pattern charge is written in a very, very general sense.
Question does for one moment.
Sure.
While they're talking, can I ask a question? Or I lost track of, is what's on the screen going to be in numerical order? Or are you skipping?
No, they're in the order.
So 13142, which is witness supported, is out. Witness impeached one. Well, that's what's on the screen.
131.45 is just the standard. This is what impeachment is.
Okay.
It's a little bit out of order because to me, you needed to tell a jury how to impeach what it means to impeach a witness. And then witness attacked is there, but witness supported has been removed based on our conversations yesterday.
And you have prior statements.
Yep. And now we're on immunity.
Got it. Okay.
Hey guys, I'm still here, but I'm still working with this appointment that I have to do. Thank you so much.
We are still holding for Donna Adelson, and looks like we're getting ready to make some headway on this.
Consider the lead case, and it's been, and what it, I think what's a fair characterization of the case law is that it is not error not to give the immunity or leniency instruction. We feel that in this case, this is really meant, and if you look at all the case law, and there's plenty of case law in Georgia with Lee and a bunch of other cases from the Supreme Court that say that it's not error not to give it. I think we feel like that unfairly having its own instruction is an unfair emphasis on immunity leniency, which is a very, very minor part of this case. Whereas it is adequately covered under the prior instruction based on credibility of witnesses, Your Honor. We feel like that having extra instructions in general runs a risk of confusing the jury. I don't know. This is relatively clear. I'll admit that, but we do feel like it unnecessarily highlights that. I don't think you need to give it. This is not the same thing. That is meant for a case where a co-defendant has got immunity. I mean, that's really what it is.
Right. We discussed that yesterday. I agree with you. That's typically where it comes up. But it is written in such a general way. I will say this, though, to your point, Mr. Wilson, Mr. McDermott or Mr. Samuel, I mean, even if the court doesn't give that instruction, you're still allowed to argue that she got immunity for assisting her husband in murdering people, right? I mean, isn't that the argument you're going to make regardless of whether I give that charge or not?
Yes, but this is in the credibility of a witness based on being protected by the immunity, not that she's a bad person. This instruction deals with the fact that she was rewarded for testifying and is still under that protection. She's still protected by the immunity she received. If she
right, but it's not immunity in this case, is their point. And it does so in theory, it doesn't in theory, it would be lesser likely to influence her testimony here, I think is what the state is saying, because
there are so many parts of a jury instruction which, aren't the most important part of the case.
Sure.
I mean, most of all of this impeachment and witnesses and, are not critically important issues. They're just overall view of the types of things the jury can consider. Inconsistent statements. When you're talking about a credibility of a witness, why bother talking about inconsistent statements? Why talk about prior statements and stuff? It's because you're giving an overall view of the types of things the jury can consider, not required to, but can consider in evaluating the credibility of witnesses. I don't think we should take out something just because it's not error to take it out. We should only take out items that are just completely irrelevant to the consideration of the case here, like we've been doing with a couple things now.
Okay. I'm going to look at it again. I did look at the general case law. I mean, again, I don't disagree with the state's assessment that this is typically intended for where a party in the case who's testifying has gotten immunity related to the case. And I also don't agree with you that the case law says it's not error to not give it, because you can still make an argument. Even if I don't give that charge, the defense can still argue.
Well, yes, Your Honor. I just don't think I think the case law is clear. It's not error for the court to instruct the jury.
But that's what I just said, right? I agree with you that it's not error to not give it.
Okay.
But I'm still not sure under the facts of this particular case that it's not implicated and that it would not be proper. So I'm gonna put a pin in that one and give you an answer in the morning. Okay. Single witness, defendant's choice not to testify, prior difficulties between the parties. So I would like to have a discussion on this topic because I think that although we have spoken in the generic about the prior difficulties that are alleged by the state between this defendant and the victim in this case, what I actually ruled was that those facts about those prior instances and allegations of physical altercation or abuse between the defendant and the victim were intrinsic evidence. And the law is clear that intrinsic evidence can be considered for any purpose once it's admitted. And this instruction says that the jury can only consider it to the extent that it demonstrates the state of feeling between the defendant and the alleged victim, which I'm concerned confuses the jury between the purpose for which they can consider it or not. Having said that, I also think that it might make sense to err on the side of giving this charge because the limited nature of the consideration might be better. I don't know. I do have concerns about it. I mean, as I said, the law is clear as far as I'm concerned that although prior difficulties, there is no case law that I can find that gives me a Venn diagram between prior difficulties and intrinsic evidence. There's some discussion in Carlson and some other things that, yes, the federal treatment of it and the state treatment of it are that prior difficulties are likely treated as intrinsic, but no discussion of the dueling standards that might apply. Because again, if it's intrinsic, then it's it can be considered by the fact finder for any purpose. If it's truly prior difficulties evidence, then it's limited in the manner that is described in this jury charge. Thoughts?
Well, I think I expressed my thoughts yesterday that maybe it's protecting the court as much as anything. It is if in fact the court says some of this is intrinsic, some of it's not, and some of it went back years. Some of it, we don't even know what time frame they were talking about. If there was prior difficulties that were some of the earlier ones at one of the earlier Waffle Houses that goes, I think, before even July of '98, rather than being intrinsic, that may have been would fit more than the Venn diagram part of prior difficulties, and at least we're protected from that. The real point is we don't want a jury saying you're guilty of murder because of the way you treated her before. That's the whole point.
Right.
I don't even know with intrinsic cases it wouldn't be improper. I mean, there is an instruction much later on. You can only convict him with that with which he is charged.
Right.
It's really reiterating that in this context. What happened to 13400? Did we just skip over that, or
130
00? 13400. It just says limiting instructions.
There is not a 13400. I think it's just the general proposition. And well, I'm sorry. Because there is no 404B evidence, there is no need for the general limiting instruction charge. I apologize.
It came out with all the similars, right?
Yes.
Got it.
Okay. So hang on. No, I've lost
130. There it is.
Thank you. So yesterday, the defense has requested this charge, and yesterday the state indicated that they didn't have any objection to giving that charge. I think there's probably a reason to consider giving the jury the charge, because whether it's, I've ruled it's intrinsic, but it is in the nature of prior difficulties between the two parties. And so if the state doesn't object to the defense's request that I give the charge.
What I'm trying to think through is kind of what the court just said, because we have case law like Flowers v. State, in which prior difficulties between a party could be motive, or could be they're coming for other reasons other than
because it's intrinsic,
right? And so,
well, Flowers is a 404B case, to be clear. Well, there's two different Flowers, but one of them is a 404B case. It says even prior difficulties have to be evaluated under 404B. You don't get notice. That's the weird difference between
Right.
prior difficulties and 404B.
So then the question becomes, do we get 134.20 and go back and get 134.10?
Hang on.
And when you find Hughes again, if it pops up, I can't find that citation for some reason.
Sure. So the purpose of the 134.10 instruction, as I understand it, and please, I don't want to make an error. If you think I'm making one, tell me. But the purpose of 134.10, as I understand it, is where you are limiting the use of that evidence. And my understanding is that when the court has ruled that evidence is intrinsic, i.e. necessary to tell the story of the murder itself, which right or wrong, I have clearly ruled that that evidence was intrinsic, there is no basis to limit the jury's understanding or use of that evidence. They are allowed to consider it for any purpose to which it is relevant and admissible in the case.
Right, so then we would ask for 134.20 not to be given, so it is not limit the purpose for which we introduce the intrinsic evidence of the prior difficulties of between Mr. and Mrs. Wolfenbarger. So we
Okay.
ask that you not give 134.20.
Okay. Mr. Samuel, your position is you do want it to be given, correct?
For sure.
Okay. Right now it's in, and that's gonna be my additional homework. Let me give you the Hughes case before, now that I have finally gotten my history on Westlaw to pull up.
I have to say, this is one of the most messed up, disorganized courts I've ever seen. I can't believe this is how they run their courtroom.
Yes. That's a different state. It's not better.
Tinkitude, that is so correct. For God's sake, your attorneys dress like it, act like it, talk like it. You freaking get enough money for it. Man, I got to tell you, maybe I ought to change my degree to law school.
Very bad at navigating my history. Give me a few minutes and I will find it before we call it a day.
It's my responsibility. You had given me 296 Georgia something, and I just couldn't. And then I tried to search Hughes plus intrinsic, couldn't come up with anything.
Yeah.
But that's okay. Why don't we keep going through it?
Okay. Let me go back to my jury charge.
I didn't realize you guys were looking for a case that whole time.
Okay.
If you don't mind jumping back and forth, I just found Hughes for you.
Thank you.
312 Georgia 149. I believe that's the case you.
Well, I want to look because there was, the case I was particularly looking at was one particular prior domestic incident. And when I was just looking now, I found another Hughes case that involved 3 brothers, and I'm not sure that's the case I was looking at. So I wanted to find it again, but it was specifically related. It talks about both prior difficulty and intrinsic. And it was, the admission was specifically related to a prior incident of the defendant allegedly slashing the tires, I think.
Oh, I saw that.
Of the victim.
I ran across that this afternoon when I was looking. It just didn't seem to be the same. Anyways, my issue. So
Okay.
So 13430, yeah, that's next.
Yes, and I have tailored it. Right now, the only evidence is evidence that witnesses have prior convictions, and so I've tailored it just generally to that. So we had some discussion yesterday about identification, and there was a discussion of whether or not to give 13510 or some portion of it. Obviously, the second portion of 13510 is very clearly directed at people who are, stranger observations of, wrongdoers, alleged wrongdoers, and that's not really what we have here. The more I looked at it, the more I thought, if we're not going to give that portion of 13510, is there really even any point to give 13510 when 13511 says it's the state's burden to identify this defendant as the person who committed the offense, which is really what's at issue in this case.
Yeah, sure. We were going to, I'm not sure if the state requested it, or we were going to withdraw 13510.
Yeah, I think it's pretty standard for the state to request both of them. And so, yeah, I will remove 13510 with everyone's agreement.
Yeah.
Okay.
On 13430, because there are no prior convictions against Mr. Wolfenbarger, because he just had misdemeanors. There was no felony against Mr. Wolfenbarger was introduced. You said against any, well, what do you have? Just a witness?
Yes, it just says that it's been tailored. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose.
Okay.
And then definition of crime, intent, no presumption of criminal intent, presumptions and inferences, malice, murder, motive, felony murder, causation in felony murder, aggravated assault with a deadly or offensive weapon.
Did you correct the typo in 21030?
I believe I did, where it said they, it now says he.
Okay.
And then there was some discussion yesterday that I don't think, setting aside for a moment the still pending DV motion regarding this issue of the offensive weapon. Do you have any, let's assume for a moment that I'm going to deny the motion for a directed verdict and that the issue of felony murder based on aggravated assault is going to go to the jury. Typically, the charge of aggravated assault is accompanied where it's not like with a deadly weapon or a handgun where we all know it's a deadly weapon.
Okay, guys, I want to talk to you for a quick second. Because I'm going to school and I am deaf, I do get some benefits. Now, unfortunately, it's been a while. My hearing aids are very old and they're not connecting. They're breaking down. And so the Texas Workforce Commission
Rehabilitative Services are going to help me get new hearing aids. So that was a meeting that I had to do before a specific date in order to qualify to get them for college in the fall, which is right now. So I apologize for having to do that. But thank you so much, Mods, June, and Tinkitude, and K-Swan. Thank you so much, and even Nightbot for stepping in there. Sometimes we have to do that. What part do you not understand? Judge wants the case to jury tomorrow. I don't understand what they're doing. I don't understand the BS. The question is, she seems told. Yeah, exactly. So thank you guys. Frankie Leroy, welcome in. All you new people, welcome in. We have a lot on X, so thank you for joining us. Yeah. Yep. Don't even get me started. I love it. Yes, thank you. Weird Debbie M. That's right. Thank you, Maude. You're phenomenal. I'm going to take a comfort break. I'll be right back, but we'll keep the court going.
It is accompanied by this charge, which I believe was requested by the defense. Any objection to that charge?
We're talking about 220, 23.
Yes.
Yeah, no objection.
Okay. Venue generally, the verdict, multi-count indictment. Alternates, etc. That's the entire charge. So I think, if I'm not mistaken, the parties are in agreement with the exception of the court's ruling on the immunity charge and the court's ruling on the prior difficulties charge, which as it currently exists, the defense has requested, but the state objects to. Is that correct? Any other charges?
I am on the offensive weapon. That seems to me the same issues that are causing some concern about the directed verdict motion, why it doesn't apply to the jury instruction also. It seems to leave this so open, they could decide that the act of dismemberment, the saw, was the weapon used, but that's not really in dispute. I
don't think so. I think the ME pretty clearly testified that those were post-mortem.
State must prove that the defendant assaulted another person with an offensive weapon
and caused the death.
Actually injured somebody.
I want to change this.
There's no display of anything to the jury. How is there any manner in which it was used? There's just no evidence of that at all. The character or capabilities of the weapon.
I agree, which I expressed during my discussions with Mr. Fawcett about the directed verdict motion, which is, like I said, even assume for a moment that I'm like, okay, it goes to the jury. There's literally no evidence of a weapon. I understand the state's argument when we were having the directed verdict discussion was, well, she died in a way where we've presented facts that, could lead, a reasonable inference could be drawn from those facts that she died by homicide. And so then I guess, and I agree with that, right? Which is why I denied the motion for directed verdict on the murder charge. On the felony murder, secondary, with the underlying felony of aggravated assault, that's what I'm still struggling with for purposes of instructing the jury as well, which is, how can a jury make a reasonable inference that a weapon was offensive if there's literally no evidence of a weapon? And I think I understand the state's best argument is that a weapon in the very broadest sense had to have been used to accomplish the death. even if that weapon was, I think your example was poison or something.
Right, and not only that, but I mean, I think getting back to the root of the evidence that came out, the reason why we aren't able to make those determinations is because the state in which the body was disposed of. And ultimately, I don't know how that's not akin to essentially, not that the court would have that intent, but rewarding the defendant for doing a good job, making it difficult to make that determination. I think that there are facts and evidence. The jury, the judges, Your Honor, is going to give the jury a definition of offensive weapon. And it's up for the state to convince the jury that there is an object or enough facts and evidence that the jury can make those reasonable inferences that an object was used and that it fits that category that the judge is going to define as to what an offensive weapon is. I think that there is testimony from Dr. Gilbo, Dr. Terry, the investigator Miller, not just as the photographs, but the injuries, the manner in which they believe that the body was dropped off and murdered at a different location, that it wasn't sacked up at that location. I think all the facts in this case, not just pointed to a homicide, but a homicide. We never said that she was killed with a saw, although that is still a possibility. She could have been, but we don't have the parts of her body that are necessary to make those determinations. And we don't have them because the defendant disposed of those parts. And I think that the jury has enough facts before it to make all those reasonable, common sense, logical deductions.
Mr. McDermott?
Hey, Your Honor, the state has to prove its case beyond a reasonable doubt from evidence, not from a lack of evidence. What he's arguing for is, court, please allow me some leeway so that I can prove this without any evidence. And if you don't, you're giving a windfall to the defendant because allegedly he hid the body really well and didn't leave us any evidence. That's not how this works. There's got to be evidence.
Well,
and you can't just say, we'll leave it at open door so that we can let them assume any possibility like poison, et cetera. That is directly contrary to how this is supposed to work.
Well, it seems as if I have some additional homework to do tonight, but I already did because I took it under advisement. But
can I make one last correction?
Sure.
This is nitpicky, but I think the statute warrants it. 13020 on direct and circumstantial. The last paragraph. You passed it.
13020.
You're right. 13020. The last paragraph excludes all reasonable theories of innocence. The statute says hypotheses. And I would request that be changed.
Okay. I will take a look at this. There are two versions of that pattern charge. There are two versions of the direct and circumstantial pattern charge. There's the long version and the short version. This is the short version, number one. Number two, this has also been plain languaged by the plain language the pattern jury instruction plain language committee. So in an effort to get rid of big words and use words that are readily accessible is, I suspect, likely why hypotheses isn't there and theories is. But I will take a look at that.
Thank you.
Anyway, all I was going to say, and I don't know that I'm saying anything that I haven't already said, but to be clear, the reason that I'm taking under advisement is I've already said I think there is evidence here that is sufficient to require the jury to determine if they believe that a murder occurred here and that Christopher Wolfenbarger committed that murder. Where I am having some reservations that I think I've been pretty plain about is, while there are facts from which a jury might determine that a murder occurred and that Mr. Wolfenbarger committed that murder, aggravated assault requires that there be facts from which a jury could understand how that murder occurred and the manner in which it occurred. And that's what I'm struggling with because there is no evidence of that. And the mere fact of death, I understand the very broad way in which the state wants me to interpret the aggravated assault standard, but I haven't finished looking at it yet, but the defense is at least urging that the broad way that the state wants me to interpret that aggravated assault isn't as broad. They're not actually allowed to have it interpreted that broadly because, for example, and again, I'm just saying this is what they've argued yet because I haven't had a chance to spend some time with it, but that other methods of aggravated assault are not available to the state, like aggravated assault strangulation or other things. And yeah. Well, that's why I mentioned it, because I don't know that I'd heard a clear response from the state on that point.
Well, I would like to pose a hypothetical to the court, for the court to consider, I think, may. Well, let me, if I could.
Sure.
So I would say, let's say we have an example where an individual is found deceased and they have a significant injury to, say, their head. And you have another individual that just no other evidence, but they confess to it, I did it. And you don't have any other facts but that. You ultimately would have evidence, not of an object. You wouldn't have evidence of a weapon that was used. All you would have at that point is the confession tying the person to the crime, the injury, the death, and then you would have the injury itself. That's the only thing that the state is missing in this case, is a visual depiction of that we could say definitively where whatever impact happened. We don't know if it's bruising on the neck. You know, we don't know if there were hand marks and she was choked, and that because of the state of her, we don't have the marks on her neck to show the jury, hey, this is why we believe she was deceased or asphyxiated, because she's got these marks on her neck.
So forgive me for interrupting, but two things to your example. Number one, I'm not sure I agree that example is apt here, because if you had a significant head injury, like for example, if the skull in this case was distended in some manner or injured in some manner, then the existence of the injury, right, could be used as some evidence of the offensive nature of the weapon that was used to cause a violent injury or an attempt to cause a violent injury. And that is not, that's number one. But number two, and my real point is what you just said, which is you've mentioned a couple of times whether there's bruising on the neck or if they use their hands around the neck. What I haven't gotten a clear answer to from the state is a response to the defense's argument that ag assault strangulation is a different crime that is not charged in this case, and the state can't argue it.
It is a different crime, but aggravation strangulation can be charged with regular aggravated assault. It can specifically be charged with aggravation strangulation. And the state would be authorized to make all those arguments and close an argument. So I don't think that specifically charging it with family violence aggravated assault or aggravated assault strangulation prevents the state from charging the cases as a plain language aggravated assault in both of those instances and still prosecuted for the jury. So I don't think that charging it specifically as a strangulation prevents us from arguing that that's one of the possibilities that you could have been murdered on one of the matters for death. The charge of aggravated assault is meant to be broad, especially when there's an issue as to the date in this case. There is an issue as to the date, especially when there's an issue as to being able to prove what type of object. We're going to have this issue anytime there is the lack of evidence because of the actions of a suspect or a defendant. This is always going to be an issue, but that is why the statute phrases the options as offensive weapon per se, and it specifically relates and mentions objects, because it says objects because there are limitless, depending on how the objects are used, they could become dangerous and cause serious injury. And that's the point making ultimately is that this is not like any other situation where you have pieces of evidence that's missing. The jury has the facts to make those conclusions based off of all the facts in the case. The injuries that occurred before, the injuries that occurred throughout the year, the manner in which her body was disposed of, the manner in which it was assaulted and cut, dismembered. And I think that all of that is something that the jury should be able to consider in that determination as to whether or not the state met its burden of proving felony murder.
Okay. So just to be clear, so I know what my homework is, I'm going to look at the immunity charge. I'm going to look at the prior difficulties charge, the theories versus hypothesis in the circumstantial evidence
At
charge.
least mine's easy homework.
And I already have under advisement the DV motion on the ag assault felony murder. And I will say this, if I allow that charge, that count to go to the jury, I expect that what I will do is give the patterns that are here and let everybody argue about what the questions that those patterns beg, right? That the state doesn't have answers to, that I've heard from the defense. So.
Your Honor,
Yes,
I
ma'am.
am looking or researching. I know that we've had some statements come in, prior inconsistent statements come in. I know we have the prior statement charge and credibility, but specifically that the prior inconsistent statement can now come in as substantive evidence, and so that they can take what the prior inconsistent statement was as fact or as substantive. And so I don't believe that the prior statements charge adequately addresses that. So I'm just trying to, and we don't have a pattern charge on that specific topic. So I may be emailing the court.
Okay, that's fine.
Non-pattern charge.
Okay, I mean,
I looked for prior inconsistent statement with the substantive portion. I didn't.
but that's, I mean, that's because it's a relevance ruling, right? Prior inconsistent is whether it's coming into evidence because it was disputed. And I believe those statements are in evidence, right? So the question is to tell the jury what to do with them. And I think the issue is go back and look at the prior inconsistent statement, or excuse me, the prior statements charge. I think that the pattern discussions indicate that it was intended.
So did we lose everybody? Where is everybody? Is it only Frankie and Weird Debbie? Y'all, I know it's afternoon. It's after lunch. Everybody's all sleepy and tired. Eyes sleepy, eyes tired, eyes bold. Just kidding. But no, seriously, it can get pretty tiring and boring for this little part of it. Do y'all want to just continue to listen to them argue and have fun? Or do you want to go over to the Donna Adelson? Because I'm going to do that right as soon as this is done. We're doing Donna Adelson. So let me know. Do you want to stay here or go to Donna?
To do a broader, more general statement about the purpose of prior statements. And if you look, it doesn't say that you can only consider it for its, inconsistency. It's for you to decide why they would have said one thing before and said something else now. So I believe that that's why there's not a pattern that specifically highlights that it wasn't inconsistent or not inconsistent, et cetera. But if there is other language you want the court to consider, I will of course consider it.
Thank you.
Anything else from anybody before we adjourn for the day?
That's what I was thinking.
Okay. I will see you guys.
Okay, we're adjourning.
Yes, ma'am.
Thank you. Juror 19, what is your occupation or your type of work?
Department manager at County Law.
What is your marital status?
Married.
What does your spouse do if they work?
He's a retired teacher.
Do you have children?
Yes, she's 32, lives in Philadelphia. She's an event coordinator at a hotel.
How long have you lived in Leon County?
Since summer of 21.
Sorry.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
My dad's a retired deputy sheriff.
Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
I had somebody break into my house and steal some of my stuff.
Thank you. Juror 20, what is your occupation or your type of work?
I am a retired claims adjudicator for
social security disability,
What is your marital status?
widow,
Do you have any children?
yes, 2 sons,
What are their ages?
44 and 31.
Do they work?
The 44-year-old does. The 31-year-old is currently incarcerated.
How long have you lived in Leon County?
Since 1984,
Do you have any close friends, neighbors, or relatives in law enforcement?
I have a nephew that's a corrections officer for the last 30 years, and also a cousin that's with the Gaston County Sheriff Department.
Thank you. Have you, any close friends or relatives, ever been charged with a crime?
Back in my late 20s, I had a charge of public assistance fraud, but adjudication wasn't fair.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes, I had a break-in in my house about maybe 13 years ago, but my alarm scared them off, so they weren't able to actually get anything.
Thank you, ma'am. Juror 21, what is your occupation or your type of work?
I'm currently unemployed, but I am a full-time student.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
For almost 22 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Yes.
Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
If I'm remembering correctly, did you also need to check with your university or program concerning your ability to serve?
Yes, I did.
Were you able to do so?
Yes, I emailed my professors and only one responded. He said missing the 3 weeks would be kind of a burden for me, but it would be possible for me to make up the work.
Right. Thank you. Yes, juror number 1.
Yeah, I want to apologize. I'm actually divorced. I said single, but it was a long time ago. I kind of forget to say it.
I'll forgive you. Juror 4.
I'll be honest.
Yes, I'm sorry if I forgot that from yesterday. Go ahead.
They sent a letter that it would detrimental. I missed 3 weeks of my program. So I wrote the letter for you with that.
Very well. If you please can bring it to the clerk, I will review it in just a moment. Juror 3.
I also forgot about the crime a family member committed. I have an aunt that was charged with prostitution.
Right. Juror 10.
So you had asked me yesterday to check with my administrator about
Yes.
getting someone to cover my class.
Yes.
She contacted 3 people, but none of them could do it. I contacted a former teacher. She's unable to do it as well. There are subs out there. It just won't be one permanent sub for the whole 3 weeks.
She's going to be excused.
So it would be somewhat of a burden to my class and myself preparing for that.
Bye-bye.
Parties can briefly approach.
That's one way to get out of it. Just saying. Just saying. Not really. This is just 3 days. That's not bad. Actually, they're moving along quite well. But she's not been wearing the headsets for anything until today. Donna Adelson.
They may have opening statements. I don't know. Oh, June. Are we needing the pickle? That's my beautiful pickle. Pickle and what is that? Pickle and what? Mushroom? What is that? Something food. Oh. Oh, what are they ordering for lunch? Pickles. Hot dogs. Okay. It was real tiny. It was hard for me to see. I sorry. I sorry. I sorry. I sorry. I sorry. Hmm. Hmm. Me sorry. So we are in a break, I believe.
At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt on the.
We've already done all that. So we're in the same position. Okay. I'm carrying that one as a better quality. Hot dogs and pickles, I plead the fifth. Actually, I was thinking about going get me some pickles for a snack. I was going to get me a snack. Yo, someone asked to, I had somebody on X ask about my Animal Crossing. That'd be my Animal Crossing. It's raining today. How do you like what I'm wearing? Do I not look cute? I got my slicker on and my fedora, my hat. I'm making everything folly looky. I got to put those things away. I'm trying to decorate for fall. My sister and I would be doing this together. She'd come over on my island and I'd just put a bunch of stuff out and she would just decorate it for me. Well, now I got to do it myself. I do it all by myself. So, I got a new game that I've ordered, although I'm probably not going to like it as much as this, but you know, I don't need that. 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 Miscellaneous. Okay, so I have an idea of something I want to do.
Numbers that have been excused at this point, you will be free to collect your things and you will not have to return at any other point during this process. Oh, let me allow the court reporter to get served.
This is my inventory. And I can change the color of these bags. I can decorate them. I got some boxes.
Sorry to get ahead of you. At this time, I'm going to announce the numbers that have been excused, and you will not need to return for any further jury service in this matter. We give you our sincere thanks for honoring your summons and participating thus far. Juror 24, you are excused. Juror 22, you are excused.
Yes.
Juror 6, you are excused.
Yes.
Juror 7, you are excused.
Woohoo!
Juror 8, you are excused.
Woohoo!
Juror 9, you are excused.
Yay!
Juror 12, you are excused.
Thank you.
And Juror 26, you are excused.
Oh, darn.
Watch your microphone.
Get my money and run,
Juror
honey.
19, you are excused. And Juror 16, you are excused. We are also going to reconfigure the box at this point as well. Juror 5, please shift down next to Juror 2. Juror 23, take the seat to the left of Juror 5. Juror
Ooh.
11,
Musical
take the seat
chairs.
next to Juror 23. Juror 13, please come down to the first row and sit next to Juror 11. Juror 14, please take the last seat on the first row. Juror 17, please shift down to take the seat on the second row closest to the wall. On the second row. Yep, that's it. Juror 18, please take the seat next to Juror 17 on the second row. Juror 20, please take the seat next to Juror 18. Juror 25, please take the seat next to Juror 20. When you hear your number, please walk up and take the first available seat. Juror 27. Juror 28.
Poor jurors.
Juror 29.
Not what they wanted.
And the last for the second row, Juror 30. The seat closest to the wall on the third row, Juror 31. Juror 32 to follow. Juror 33 after that. Once you are seated on the third row, if you can hold up your paddles so I can ensure you're in the right positions. 31 closest to the wall, 32 next to her, thank you, and 33 right there. Juror 34, please come up as well. Juror 35 and Juror 36. It will be another few minutes before we resume. If anyone needs to use the restroom, please do so at this time or stretch your legs. We will get started as quickly as possible. Once again, you are not to speak to each other or discuss this case while we are still going through this process. We will resume in a few minutes.
So it looks like we have a jury. Wait, Debbie, thank
Thank you. Sorry, I didn't see it quicker. Thank you, beloved. Oh my gosh, you're so quick. Look, I got pumpkin and spice. Keeps me nice. Yeah. I'm in the mood for fall. I hate that summer is leaving. I hate that spring is my favorite season of the year. But you know, it is what it is. Oh, no, I don't want to do that. So I am decorating my island for the fall in Animal Crossing. Don't be offended. Sometimes it's hard for me to sit and not do something. I don't have college work to do right now. College class starts next Monday. So right now I'm I kind of have the luxury of double dipping. So that's yay. Thank you so much again for your blessing, Weird WM. Thank you so much. Anybody else play Animal Crossing? Oh, I'm loud. I'm sorry. Is that better? I sorry, June. Me sorry. I have to talk softer. It's so hard because I can't hear myself. Thank you so much for your support. Is that better, Miss June? That be better? Thank you very much. Oh, I wanted to read something Miss June sent us. That over there. Where did it go? Okay, guys, there's something Miss June sent us, and I want to read it while we're on a break. U.S. My apologies. U.S. Navy soldier convicted for selling military secrets to China. Yep. Let me do this. I can get it in big and nope, that won't biggen it. Maybe this will work. Oh, I don't want to do that. Active duty U.S. sailor was convicted of espionage by federal jury on Wednesday, according to the DOJ. Machinist mate, U.S. Navy sailor was convicted of espionage by federal jury. Machinist mate, third class Jinkio Wee, I don't know, we'll call him Mr. Wee, 25, was stationed in the naval base in San Diego, sold Navy secrets to a Chinese intelligence officer for $12,000 over the course of 18 months. Dude, if you're going to sell intelligence, if you're going to sell intelligence, get money for it. That's $1,000, less than $1,000 a month. Really? The defendant's actions represent an egregious betrayal of the trust placed in him as a member of the U.S. military. Adam Gordon, U.S. United States Attorney for the Southern District of California, said in a statement on Wednesday, by trading military secrets to people in the Republic of China for cash, he jeopardized not only the lives of his fellow sailors, but also the security of the entire nation and our allies. Lee was convicted of 6 crimes, including conspiracy to commit espionage, unlawful export of, and conspiracy to export technical data related to defense article in violation of the Arms Export Control Act and the International Traffic in Arms Regulations, the release said. He was arrested in August of 23 for espionage charges. He arrived for work at an amphibious assault ship, Essex, a naval base in San Diego, California. Lee began his criminal plot on February of 14th of 22 when he engaged in communications on social media with Chinese intelligence officer who claimed to work for the Chinese Shipbuilding Industry Corporation. Regardless of the officer's French identity,
Evidence presented during court proceedings outlined Wee's understanding of the officer's allured motive according to their release. I love it when people give me this cool stuff. Thank you, June. This was shortly after he was briefed through the counterintelligence training and foreign adversaries might recruit him through social media, according to early Military Times reporting, which cited his indictment. We possess a U.S. security clearance and was privy to national defense information about Essex weapon systems and infrastructure, informed another U.S. Navy petty officer that he'd been tasked with spying on behalf of the People's Republic of China. February 22nd of 22, we told the sailor that he was going to make $500 for providing intel to an individual who appeared to be Chinese intelligence officer and that he was aware his conduct was illegal. I think it's coffee time. I need something warm. Right now, I guess because it's raining in my game, well, it's raining here. I got my blanket, got the heating pad. I'm just curled up. I want my coffee and a pillow. This is quite obviously espionage, we said to his fellow service member. The sailor told we he should delete the intelligence officer's number from his phone and walk away. No, what he should have done was reported it. We's instead doubled down, commencing his spy campaign. It would help if I had my blanket correct. Right now it's not covering my feet. And switching to an encrypted message platform for communications with the intelligence officer, for whom he referred to as Big Brother Andy. Between March of 22 and August of 23, we was arrested. We sent Chinese intelligence officer photos and videos of the Essex locations in multiple Navy ships and sensitive intel about the Essex defense system. Ooh, snap, that ain't good. We restricted U.S. Navy computers, stealing and sending thousands of pages of information about the U.S. Navy warships to the officer and informed the latter about the potential weakness of other Navy vessels. June, I'm a coastie brat, so Navy's water, coastie's water. Okay, I get it. But I got to tell you, why is he not being beheaded? He would be lined up and pow-powed till he was unalived or at the guillotine. This is treason beyond. We collected $12,000 over 18 months selling Chinese intelligence officers 60 technical and operating manuals about the Navy ships. Oh my gosh. The government proved legal culpability, demonstrating that he knew the treasonous ramifications. February 5th to 23, we text his mother boasting of his financial windfall. According to another press release, U.S. Attorney's Office of the Southern District of California sent Military Times an email. Other Chinese services serving in the U.S. Navy are still trying to figure out how to make extra money driving cabs, he wrote, whereas I am leaking the secrets. Oh my God. I know. He took a plea deal. That sucked, man. He even combined the internet for another case involved the U.S. Navy sailor convicted of espionage, reading a Department of Justice press release similar to the one he would find himself in years later. Upon his arrest, we admitted guilt, acknowledging that his decision to provide secrets to China was espionage and wrong. I'm screwed, he told the FBI agent during the interview after he was taken into custody. Wow. The 14 witnesses who spoke during the trial, including including FBI agents, naval criminal investigator services, and the U.S. Citizens and Immigration Services officers and U.S. officers and civilians. Okay. He be found guilty. He was guilty. All right, let's get back in.
With 27 and going through 36, I'm going to need to ask you some of the same
Thank you, June, so much.
questions that were asked to the group
We're not done yet.
earlier concerning your prior jury service, any connection to the attorneys or the defendant, and also some brief biographical data from you. Once we've accomplished this, the attorneys will each have an opportunity to speak with you as well. I am not going to reread the law to you concerning the presumption of innocence, the right to remain silent, and the burden of proof. The law is fixed. Nothing has changed with it. Does anyone have any questions concerning the law that was previously read for jurors 27 through 36? Please raise your paddles if you have a question as to what the court read. Very well. I'm now going to ask 27 through 36 as a group, have any of you previously served on a jury? Please raise your paddles if you have. Juror 28, please tell us where and when you previously served on a jury. Do you recall if it was a criminal or civil proceeding? Do you recall the charge or the type of case? Without telling us the verdict, did the jury reach a verdict? Were you the foreperson of that jury? Did anyone else have their paddle raised for having previously served as a juror? No other paddles are being raised in response. As to the attorneys on this matter, are any of you, and I'm referring to jurors 27 through 36, related by blood or marriage to any of the attorneys, or do you know any of the attorneys that were previously introduced this morning? Right, no response has been given in the affirmative. Concerning the defendant, are any of you 27 through 36 related by blood or marriage to the defendant, or do you know the defendant personally? Concerning the names of the potential witnesses that were read earlier today, as to 27 through 36, do any of you know the witnesses that were identified by the parties? And now I will go through your biographical information. Juror 27, what is your occupation or type of work?
Owner and operator of a online marketing agency.
Right. You'll never get advertising better than this. Shout out that name. Go ahead, give us the name.
eVision Media Group. eVision Media Group.
What is your marital status?
Married.
What is your spouse's occupation if they work?
Physician assistant at Caprio.
Do you have children?
Yes, 2.
And what are their ages and do they work?
22 and 12. 22-year-old does work, full-time student at UCF and is working at Fulton County.
And the 12-year-old is just at home? Yes, sir. How long have you lived in Leon County?
13 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Close friends, yes.
Have you, any close friends or relatives, ever been charged with a crime?
Yes, my brother was indicted, federal indictment on fraud.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes, my aunt was murdered 17 years ago, and a close friend of mine was also murdered.
Thank you.
A close friend of mine was also murdered.
Juror 28, what is your occupation or type of work?
I'm retired, environmental manager.
What is your marital status?
Widow.
Do you have any children?
Yes, sir. 1, 26 on Saturday, Sunday. Works for Civic Tech.
Right. How long have you lived in Leon County?
About
Any close friends, neighbors, or relatives that work in law enforcement?
No, sir.
Have you, any close friends or relatives, ever been charged with a crime?
No, sir.
Have you, any close friends, or any relatives ever been a victim of a crime?
No, sir.
Thank you. Juror 29, what is your occupation or type of work?
Project manager for a civil engineering firm in town.
Right. Once again, no better free advertising than what you have right now.
DRFV,
What is your marital status?
married.
What is your spouse's occupation if they work?
She works with the Department of Health.
Do you have children?
Yes, 2, 8 and 12. They do not work.
Do they owe you money?
I probably owe them money. But no.
How long have you lived in Leon County?
All my life, 40 years.
Any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime?
Yes, close friend.
Have you, any close friends or relatives, ever been a victim of a crime?
My wife's uncle was shot and killed probably 10 years ago.
Right. Thank you. Juror 30, what is your occupation or type of work?
I'm unemployed, but I'm a social worker.
If you can say that again, they could not hear you.
Unemployed, but I'm a social worker.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
Off and on for 11 years.
Any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
My parents auto theft.
Thank you. She said her parents' auto theft. For everyone on the panel, if you can remember to do this, please speak up and speak clearly so you can be heard. Juror 31. What is your occupation or type of work?
Data analyst, Department of Transportation.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
A year, 8 months.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
My brother has DUI.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Thank you. Juror 32, what is your occupation or type of work?
I work part-time at a restaurant,
What is your marital status?
married.
What is your spouse's occupation if they work?
He's the owner of a restaurant in town.
Shout out that name.
Carrabba's Italian Grill.
Do you have any children?
Yes, sir, 2. I have a 17-year-old and an 8-year-old.
Right. Does your older child work?
He does not.
How long have you lived in Leon County?
8 years?
Any close friends, neighbors, or relatives that work in law enforcement?
Yes, sir, retired.
Have you, any close friends or relatives, ever been charged with a crime?
I have a brother that was charged with DUI.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes, we had a masked individual try to break into our home earlier this year.
Thank you. Juror 33, what is your occupation or type of work?
Deliver and install appliances.
What is your marital status?
Single.
Do you have any children?
1.
What is your child's age?
9.
I assume they don't work. How long have you lived in Leon County?
They are born.
Any close friends, neighbors, or relatives that work in law enforcement?
Yes.
Have you, any close friends, relatives, ever been charged with a crime?
Yes.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes.
Thank you. Juror 34, what is your occupation or type of work?
I operate our 2 family-owned businesses, For the Record Reporting and Bouncers of Tallahassee.
What is your marital status?
Married.
What is your spouse's occupation if they work?
He is a law enforcement officer of the Florida Department of Law Enforcement.
Do you have
They're not going to want her.
What are their ages and do they work?
16 and 13, and no, they do not work.
How long have you lived in Leon County?
36 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Other than my husband.
Have you, any close friends or relatives, ever been charged with a crime?
No, sir.
Have you, any close friends or relatives, ever been a victim of a crime?
No, sir.
Thank you. Juror 35, what is your occupation or type of work?
Delivery truck driver.
Couldn't hear that, Your Honor.
Delivery truck driver. What is your marital status?
Married.
What is your spouse's occupation if they work?
Customer service coordinator for a truck company.
Do you have children?
No.
How long have you lived in Leon County?
3 years.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Thank you. Juror 36, what is your occupation or type of work?
Excuse me, I'm a little under the weather. I'm a fiscal specialist for the state of Florida. I actually work for People First.
You're not contagious, are you?
I hope not. It's
Go-
just
go-
on
go-
this cold air.
Go ahead and put that mask on then.
But I wanted y'all to hear me.
What is your marital status?
I'm single.
Do you have children?
I have one son, the age of 10.
And I assume he does not work.
No, sir.
How long have you lived in Leon County?
I'll just say I've been in Tallahassee for the last 17 years. I had went back to Fort Pierce, Florida for a year or two for school, and then I came back. So I've been
Any close friends, neighbors, or relatives that work in law enforcement?
no, sir. My step grandfather was a state trooper, but he's retired now. That's the only that I'm aware.
Have you, any close friends or relatives, ever been charged with a crime?
Not me, thank you God. But yes, I have it. My dad, my sister, and my brother. This was years ago. I'll say back in 2004 was my dad, and then 2005 and 6, my sister and brother.
Have you, any close friends or a relative, ever been a victim of a crime?
Not me, a friend has been. And that was basically, she was a minor, and I had to basically be summoned to vouch that someone
Judge.
If you can repeat that, go ahead.
So it was I'm just say a friend of the family. I was subpoenaed because she was minor, and I witnessed her being abused, and I'll just put it that way.
Thank you.
You're welcome.
Once again, for our newly seated jurors, I am not going to read the jury instructions concerning the burden of proof, presumption of innocence, and the right to remain silent. These concepts are static, they are fixed. The law has not changed on these matters since we've started the process. Is the state ready to inquire?
Yes, sir.
You may.
Hi, everybody. I'm Sarah Catherine Dugan. I'm representing the state of Florida in this case, along with Georgia Kappelman. I know y'all are tired, hungry. It's 5 o'clock. I'm going to try to be really quick. I want to go over just a couple of concepts with our new folks to see if y'all have any strong feelings about any of them. But if any of our original folks that are here in the first and second rows, if you have anything that you want to add, change your answers on, an idea that popped into your head, just raise your hand and let me know. All right, so Ms. Kaplan talked about reasonable doubt. The state's burden in a criminal case is we have to prove the case beyond a reasonable doubt. We have to prove a crime was committed and that Mrs. Adelson is a person who committed that crime. And we talked about the definition of reasonable doubt. It's not a forced doubt, something you're making yourself believe. It's not a speculative doubt or a possible doubt. We could all sit around and come up with maybe this happened, maybe that happened. The doubt that you're having has to be reasonable. Does everybody understand? Okay. And we talked about why it's beyond a reasonable doubt, because it's impossible unless you're a witness to be convinced beyond all possible doubt of anything. Okay. Hearing that though, do any of our new people feel that I understand what the burden is, but it should be higher than beyond a reasonable doubt? I would personally have to be convinced beyond all possible doubt in order to reach a conviction in a criminal case. Does anyone feel that way? First or second row or third row? Okay. And who decides whether the doubt you're having is reasonable to believe, given all the evidence in the case? Who decides that?
You do.
You guys do, right? Okay. And you do that thinking back on everything you heard in the case, using a totality of the evidence that you heard. We had a couple of people in when the defense was asking questions that some of you mentioned, Mrs. Adelson, maybe she did something to be charged, but and while I understand what you're saying, that's not something for you to consider in a criminal trial. The law is that she's innocent until proven guilty, and that it's the state's burden to prove the charges beyond any reasonable doubt to you all through the evidence you hear from the witness stand. Does that make sense to everybody? Okay. So that's something that should not be considered. The evidence in the case and whether it meets that burden is what y'all consider, okay? And speaking of evidence, if you're picked as a juror, your job is going to be to focus on that evidence. That could be physical evidence, like a picture you can hold, or it could be testimonial evidence. That's going to be a lot of what y'all are hearing. People are going to be coming up to the witness stand that may have knowledge or information about the case, or people who investigated the case. You're going to be listening to the words that they say, watching their body language, so that you all can determine the facts of the case and what happened here. And then you're going to apply what you've heard to the law Judge Everett gives you and render a verdict. One thing that Ms. Kappelman touched on is that it's not the jury's job to decide the sentence. Knowing that, though, is there anybody who feels that I just would not be able to reach a verdict if I didn't know what the sentence is going to be? Anybody on the first row or second row or third row? Okay. Another thing I thought about is, obviously this is a first-degree murder case. And when you hear first-degree murder and you talk about possible sentencing, sometimes people think death penalty. That's not something that's on the table in this case, or could ever be a possible sentence here. So just want to make that clear for everyone when we're talking about that, okay? And I didn't see anyone's raised hands. So everyone is okay leaving this sentence up to the law and to Judge Everett, and you all decide the verdict, right? Okay. We talked about the principles instruction. You guys heard the law on that, even though maybe you're not the person who pulled the trigger in the bank robbery example that Ms. Kappelman did with the court reporter. If you had the intent that trigger be pulled, if you did an act or said some word that encouraged or assisted the person who did the shooting, then you can be considered a principal and treated as if you were the person who pulled the trigger and did the shooting. Does that make sense? All right. Now, okay, so I have another example that if you are, let's say during a football game, if a quarterback throws a pass to a wide receiver, okay?
She's talking football?
In the end zone, it's a touchdown. If scoring a touchdown is a crime, who is a principal to that touchdown? What do y'all think? Let me see. What do you think, Ms. Tolbert?
Quarterback.
I'm confused, but I will say, I guess the guy catching the ball would be the one in front.
Wide receiver. Catch the ball to make that touchdown happen. He wants it. He's running, trying to catch it.
Is it me or is it them? My ears are not doing so good. That's them. See if I can get a different feed.
You don't know? Okay. Is he doing an act or saying a word to assist that touchdown?
The person blocking or the person throwing the ball?
The person blocking.
He's doing what he's supposed to do with it.
Okay. Okay. I gotcha. Okay, so if the person blocking is doing an act of blocking so that the touchdown can be scored, and he wants that touchdown to be scored, is he a principal? Okay. Does everybody agree with Ms. Tolbert there? Oh, she's.
Come on now. Okay, we're taking a break. Give me a break. Excusez-moi. Oh, I think I'll take that one. There we go. It's them. It's them. It's them. It's them. It's them. We are going to be watching the movie tonight at 6:30 on Discord. Sorry, we're going to be watching a movie at 6:30 on Discord called My Oxford Year. I hear it's a good movie. It's one of the number one movies on Netflix right now. So y'all be sure to come join us in Discord. I may even sneak to the store and get me some popcorn. I may go get me a bag of popcorn. Maybe I can convince my son to go get me some popcorn. Wouldn't happen. How many of y'all love candy corn? Let's get the candy corn discussion going. Are you getting up, Matt? Hey, Matthew. I love candy corn, but what I don't like is old candy corn. I love the good old soft candy corn. Really love the good candy corn. So yeah, I'm a candy corn kind of gal. I know some people are like, ew. Well, guess what? You can ew it all you want because I love candy corn. I'm a candy corn kind of gal. Yes, I is. Yes, I. That's not where I want to go. Let's try it this way. I was a candy corn kind of girl. So yum, yum, yum in my tum. Okay, guess I can't put it there. Yeah, no, I really do love candy corn. And it's one of those things that I do look forward to having this time of year. There we go. I do, y'all. So candy corn? Hell yeah. And then I love pumpkin spice things, you know. I know. And I have to be in the mood for it though, and I've not been in the mood for it, but I was getting in the mood, bada, in the mood. Yeah, I am kind of getting in the mood for some candy comb. I don't know why I was in such a good mood for candy comb. What is your favorite fall candy? Come on, y'all, give it to me. What's your favorite fall candy? Tell me now. I really want to know. Nothing better than pumpkin spice or coffee latte. Yeah, but you know one thing I don't like is I like cinnamon in food, but these people who just take a coffee and dump a bunch of cinnamon in it, not my cup of tea. Just saying. Not my cup of tea. Sweet. Oh, I know. I know this girlfriend of mine that she would just make coffee and she'd take a little bit of cream and then she would dump, and I mean dump, a heaping teaspoon of cinnamon. It's like, what? I know, y'all. It's like, what? But I mean, I don't mind cinnamon. Just a little touch of cinnamon would be good. Touch. But to sit there and just do a whole dumping of cinnamon, no, thank you. Well, you know, you've heard about that cinnamon tank challenge, right? You've heard about that challenge, right? Yep. Yep. I'm appalled at that challenge. I never did that. Although my kids tried to do that, and I was all like, hell no, you don't. My daughter tried it. Oh, she got so sick. And then they had that rubber eraser challenge. They had the ice challenge. She's got scars right here where she did the eraser challenge on her hand. She still has scars. Very visible scars, might I add. She still has those today. I was so disheartened when she did that. I actually got quite angry because I knew that was going to scar. I just couldn't understand why on God's green earth would you do that? Back your bus up, rubber eraser. Yeah. People, I mean, I don't understand that. I don't. I'm sorry. Sorry, not sorry. Is that how they say it? Sorry, not sorry. I thought I had a workbench. Did she take it? There they are. There they are. Here, I'll put y'all so you can see what I'm doing. I'm getting ready to start working, y'all. I was getting ready to start working, y'all. What was I going to do? Let me see what I got in my bag I need to work on. No, I need to go dump that off, but I need to find. That's what I need. That's one. That'd be 2. That'd be 3. Nope. Okay, so we can go over here and go to work. So one of the things I like about this is you can, well, I don't want to craft, I want to customize, sorry. You can customize things. Oh, I guess that's the only thing I can customize my Zen cushion. I'll have to go purchase me some let me scroll down here and find my own custom pattern. Customize it. Yep. Woohoo! Customize my own Zen cushion. Then I'm going to go over here and just kind of, I guess, place it in the corner. There's my cushion. Woo! We get these little joy, joy, joy. All right. I'm done with that. What on earth are kids thinking nowadays? What? Oh, wait, they're not thinking. That's what's the problem. Yeah, that is exactly right. They're not thinking. But I remember in my day and age, we had something that was horrible. I know, right? How are you doing, love? Do you play Animal Crossing? But in my day, it was the pass out challenge where you do this until you passed out. Yeah. Yep. Oh my God. I've got some people being assholes online. Hold on a minute. When in the video did the judge sentence him? I hear everyone talking about the same volume like casual conversation. This is the worst sentencing I've seen. The judge needs to speak the F up. Okay. That was yesterday. Today. Oh my God. I can't take the baby talk. Well, do you know what?
You can't take my baby talk?
And then somebody said, I'm out of here. Well, good for you. Have a nice day. Do you know what I don't understand? And maybe you guys can help me with this. Why is it that YouTube people, they come on someone's channel and they decide that they don't like what's going on? So instead of just quietly leaving and just go, nah, this just isn't for me. No, what do they have to do? They have to sit there and leave rude comments, be snots, and just totally be jerks about it. I'm like, dude, not everything's for you. You may not like everything. Guess what? That's okay. Boo, that's okay. I don't care. I mean, don't get me wrong, I do care. I want everybody to be happy. I want to be able to please everybody, but I can't do that. But if you're going to go and send a message to me in a link and give me that.
You don't like baby talk? Well, then maybe you ought to get this head. I'm going to get something stuck in your head. I'm going to get something stuck in your head. Are you ready? Baby shark, do 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 do. Baby shark, do 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 do. Baby shark, do 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 do. Baby shark. Mommy shark, do 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 do. Daddy shark. Okay, guys, I'm having fun. I'm being deliriously tired, but let's see what the pickle sounds on helium. You ready?
Oh my God. Why does it sound like crickets in the background? I mean, I know, but to me, it sounds like crickets in the background. It's a song that never ends. It goes on and on, my friend. I think I just lost everybody. I think everybody just went, we're done. They're like, bye. Oh, y'all. Y'all, I'm going a little bit crazy today. They can all play at the block party. We don't mind. Well, the problem is they're not even coming in here and saying it. They're sending me messages. And that's what's so frustrating. Is they send me messages and I'm like, yo, 10 hours sleep in 3 nights. I'm lucky I'm here. No, you don't. You don't have to keep your mouth shut. You're mine. You can say whatever you want. But I think we lost June. I haven't seen June. Oh, there you are, 405. Okay, you're here. I wonder if the headset that she is wearing is for her to be able to hear the parts of the process. Well, yeah, I think so. I think the jury is so soft spoken that she may be having a hard time hearing them, and that's okay. Thank you so much for hopping in, Cafale. That's a beautiful name. You may find me a little crazy today. Well, because I've had no sleep. And I'm stressing because Saturday and Sunday we're moving my studio, supposedly. And so tomorrow night, I've got to get everything organized in my home, in the guest bedroom that I'm turning into an office, and move all of this home. You guys have no idea how hard this is going to be. 5 monitors, all this equipment that's very fragile. Yeah, I am a little bit on the anxious side, but we'll get her done. We'll get her done. Get her done. Yeah. How you doing, Miss June? Oh, Mandy, I can tell you that wasn't. I'm reading your comment. You can open your mouth because that's not the right person. We're all good. But I'm like, y'all, I don't think I have ever gone in and announced that I'm leaving or made rude comments or done anything like that. I just never have. I didn't feel that there was a need and what good would come of it. Saying. I don't know. I'm just. Oh no, I know this guy. Somebody I know got arrested drunk driving. Dude, come on, you know better than I think it's drunk driving. Let me see what he got arrested. Oh, theft of property. 2,500 times 2 more previous convictions. $10,000 bond. I didn't know you were a thief. I love it when you got something called busted newspaper and people who get arrested, their picture is put on the Facebook page.
So, yeah. Anyway. So, I need to look for Jerry Moore. I don't know what YouTuber people think they need.
Good evening. What I'm trying to do is go through my outline to pick out the key topics I want to address so that we're not here for another hour, hour and a half. Figured that you guys
Thank
have other
you.
places you would like to be at this hour, as do we. Did everyone hear when I discussed the concept of implicit bias earlier?
Yes.
Yes? You all agree that you will make a conscious effort to be aware of that if you were selected as a juror and in your deliberations? Okay. By a show of hands for the new ones, anyone in a leadership position? Okay, we got quite a few.
What?
Mr.
Oh, he's
sorry.
doing the same as he did last time. He asked
Okay.
that same question last time.
Do you have staff that work with you?
Yes, I have 2 staff that work with me right now. That I've been owner operator for the last 13 years. I've had a staff of 10 at times.
Okay. How do you, when you're a leader, try to draw out other people so that everyone is involved in the conversation?
You want to set up a process or a system to do that.
I'm
You want to set up a process or system to do that.
Hello.
To get everybody involved, kind of let everybody know. Let's have a system where we delegate. Everybody has a time to speak or give their thoughts, and then we can let them come back.
And so, as a leader in that type of scenario, you would make sure that everyone's voice is heard.
Yes, absolutely.
Even the ones that don't really want to speak.
Everybody has to be heard.
Everyone has to be heard.
Correct.
Okay. Ma'am, what was your number? No. Yeah, 28. Thank you. I didn't have it written down properly. You raised your hand when I asked about leadership position. How do you avoid a misunderstanding?
To clarify, I'm hired now, but I'm going to still.
Congratulations.
Thank you.
When you were working, and it would apply now too, how do you avoid misunderstandings when you're in a group setting?
Repeating what somebody said, making sure there's active listening and active communication. Going back to people, making sure that they repeat what's been said or repeat the question.
So in other words, not just listening, but comprehending. Okay. Does everyone agree with that? Yes. For those new individuals, would you agree that we're all human, we make mistakes?
Yes.
That includes law enforcement, includes the state. Number 32, you said that your family was recently victim of a home invasion type of incident?
Yes, sir.
I'm sorry?
Yes, sir.
Is that something that, I assume that you all were home?
We were not. We were actually out of town and our cameras picked it up. So we called law enforcement as soon as we saw it and they came out and did their thing.
People arrested?
Yes.
Well, I'm glad that you guys weren't home.
Yes, me too.
Did you do anything, heightened security after that?
I mean, we already had things in place for security. So we haven't taken extra measures on top of what we already have.
Is that something that you think about on any sort of regular basis?
Sure, yeah, of course.
Now, would that or could that be something that you would think about if you were selected as a juror in this case?
No, I think they're two different situations.
Number 29. Said that your uncle was murdered.
My wife's
Your wife's uncle, I'm sorry. How long ago was that?
about 10 years.
10 years? Was that here?
In Greenville.
Greenville.
30 minutes away, east.
Were you all close to him?
I guess she was because it was her uncle, but not really. He was kind of in and out as far as just maybe an odd uncle. I don't know. You know, he was there, but I don't know that he was like super close. But the whole incident was a shock. But I mean, I don't know that I never really knew him to know like if he was involved, if it was he placed himself in the situation, or whether it's just wrong place, wrong time. I don't really know the details.
So you weren't very close to him, so this isn't something that you would carry into the jury room. Okay. Number 27, I'm gonna come back to you on that. You had two family members that were murdered.
Family member and a very close friend.
Okay. How long ago was that?
I thought the 17, but it's actually closer to 20 years ago.
And your friend?
6 years ago.
You still think about him?
Yes, my close friend, very much so. I was like younger from my aunt, but we were close. But my friend, we were actually best friends.
Sorry.
Yeah.
Obviously, my client is charged with murder. And so you could anticipate that I'd be concerned that your experience with your friend and your aunt could impact how you feel in this case. When the state asked you about that, you said, I don't think it will bleed over. You don't think that it'll influence you. I don't think is kind of equivocal.
Yeah, being candid, honest at that point, because I can't say right away that, it just absolutely won't. But I don't carry that bias into the courtroom. I will be able to evidence the case and make a decision based on evidence.
But as you sit here, you can't say to me, Mr. Zellman, I'm not going to think about that at all.
Yeah, I'm not sure.
Okay, thank you.
I'm sorry, you said it would be not true?
Yeah.
Now, and you've heard the state say this a few times, and we probably addressed it when we were back in individual voir dire. The court's instruction is going to be that you can only rely on the evidence that's presented in court. But as you sit here, you can't tell me that I'm not going to think about that.
No, I can say that I would absolutely only rely on evidence of the case. When you're asking about thinking about the past cases of my aunt, or past incidents of my aunt, our best friend, and just as a human being, as the case goes on, if I saw pictures or images or something, I may have a thought about those two.
And that actually brings up a good point, sir. This is a murder case, there are going to be pictures from the crime scene, from the medical examiner. For those new prospective jurors, are you comfortable having to see some of those pictures in this case? Is anyone uncomfortable? If I can get a show of hands. Not that we like having to do this, but is anyone uncomfortable? No hands. Thank you. I'm going to go through briefly some of the hypotheticals that I used to discuss the burden of proof. It's, beyond a reasonable doubt. Did everyone hear the bank robbery hypothetical that I addressed earlier? Yes. Okay. Number 33. So with that hypothetical, the first one, where the witnesses to the bank robbery identify the defendant, the surveillance video depicts the defendant, and the defense attorney gets up in closing argument and says, "The state didn't prove it wasn't my client's twin brother." What kind of doubt is that creating or raising? You remember what we discussed earlier? What was discussed earlier with the prior panel? What kind of doubt did we discuss? Anyone else remember? Number 27. And speculative doubt is not what? Has anyone ever had a knee-jerk reaction? Jump to conclusions? Okay, I'm going to pick on number 30. You ever jump to a conclusion before? You realize that you were wrong? In that moment, did you say something that you may have regretted?
Yes, I did.
You realize that you were wrong. Everyone else have similar circumstances happen? Just a moment, Carl. Number 32, you indicated earlier that you had a family member who's retired law enforcement?
Yes, sir.
And who is that?
My husband's uncle is retired with Leon County Sheriff's Department and worked,
I'm sorry.
and also worked for the governor.
Okay. You close with that individual?
Yes.
Do you hold is their opinion of you important to you?
Sure, yes.
Now, would you have any concern if you were selected as a juror in this case, heard all the evidence, and returned a verdict of not guilty, how your husband's uncle would feel?
No.
Okay, thank you. Same question for number 34. No concern? It's your husband.
It's my husband. No concern at all.
Number 14, no, 20, sorry, 29. Yeah, my numbers are all messed up. You have friends or family law enforcement?
Brother-in-law works for FDLE. He's Caprio police. And I know a few, at least one who's mine are retired law enforcement.
Any concern about what they would think of you if you found somebody not guilty, even of murder?
Sure. No, sir.
Thank you. Number 27, you had?
Yeah, it's several friends, but they several friends. They all went back in Sarasota County.
Okay.
But no concern.
You're not concerned?
No.
Okay. Anyone else have their hand or paddle raised to law enforcement? Did we talk to you about that? Well, we can't talk to you about it again. So, but specific as to the new people. Sorry. As to the new people, anyone been divorced? No divorces for the new people? Good for you. I haven't been so lucky. Let's see. For the new people, this, as I said earlier for the prior panel, it's not something I would normally ask, and I apologize if it's offensive in any way. But just for those new people, can I see a raise of hands of anyone who has any knowledge of Judaism? There's certain events in our culture that are important in life events, correct?
Yes.
Can you give us some examples?
Referring to Judaism specifically?
Yes.
Bar mitzvahs is what comes to mind.
Bar mitzvah being
Or a bat mitzvah for
yeah.
girls.
Okay, thank you. Anyone else familiar with Judaism? Number 35. How do you feel about some call them jailhouse informants or jailhouse snitches? How do you feel about them?
I can't say that I have an opinion.
You can't say you have an opinion?
About them,
Okay.
or I haven't formulated an opinion.
Why do you think that somebody would, a jailhouse informant or a snitch would testify against somebody? What would motivate them?
I don't know, maybe they want to do the right thing, or maybe they get a quid pro quo out of it. They get something.
They get something in return?
Yeah, possibly like a lighter sentence, or I don't know, maybe they get like, I don't know, more benefits.
I'm sorry?
More benefits in jail, I don't know.
So do you judge their testimony more critically as because they're getting a benefit?
Not necessarily.
Number 28. How do you feel about that?
I don't have an opinion on it, really.
The fact that they might be getting a benefit, is that something that you would consider in weighing their credibility?
I think I'd be more cautious of listening to what they present.
Does everyone agree with what number 28 said? Be more cautious in what they say?
Yes.
Anyone in the new group disagree with that? Ma'am, do you disagree with that? Yes. No?
would also be more cautious.
I can't hear you.
I would also be cautious.
Okay.
With you on it.
Thank you.
Good use of your paddle.
Just a moment, Your Honor. Thank you very much for your attention. Nothing further, Your Honor.
We are going to take another break. Once again, I am going to instruct you not to speak to each other. You are definitely not to discuss the case. If you need to use the restroom or stretch your legs, you may do so at this time. Please return to the courtroom as quickly as possible after you've done so. The attorneys and the court reporter can join me in the jury room.
And why is there no sound? Thank you, Tinkatude. Thank you. Hi, it's not real. I don't know why there was no sound. I don't know why I had to push it on and push it off and on. I had to double tap it. It got a little glitchy. So this is my Bellamy Beauty Boost. It's got collagen. It's got vitamin C. It is on it has natural flavors, leaf extract, stevia, sodium, a little bit of salt in it because it's salted caramel. It's got ashwagandha fruit, ashwagandha in it. Hydraulic, I can never say that. Boyatin. I don't know why, but Yeah, well, I'm putting this in my coffee first. And I'm going to froth it. Get my creamer. And someone says, what creamer do I use? I use the oat milk, plant-based creamer. And I'll put that in a minute. I'll put it in a minute. It's okay. So I'll put the creamer in. I'm going to froth it a little bit more with the creamer in. And pulsate it so it doesn't spill over. I'm going to put my caramel in. Oh, look at that gooey, 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 gooey. It's really a thin stream. I'm not putting really that much in there. It looks like I'm putting a lot in there, but I was not putting a lot in there. And then once again, I'm going to froth it one more time. Just to make sure the caramel gets. If you do it right, you can pull that out and it won't be wet. I have a cappuccino, frappuccino, mocha, whatever machine, but I don't have any milk. I don't have any milk, or I'd be making me one now. This is the time of year where I really start drinking a lot of coffee. Of course, everybody's kind of that way. And my thing keeps falling. My big butt. But this is, of course, the time of the year where I really drink a lot more coffee and tea, hot tea especially. So, oh, yes. I didn't even have to use my little spoon. Oh my gosh, y'all, that is so good. All right, now I got to find something for us to do. Anybody got to have an idea? I'm not gonna. Oh, that really feels good just to sit down and get that warmth. I don't like winter because my joints don't like it. I know, Tinkitude. I saw the no sound. It just took me a minute for it to re-engage. Oh, Tinkitude, I'm answering you in Discord. There you go. I answered you in Discord. Let me put this down. Let me get this up. Let me put that down. Let me see what I can find for us to watch because everything else is pretty much done for the day. I mean, it's 5 o'clock. Everybody's my time. Oh, I love it when people talk about going out to dinner. They're 2 hours ahead of me. I'm looking for something for us. I'm looking. Who remembers lamb chop?
I'm looking for a minute. Hello, Miss Debbie. Hello, Debbie. Let's watch this for a minute. Ooh, y'all, that water getting nice and turned up. Where is this at? I'd be getting all those buildings off that pier. That's insane. Oh, wow, watch this, y'all. Why are you even out there? This is in the Carolinas. Carolina Hydras, Nagras. Wow. What do y'all think about that? Anybody, any of my viewers in that area? Look at all the people. Okay, I want to say this. Look at all these people here, and all it takes is one wave and 1 week supports on that bridge for it to collapse down. Even though it's not high, that thing can collapse any minute. I don't get it. Well, I'm a storm chaser, and I would go down there, but I wouldn't be standing on the pier taking a picture of me, taking a picture of me standing on the pier. If that wind is blowing that hard, geez. Those are getting higher. Look at that. I don't understand it. I don't. I don't understand it. I'm looking for more videos, y'all. New Jersey, Ocean City, New Jersey, North Carolina, Myrtle Beach. Oh, I haven't seen it. Myrtle Beach, North Topsail Beach, North Carolina, Stone Harbor, New Jersey. Do you know what? I need to get a hold of my buddy because she lives in Carolinas. Let me get a hold of Diane and make sure they're safe. Let me see if she's safe because she's in Carolinas, not far from the water. Pretty Florida. See, look how nice Florida looks. That's pretty. Let me see if I can get it on radar so we can see where it is coming in.
I'm looking, y'all. So we had a beautiful, my children and I had a beautiful time at Galveston Beach, which is normally nasty as hell. But we had a beautiful time at the beach. And, um, and then 2 days later, it got so hot there that the asphalt was popping up. I was like, oh my gosh. I mean, literally the main road popped up like that, popped up, and we were just on it the day before. So it was kind of weird. Now we're sitting here looking at um, epicenter hurricane air impacts U.S. Carolina, Patras, Nag, Carolina, okay. But it doesn't look too bad. I mean, I wouldn't want to be out swimming in it. Oh, and you know what was really bad? As we were coming home, we were coming from the beach. We were heading out of town, and we're stopped at a light, and all of a sudden, the EMS and fire and somebody had gotten out in the water, and it was a yellow flag a day, and apparently had drowned. They brought him back, but it was CPR and a lot of work. Oh, that is so good, y'all. That is so good. We are waiting right now for the next phase of the court to come back. What are y'all having for dinner? Well, these are okay, but this hurricane is not going to hit us. See, we're going to get the land, it's not going to make landfall as far as the outer parts is going to hit the whole eastern coast of the United States. You can see all of the warnings and the storm warnings, surge warnings, and the flood warnings and all that. But it's not going to will not make landfall, but there will be a lot of raining and the be some flooding, gale winds, things like that. But the hurricane itself is the size of the state of Texas. I kid you not. It really is. And so that is, thank God it's not going to make landfall, because if that thing made landfall, we don't need another disaster. I mean, I live in Kerrville, Texas, where we had all those floods, tornadoes. Yes, those will be spinning off as well. But we're still not recovered from the floods. We're not. But I was like, oh, please don't put anything in the Gulf right now. I was glad to see it wasn't going to hop Florida and go into the Gulf, because I tell you, if it did that, it would, and we got rain, it would be devastating. We're going to update on the active shooting.
Report of a possible active shooter on the campus at Villanova University. A Nova alert from university just went out. They are advising people to move to a secure location and to lock and barricade the doors. We have crews on the way to the scene, and we will bring you more information as
today.
it becomes
Earlier this morning,
available.
Tennessee, I don't remember what town in Tennessee, but they had a oh, you're having steak again? You had steak last night, love? You're making me all jealous. You are making me all jealous. Judge Boyd had an interesting case, and I'm going to follow that case. We'll follow that case when we don't have anything else to follow. Oh, Priscilla Presley is accused of exploiting daughter Lisa Marie's death. Oh, get off of it, people. Oh, get off of it, people. I'm looking, y'all.
Some things I can't show, some things I can. I'm in North Carolina, but not on the coast. Thank God. Been waiting a little bit, wanting a little bit of rain. Yep. Oh, sorry. I'm not going to delete. Okay, good. I didn't delete you. Chicken salad sandwich. I'm eating a late lunch, early dinner. That sounds great. You know what? We have some good tuna. Maybe I ought to make us some tuna. Go to the one that June posted about the sheriff that killed the judge. When did she post it? When and where did she post it? Oh, let me see. I don't have anything in live communications. Oh, we need to look at this. We need to see this one. All right, this is that one that we started. We had the first day of, but then we hopped on to this trial. This is the one. This is the Hernandez Govan Hugs attorney as judge reads the shocking verdict.
Before
And
I
it was
bring the jury in, to the audience in particular, for either side, particularly family members, if you're going to have difficulty controlling your emotions, I need for you to step out now. Outburst will not be tolerated. You can bring it through.
Oh my gosh, y'all. And the thing is that they wanted to nail somebody for this red room, but I don't think it's going to be this.
You ready, Your Honor?
Yes.
Okay, so real quick, here's the quick breakdown. Hernandez Govan trial, which included a 21st, 25. I'm not telling you the verdict, you may already know. He was charged with red room. Defendant, age 45, first degree red room conspiracy to commit red room, attempted red room. Victim, Adolph Thornton Jr., young Dolph, shot 22 times at Makeda's Cookies on November 17th of 21. The trial dates are now up to now. So this is the verdict.
Here's now heading into the courtroom.
Right, we had an active shooter in the University of Tennessee in Chattanooga.
Ladies and gentlemen, have you reached the verdict?
Yes.
State of Tennessee versus Hernandez Govan, count 1. We, the jury, find the defendant Hernandez Govan not guilty in count 1 of the indictment. State of Tennessee versus Hernandez Govan, count 2. We, the jury, find the defendant Hernandez Govan not guilty in count 2 of the indictment. Ma'am?
Court's in session.
Ma'am? Ms. Johnson, is this your verdict? Is this your verdict? Yes. Is this your verdict?
Yes, ma'am.
Is this your verdict?
Yes.
Is this your verdict?
Yes, Your Honor.
Is this your verdict? Yes. Is this your verdict?
Yes.
Is this your verdict?
Yes, Your Honor.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Ladies and gentlemen of the jury, I want to thank you for your service this week. You've done exactly what the court asked you to do, which was to sit, listen to all the proof, and come to a decision. You are excused. Thank you.
Jurors excused. Thank you. Go ahead, John. Court still in session.
Mr. Hernandez-Govan, a jury of your peers having found you not guilty of all charges, sir, you are free to go.
Thank you so much, Judge.
You're welcome. You may come off the record.
Court's in recess.
Now they may celebrate. That is one of the most ugliest courthouses I have ever seen. That is one of the most ugliest courthouses I've ever seen. Courtrooms. I feel bad because the victim in this case is unalived. His family, they don't get any resolve. Now, he very well may be not guilty. And that's one thing I wanted to, June and I were talking about this, and I want to bring that. It's a good lead in. But the family of the victim still have no closure, and they probably won't, because how many times do you ever know that someone goes all the way to trial, they're found not guilty, and then they go and find the real person who did it and follow up with that? Never. So I feel for the family. I really do. I really feel for them. And I know it's upsetting for the family, but if he's innocent, if he's not guilty, he's not guilty. All right, June, let's talk about this. One thing that June and I were talking about is just because you're found not guilty does not mean you're necessarily innocent. You just did not have enough evidence to convict beyond a reasonable doubt. You still could be guilty as hell, but you know what? The case wasn't proven by the state, and therefore you were found not guilty. There's a big difference. And so throw up your words on that, Miss June. I had somebody really get mad and upset because I was talking about this a long time ago, how not guilty does not mean innocent. And they were like, yeah, you're innocent. If you've been found not guilty, you're innocent. I'm like, no, not guilty just means they didn't find enough evidence to prove you did it. I know. People may argue me with that, but that is true. And it is very hard, and it's extremely hard to find someone innocent unless you have video or hard or actual proof of it versus the what's the word I'm looking for? I'm tired. But hold on. I thought maybe you could hear him talking. I wrote something up. I'm looking for it. Give me a second. So I'm going to read this while we're watching him.
And I'm still watching. The other court is still running. So being found not guilty basically is a legal definition. Prosecution failed to prove the defendant's guilt beyond a reasonable doubt. Got that selfie? The jury wasn't convinced enough to convict, but that does not mean they believe the defendant did not do it. The Hernandez-Govan trial, this one here, the jury found him not guilty, but that does not mean they declared him innocent. It means the state didn't meet the burden of proof. Innocent in the moral and social definition, the person did not commit the crime. Okay? In the legal system, the U.S. courts does not formally declare someone innocent. They only determine whether guilt was proven. In the eye of the public, someone found not guilty may face stigma, suspicion, and or civil consequence. So the term not guilty, the prosecution failed to prove the guilt. Public meaning is could still be guilty in reality, and the courtroom use, the verdict is used in verdicts. Innocent, no involvement in the crime. Clean slate, no wrongdoing, not used in verdicts. So when you're covering trials like Donna Adelson and Christopher Wolfenbarger's, it is critical to clarify that not guilty verdict does not equal an exoneration. It just means the jury was not able to convict beyond a reasonable doubt. That's what I put. That's what I wrote. And that's what I say. What's your opinion? What is your opinion? Not guilty is different from factually innocent. And that's the thing. Being factually innocent is extremely hard to prove because most of the evidence we have is circumstantial. Now, I will tell you there is factual evidence in the sheriff trial that you guys were telling me to pull up, and I'm trying to remember. Here we go. I got it right here. I'm pulling it up. Okay. So we're going to talk about the Steins case. While that's the one where the sheriff unalived the judge. There is factual evidence. There's a video, no denying it. You cannot refute it. Okay? Refute it. Sorry. So let's talk quickly. The Kentucky questions remains regarding the report of brothel that occurred in the same room where the Elector County Sheriff gunned down the district judge 3 years later. Former Sheriff Sean Mickey Steins was charged with the Red Room of the public officer in a public office after the September 19th, 2024 courthouse unaliving. Security cameras capture the entire exchange, including Steins unleashing the gunfire on Judge Kevin Mullins. Just one day before the shooting, Steins was deposed in a lawsuit filed by two women, one who alleged that the former Elector County Deputy Sheriff Ben Fields forced her to have X inside Mullins' chambers for 6 months in exchange for staying out of jail. Attorneys have previously told Fox 56 that the lawsuit plays a bigger role in the shooting than meets the eye. I'll continue this in a minute.
Who are currently seated.
We are not getting into closing our opening statements today.
Respective juror panel, we have been able to select a jury at this point. I did want to extend to everyone, thank you for honoring your summons and attending this process today. Although it has been time consuming, it has been very valuable in moving this matter forward, and we are not able to do our jobs without you. So with that, again, we give you our thanks. When I read the following numbers, you are to remain. Everyone else is excused at this time, and you will not need to return tomorrow or at any other point. Juror 1, you are to remain. Juror 2, you are to remain. Juror 5, you are to remain. Juror 23, you are to remain. Juror 11, you are to remain. Juror 14, you are to remain. Juror 25, you are to remain. Juror 27, you are to remain. Juror 28, you are to remain. Juror 29, you are to remain. Juror
All the 20s.
31, you are to remain. Juror 34, you are to remain. Juror 35, you are to remain. And Juror 36, you are to remain. Everyone else is excused at this time. Have a good evening.
Okay, that's pretty much 1 through 30. I mean, that was a lot of jurors in the 20 numbers of the 20s that remain. So that's cool. All right, I'm going to continue.
Sheriff, his name is Sean Mickey Steins. He shot the judge, who was named Kevin Mullins. And there's really no denying the sheriff did it because it was captured on video surveillance right in the judge's chambers. You see the sheriff hold up the gun, and obviously we don't play the whole thing, but it's all on camera. And there is a possible twisted sex.
And alternates. Now the fun begins. Before you are sworn in this evening, does the state accept this jury?
Yes, Your Honor.
Does the defense accept this jury as well?
Hey, Frankie Leroy.
Mrs. Adelson, do you accept this as the jury to try your case?
Yes.
Members of the jury, the first official act that I'm going to ask of you is to stand up, raise your right hand, and be sworn.
That woman sitting next to the woman sitting next to Donna actually looks like she could be a family member.
Raise your right hand. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and this defendant and render a true verdict according to the law and evidence? If so, say I will.
I will.
Thank you.
You can be seated.
Before we end, while I still have your attention, you guys, please come to Discord. Join us at 6:30. We're going to be watching the cutest movie ever, My Oxford Year. It's pretty dang cool. I've seen just a part of it. So come by and join us on our Discord. Watch a movie.
Before you are released for this evening, I am going to give you some instructions. At this point, you are the selected jury in this case. The instructions that you received before concerning not discussing this case, not seeking out any information about this case, or reviewing any other news or speaking.
Looks like it could be her family member.
Now applies specifically to you. Does anyone have any questions concerning the court's prior instructions on what the prohibitions are concerning information in this case? Number 5.
We tell our employer how long we're expected to be here?
Yes, you may. But as far as any other discussion about the case, that is not to take place. 36.
Yes, sir. Would there be any kind of form that I could present to my employer? Because I for the state of Florida, and they are very particular about, you know what I mean.
Do you need me to call somebody?
I mean.
Yeah, I need you to call my boss. Yeah, I need you to call my boss because my boss ain't going to believe I'm over here with this jury. So I just need you to call my boss and let him know so I just don't get fired. Lord, y'all.
There will be a form that will be provided to you from the clerk that outlines the fact that you've been selected for the jury and the length of the trial. Any other questions concerning that matter? All right. I believe earlier when we went into individual voir dire, we discussed that we would be working more or less a standard day. You are to report at 8:45 tomorrow, and we will expect to finish by around 5:30. It is important because you must move as a group for everyone to be on time. Also, as well, as ridiculous as this may sound, once you arrive, please use the bathroom before you come to the courthouse.
June, I'm sorry, that's 5:45 in the morning your time. You don't have to hop on first thing in the morning, June. Yeah, I love you, June. I'm not going to require my mods or demand my mods to do anything, but dang, that's too early.
All 15 of you need to use the
7:45 is bad
restroom. That is
enough.
going to hold us up from getting started. The bailiffs are going to provide you information for parking throughout the duration of the trial. Also, as well, this is the courtroom that we will be in for the duration of the trial. It does vacillate between hot and cold. If you need to bring a jacket or light sweater so you're comfortable, please do so. You are always permitted to bring reading material with you during any breaks. However, again, you are not to discuss the case with each other, even now as selected jurors. You may discuss any other matters that are unrelated to the case during your service. You can talk about the weather. You can talk about how many wins you think FSU might get this year, but you can't talk about the case. Does anyone have a question concerning this? Yes, sir.
Sound like a kid, but what about food? Can we bring food?
You can bring food. I will also have some snacks that are back there for you. Went to Costco, bought them myself.
No. 8:30 their time, 8:45 their time is 7:45 my time. 5:45 California time. I just may spend the night here tonight. I just might, because I got a lot of I got to start packing. I got to organize. Oh, this is going to suck. This is when I will tell you, having this in my home will save me about an hour a day. But other than that, I can be in pajama bottoms. I don't have to worry about getting in public. No, I'm going to miss this room. I got to be honest. I'm going to grieve not having this room. I like the warmth. I like the enclosedness. I like the tightness of it. Feels like a womb.
If you don't, you always have money and you can obtain what you need. Any other questions?
In other words, bring your money with you, boo.
Number two.
Is the start time at 8:45 every morning?
You are to report at 8:45. We anticipate getting started by 9.
Please report downstairs.
Yes. Please report to the area where you initially reported for jury selection. You're to move there as a group. Oh, 1 second.
We're going to take them in there and discuss coming up with them.
Very well. The bailiffs will explain to you where you will meet, but again, do not come up to the courtroom by yourself. You're to move as a group. Does everyone understand this? Any other questions before we part ways for the evening? 31. I'm not going to tell you what to wear. Wear something that you'll be comfortable in the courtroom with. Beyond that, I'm not going to critique your dress code. I'm not the principal at the high school. Yes, ma'am. 35.
Okay, so I'm going to come in a swimsuit and a cover-up, boo.
For Labor Day, we will not be having court. That is a recognized federal and state holiday for anyone who already has a Labor Day plan. This trial will not affect that. 29.
Well, it depends on how long you were going to be off for Labor Day.
At least 2 weeks is what we're assuming. It could be shorter, could go longer, but is that a good?
We're anticipating the trial ending by September 5th, but if it possibly goes longer, certainly everyone will be made aware of this, so that way you can address any issues with work or other matters. Any other questions? Very well. I will see you tomorrow, bright and early. Again, please be mindful of the instructions that you've received. We will get started with the court's instructions, the opening statements, and then we will hear from the witnesses. Have a good night.
All righty, y'all. All righty. Well, that's interesting. I have never seen, oh no, she should be crapping in her pants right about now. And she has every right to be. She ain't laughing no more. Nope, they're on their own for lunch. My thing is that he thinks this is going to be done by the 5th. I don't know about that. Maybe we ought to take bets on that one. Maybe we ought to do a betting pool on that one. So tomorrow morning I will be here at 7:30. Hold up.
opening. The issue can be argued now. Mr. Zellman.
That's is her husband back there? I have not. Do we know if her husband is still with her? I'm coming in my PJs. Yeah. Okay. Yes. Bingo will start for the first for this trial after opening statements are over. So the card will be ready for Monday. Will June opening statements may be done by tomorrow by noon or 1:00 tomorrow. But we will not have bingo until Monday. Per the boss lady. It's on them.
Withdraw the objection at this time for purposes of the opening.
Very well. Do the parties have anything further to raise that we have not already addressed through the process today for jury selection or other matters? All right, please report also by 8:30 tomorrow. We will wait for the jurors to arrive.
There's her husband.
You'll have the opportunity to defense if you need to speak to your client before we have the jurors there. Everyone can prepare for their openings. Are there any multimedia aspects to the openings that we need to address or you have not already worked out?
Yeah, that's her husband.
We will be having a presentation, but I'm familiar with how to use equipment technology.
All right. If you need to practice with that before we get started, please do, so we can move through seamlessly. We'll see you all tomorrow.
Court TD, fix your aperture. You just darkened up. Oh, there you go. Because he's not on any documents, papers, recording. There's no evidence or proof that he was involved in this red room at all. Doesn't mean that they won't charge him later. Depends on what comes out in trial. Don't forget, RV, please don't forget to subscribe. Click the bell so you know when I'm going live. Right now, we're going to go over here and we're going to do our fabulous giveaways. Let me do this because it keeps dinging my sound. So let me see if I can we'll do country. Y'all ready for the draw? Let's get country, y'all. No. Yay, we're WM. You got that one. Well, we only have one sub. They're automatic winners. Let's go to the like, y'all. We need to get more entries on this, you guys. You can do better. This is free. One sunny day. Frank Leroy. There we go. So one sunny day, Frankie Leroy. And oh my gosh, I lost the other one. My brain, I've really been, this is not live. Yes, I am live, Tom Baker. Thank you so much for hopping in. We have just ended our day today. Maybe you can come back. Oh, don't want that no more. We had breaking news earlier. I hope you can come back another day, Tom. We are going to be starting, we're going to be starting the Donna Adelson tomorrow. They'll be doing their opening statements, and then we'll be getting into court. Congratulations. We're WN one sunny day and Frankie Leroy. There you go, June. Thank you very much. Oh, okay, because it's 9 hours. Yes, I'm live from beginning of court till the end of court. Sometimes I've been live as many as 18 hours. We had a case that I went live and they went into jury deliberations and the jury didn't want to go home till they had it done. So yes, we do have very long lives. So thank you so much for joining us, Mr. Baker. I hope to see you again tomorrow, along with all of you. Don't forget, y'all, don't forget, come join us. We are going to be having our movie on our Discord page. If you would like to come and join us in Discord, we would love to have you. It is a fun kind of thing to do. We get into chat a lot. Some of us will talk. Oh, the hostile witness will be in tomorrow. We'll also be watching out for that one. So this is how this is going to play out. Donna Adelson will be our primary tomorrow. During breaks, we will be going into the Wolfenbarger trial. I anticipate everybody will be resting tomorrow. They probably have one witness left, if not two. They'll do their closing and then they'll be resting. So we will be watching that one during breaks. Okay. We're going to do the flippy loo. That's what we're going to do. Congratulations, guys. State of confusion. How is you doing? How's you doing? State of confusion. Give me a second. I need to see something. And it's acting slow. Come on. Why are you not popping this up? There we go. Let me see if it'll do it now. Let's see, Debbie, that would be great. It's really fun. It is fun, guys. I like to do things with you guys. Why are you taking, well, do you know what I'm going to do? I'm going to close out a lot of this. I got a lot on my computer open. I mean, a lot on my computer open. And it is really running sloppily. Let me do this. Let me close it up. Open it up again. Close it up. Open it up again. I need this before I go. There it is. And just where I need the image is gone. Everything's taking forever to load. I take screenshots of all the winners. Why is this giving me such trouble? By the way, don't forget, guys, that I will be moving my studio out of the office to the home, and it is going to be a very difficult weekend and a long process for us. So patience is going to be asked for and hopefully received in the situation when it comes to 7. Okay. So it was 4, I believe, is when this happened. I'm trying to remember who was the second winner. Who was the other winner of the I know one of them we got, but I need, if you were a winner, State of Confusion, did you win either the bingo or the end of the month giveaway? Because I can't remember who won it, but I don't have the information. I'll figure it out in a little bit. I don't have the information. Wendell 8, Wendy. Oh, that's why I'm running. Why do I have 3 StreamYards open? I'm not running 3 streams. I'm going to put that down. Give me a second, y'all. I'm trying to work on it. There we go. Now, I'd like to be doing some fun things during the Donna Adelson, because let me tell you, it is very difficult doing these cases because a lot of these cases get very, very heavy, very, very monotonous, very, very difficult. I guess I'll have to tell y'all tomorrow. I just need to know. No, State of Confusion. I'm talking about an old winning. I'll figure it out. It's taking forever. No, my votes were picked up today. Okay, remind me tomorrow and I'll double vote you tomorrow. The movie night is going to be on our Discord, and I'm getting ready to post the link to our Discord. Just give me a momento.
There's our link. Join us. Validate yourself real quick. It's not hard. And then you can watch it. Wow, you're still alive. Just go home. Well, dude, I can't. I got to pack up all this. We're moving out of our space. My son, yes, you did. My son is going to do different endeavors, and it's really not worth the $3,000+ a month for this office space when we're not really doing what he was doing anymore. So we are going to be moving everything back. I'm going to be moving this to my home, and we've got a lot to do in the next 10 days. So it's going to be a little crazy. I think we're going to try and get the studio moved this weekend into my home. Yay. I'm very anxious about it because when you have these kind of specialized cords, a lot of times when you oh, there it is. It's coming up in a different way. When you have these specialized cords, it can be a little problem. Oh, Defender of Faith. That's who I'm looking for. They are very finicky cords. And when it stays set up, nothing goes wrong. You unplug it and plug it back in, and all of a sudden these cords don't work. So until I'm up and running on Monday morning, I'm stressing. So we'll get there. We will get there. Yes, we will. So everybody come join us tonight. I'm going to be here in the background packing up and working. You guys are fabulous. Everybody give a round of applause for my mods. My mods are fabulous, fabulous people. They work very hard for all of us. So give them This is the movie, My Oxford Year. It's join us at 6:30 p.m. on Discord. It is one of the #1 hit movies right now online. And so we're going to watch it together. All right, guys, mods, thank you so much. And we will see you guys at 6:30 on Discord, 30 minutes. So I'm going to have a quick moment to be able to grab what I need to grab. And then tomorrow morning, I will be live approximately 7:45-ish. I want to give a quick rundown and kind of lay the land and get all the bingo cards and everything set up for tomorrow. Miss June, our fabulous mod, makes our bingo cards. She is simply amazing. Oh, I'll do a test live. Don't worry about that, y'all. I will definitely be doing a test live. I'll probably do it on Sunday night if we got everything up and running. So as soon as I get everything plugged in and up and running, it may not be decorated. It may not be fully gorgeous and everything. This is going to be totally different. None of this is going to be there. It's going to be more light. I have a bunch of white furniture and cubbies. I hate to say it. It's similar to EDB's, but not that nice. But I'm going to have to change everything up. I know. I really like the warmth in the winter, but we'll see. Awesome, awesome. All right, guys, be blessed and meet glad to see you in the. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.